All right, looks like we're ready. Pardon? Okay, great. All right, good morning, everyone. Ms. Rivers, are you able to hear us?
Good morning. Yes, I am.
Great. Okay, we don't need to take anything down yet. I just want to make sure you were connected. So today we are working through a trial calendar to figure out what will be going to trial starting on Monday. It's a 3-week trial calendar. And the expectation is that if Mr. Wolf's cases don't resolve, although I've been told they will, and I see his lawyer is on the Zoom call, one of them will be first out next week because of a speedy trial demand. I know the state has questions about the speedy trial demand, but either way, I'm viewing that as first out. And then what we would try starting on October 2 would be Mr. McGyver's case. So there are a bunch of other cases on here. Some of them may resolve today. Others will be backups to the 2 cases I just mentioned. But if Mr. Wolf's case pleads, which would be ideally the first plea we take today to clear up that horizon, then next week is wide open for other possible cases. What I plan to do is call the calendar first so we can get the latest update on each of the positions and then circle back to figure out a schedule for today if we are taking a bunch of pleas. I can have your client come out if your client is in custody while we simply talk about the procedure and posture of the case. I don't need to do that. I'm happy to do that for you if that's what you want. Obviously, if we're taking a plea, your client will come out if your client is in custody. And I'm happy to have a conference with the lawyers at some point later today on any case that needs a conference. With that, the first position on the calendar is State versus McGyver. I see Ms. Clark Palmer. Good morning. And I see Mr. Abate. Let me start with the state. Is the state ready if this is what we start with on October 2?
I believe client has to leave this. I know Ms. Clark Palmer needs to speak to the client, and then after that.
I need to read it.
Hold on 1 second.
I was trying to take.
Okay.
Well, we would like to approach the bench and talk with the court.
Okay. Is that all right if we do that after I call the calendar?
Yes, Your Honor.
Great. Okay. Anything you want to add to that?
Just that I would like to see Mr. McIver as soon as he's up, and I can go step back and help him.
So he's up now. If we have enough deputies that you could be back there, that would be great for Ms. Clark Palmer and her client to talk. Position 2 is Mr. Pitts. I see his lawyer here. Hey, Mr. Brown, how are you, sir? Any contact with Mr. Pitts?
That's what I was about to say. The information I had apparently wasn't good information. The number I had for him, my call is apparently disconnected. The address that I have for him, I wrote him, I haven't gotten a response. So I would just like to further find out if I can track him before the court.
Okay. Mr. Peoples. All right. So, Mr. Brown, I appreciate the efforts you've made. My review of Mr. Pitts's docket is that he has pretty comprehensively failed to plug into the opportunity he was presented. This was before your time, when he had a chance to do pretrial diversion through the district attorney's office. And it sounds like on basically every measure, he failed or didn't connect or didn't comply. So what I'm going to do is sign the bench warrant. If you contact Mr. Pitts and get him to walk in, I'm happy to lift that if we get a better understanding that, hey, he actually moved or his mom was sick or who knows what the situation was. So I encourage you to keep trying. I don't know exactly what you'll do. If you've used every bit of information in the case file, I think you've done your due diligence. And we'll get that bench warrant out there, which would put the case on judicial hold. So it'll stay on your caseload, but you're not going to need to do anything unless and until law enforcement and Mr. Pitts bump into each other.
Yes, right.
Okay.
I'll continue to do whatever I can.
I appreciate that. And it's an older case, but Mr. Pitts, again, had this chance to plug in with the DA's office and keep things current. And that's not how it played out. So we'll go forward with the bench warrant, obviously keep you posted. Do you have other cases on the calendar?
Yes, William Coley, this is already down on the calendar, and I think that's gonna be a non-negotiable.
Great. Then if you don't mind taking a seat, we'll get to that.
Thank you.
Position 3 is Jamariel Thompson. Hey, Mr. Thompson, here as usual. What do we know about Mr. Bastian?
I spoke to him yesterday, Your Honor. I anticipate that he'll be here.
Okay. Mr. Thompson, if you don't mind sitting tight, I know you've always been here, so please stay here. And I will get an update from my staff as to Mr. Bastian's whereabouts. Unlike the gentleman we're just talking about, Mr. Bastian's not hard to find. He may be coming from courtroom A to courtroom B, but we can't talk substantively about your case without him here. Okay? Thank you. Mr. Peoples, had you had any contact with Mr. Bastian since the last time you gave me an update on this case?
Yes, Your Honor. As it relates to the potential alibi information, we had looked at it. I don't believe that it is positive fully in his favor. We had another conversation, so I think he was going to have a separate conversation. I'm just not sure if he.
Got it. Okay, well, we'll wait for Mr. Bastian's arrival. Positions 4 and 5 are Raheem Conley.
I believe that's going to be a global plea. I've spoken with Attorney Wood. I think we have something on her case, and I've also spoken with Attorney Olaloye, and I believe we have something as well.
So Mr. Conley's in custody.
Yes, Judge.
Do we know anything about the whereabouts of Attorney Olaloye?
He's on his way, Judge. He's
Great.
in a traffic situation on 85.
Okay, a traffic situation. All right, then we can do the Conley plea. We'll make a queue of pleas. Was it your sense, Ms. Wood, that Mr. Olaloye would need to be involved in the plea colloquy?
I don't mind handling both. I just know there's probably terms on that case that I'm not aware of. So
Got it.
I can just talk to Mr. Peoples.
Okay, well, we'll want Mr. Olaloye to be here if we end up, I know we've got a birthday lady who we may try to prioritize her pleas, and a birthday dad, we may try to prioritize those pleas. Just figuring out where this one would go, but it sounds like that's a plea. All right. Ms. McBurrows, position 6.
Oh, mine as well, Your Honor. I attempted to reach out to Attorney Mignot yesterday. We weren't able to connect, but I'm not sure.
Okay, she was on, was it Monday when we had, it was a final plea calendar. Yes, it was the furlough co-defendant. She had one of those, and so she's around somewhere. But more importantly, we don't have Ms. McBurrows.
Let's see what that's for in Blanco picture, but we'll hold until
Yeah.
Ms. Mignot arrives.
Okay. 6. All right. Bench warrant question mark. Precious Mitchell.
The state's going to submit an offer on that.
Okay. Is Ms. Mitchell here?
She is, Judge.
Where's Ms. Mitchell?
Oh, right.
Hey, Ms. Mitchell, how are you? All right. You heard what the announcement was from the prosecution? Okay. Null pros is fancy for dismiss. So I'll sign the appropriate paperwork. Ms. Wood can get that to you. And I don't know if you're going to go back to the Bay Area or stay here, but you don't need to stick around just because of this case. All right? Any questions? All right, good luck with everything. Alex Philemon.
Yes, he is in custody, Your Honor, and this is one that Miss Ross has been working.
Yes.
This is my case, to try to find support for him when he
Right.
gets out, because this is not a situation where we are kind of gearing up towards trial or anything like that. But unfortunately, he was denied by Homes of Light.
Okay.
Because of the nature of the charge, but she's working on Viewpoint and ICM.
Okay, so it is working its way towards a resolution, I think. Mr. Peoples, is this something, if the Mr. Philemon's team is able to come up with some kind of program, is it gonna be a non-negotiated plea because the state's looking for time to serve, or where are we with that? I ask only because you'll likely be handing this off to Ms. Clark.
Right, Your Honor. My understanding in communication with Ms. Feely was that this would be a negotiated resolution. We were looking more towards the 10-2. At the time of the printing of this calendar, it served about 237 days.
Right.
So it wouldn't, his incarceration likely wouldn't last too much longer.
Okay. What is your request, Ms. Feely, that we not set this down for trial because Ms. Ross needs to do more work?
If we could have a few weeks maybe and then do a status.
Okay. But you don't see this, we're not taking this off a trial calendar to try it at another time. Okay. All right. Ronald Rosario. There's Mr. Rosario. Good morning, sir.
This will be a plea, Judge. We just need to finalize the terms.
Okay. Mr. Peoples, you agree?
I agree, Your Honor.
Excellent. So, Mr. Rosario, you can sit tight. When we get through the call, the calendar, Ms. Wood may say, hey, you can come back in an hour or something, but please don't disappear for the day. We will resolve your case today. Terry Spence.
It's also my case, Your Honor.
Right. And you're ready. And that's another Mr. Bastian case.
It is. I've spoken with Attorney Bastian several times on this. I believe we have a negotiated resolution for the court.
All right. So 2 reasons we need to track Mr. Bastian down. Jamel Lewis. Ms. Feely.
We remain ready for trial.
Okay. And Mr. Abate, we'll just need to work through your schedule after you and Ms. Clark Palmer and I talk. Okay. Kevin Rouse. Mr. Rouse is here.
Judge, I need to speak to Mr. Rouse briefly. I have a new and improved offer on this case.
Okay. So Mr. Rouse, when I last asked your lawyer and had the prosecutor in the same space, your lawyer announced ready for trial. It sounds like there's a new offer on the table. So I'm going to ask you and Ms. Wood to talk about that. If that's not something you're interested in, then I'll make sure your case is on what will likely be a fairly short list of things that we'll try over the course of the next 3 weeks. Okay. Ms. Willingham, did you have something you wanted to add? No. Okay. So I'm going to ask you to sit tight as well. And Ms. Wood will talk to you once we get through the calendar. And Ms. Willingham, the state's ready on one of the 3 weeks?
Yes, Your Honor.
Okay. Emery Batten, who is co-defendant with Mr. Wolf, and I have an accusation. So let me unpackage the Wolf situation first, and we've got Mr. Menettis on. Can you hear us, Mr. Menettis?
Yes, Your Honor, I can.
Great. Okay. The accusation that I have is that what would resolve the case that Mr. Wolf has with Mr. Batten?
Yes, all of Mr. Wolf's cases.
Okay, all would be folded into this accusation.
Yes, Your Honor.
I don't see Mr. Batten's name on it.
I didn't, this was part of the negotiations with Mr. Menettis to accuse the 4 charges he was pleading to. Not going to do that for Mr. Batten, but we will resolve Mr. Batten's cases as well.
Okay, so you envision a plea with Batten, but it would be to the indictment that's listed, excuse me, on the calendar.
Yes, to some of the charges
Sure.
on there.
Okay, but there's not a new
No.
charging document floating
Yeah,
around.
and I had submitted that accusation yesterday along with the waiver to the clerk's office.
I've got the waiver. I don't know that we've got the SC number yet.
They said it would be first thing this morning. There were some glitches with us yesterday.
Okay,
So I can either check on that or we can take this and wait for you to enter sentence once the number is assigned.
we'll figure it out. We may lean on some higher powers in the clerk's office to get them to disgorge a single number. I bet they could do that. Okay, all right. Mr. Monetis, are you ready to go forward once we get through the calendar, assuming we get the SC number?
Yes, Your Honor, I am. Thank you.
Great, all right. And Ms. Wood, your thoughts about Mr. Batten? You expect it to be a plea?
I do, Judge. I do need to speak to him briefly before we go forward.
Okay, we'll make that happen.
And I do have the wife of deceased victim and I believe deceased victim's parents.
These are the folks from California or West Coast who are dialing in?
Yes, Your Honor. And there'll be, I see Ms. McKinney, I see her log on to Zoom, so I texted her and let her know what's going on and that we'll let her know at the appropriate times.
Great. So we'll press through the calendar. My thought is when we're done calling the calendar, I'll meet briefly with Mr. Abate and Ms. Clark Palmer. I'll go lean on the clerk's office to get that SC number. And then especially since we've got folks from the West Coast dialed in, we would turn to Batten and Wolf and handle those in whatever order you want to do.
These are my only two cases on the calendar. I have a pretty good relationship with the clerk. Do you want me to walk over there right now and see if they can?
Why don't you use some of that Hiles charm on them? That would be great. Okay. That jumps us all the way to number 17. Reginald Hughes should be in custody.
Yes, and we finally have all the pieces in place, I believe, for a negotiated plea today.
That's correct.
One of his cases was indicted, went to Judge Cox, and they promptly slid it over to us. What about the other CP?
The third, Your Honor, I dropped off the appropriate paperwork this morning and the clerk's office said that they should have an SC number shortly.
Okay,
But the state will be ready for a global resolution this morning.
got it. And Ms. Feely, that would be, I guess, a plea to all three cases.
Yes.
Okay, got it. Octavius Price. Mr. Price?
I do not see him, Judge. I will try to make contact again.
Okay, have you had contact with him in the recent past?
Within the past month, I'd say.
Okay, I'll put a little note here to hold on that. If he doesn't show up, bench warrant?
Yeah.
All right. Charlie Neal.
I'm gonna stay removed for bench warrant and bond forfeiture.
Ms. Wood, same question. Recent contact?
Judge, I did leave a message for him last week, but I have not spoken to him in a few weeks.
Okay. Both Mr. Price and Mr. Neal, should they show up, as I understood it, we're going to be pleased. Is that right?
Yes, Judge.
Huh. Okay. Morgan Villa.
Your Honor, he's represented by Attorney Melnick, I believe from the correspondence that I've seen through email with Ms. Nelson and Attorney Melnick. I think he's in trial in DeKalb right now.
Okay.
But my conversation with him is that this is gonna resolve. I'm just not sure if he'll be able to come over.
Okay. Ms. Nelson, did we excuse Ms. Villa because we knew Mr. Melnick couldn't be here?
No, I did not excuse them.
Okay. All right. Darnelte, and I'm sorry if I'm mispronouncing your first name, Russell. Mr. Russell is here. You've been in touch with Mr. Mohammed?
He's on the way.
Great. Okay. Ms. Willingham.
Judge, this case is actually gonna be handled by ADA March.
Mhm.
And it is my understanding that the defense has filed a motion to continue. The state doesn't have an objection to that. But further, the state we've received some information that we're further investigating. And we asked that if it's gonna be placed on the short list, we asked for the last week. Because the information that we're investigating may result in us not moving forward on the case.
Okay. When Mr. Muhammad gets here, we can have a conversation about the motion to continue. So Mr. Russell, sit tight. When Mr. Muhammad gets here, with you present, we'll talk about the continuance, okay? Adrian Washington is here. Good morning, sir. I think this is another Melnick production.
It is, Your Honor. We've spoken at length about this case. I did also understand that he is currently in trial in DeKalb County. He asked prospectively for the last week of the trial calendar. We are very close to a negotiated plea, but he did ask for the very last trial calendar.
Okay. Mr. Washington, I'm not going to make you stick around anymore. Your lawyer filed the conflict notice. He's in trial right now, so he can't be here. You're going to want to stay in close contact with him because if he and the prosecutor can't resolve these charges, then I'm going to expect him to be ready to get you into court so we can try the case. So don't be scarce if he's trying to call you, all right? And he'll give you notice when you need to be back here. This calendar covers the next 3 weeks. So I've officially given you notice that at any point during the next 3 weeks, I mean, we wouldn't call you and say you have to be here in 5 minutes, but it might be a couple days in advance. We say, hey, it's time for you to have your trial and you need to clear up your situation and be down here for that trial. But we wouldn't call you directly. We'd call Mr. Melnick and then he'd let you know, hey, Mr. Washington, it's time. Okay. Any questions about that? All right, you're free to go. Brittany Davis, that's who's in the hospital. Okay, is she okay?
I hope so, Judge. I do need to speak. with
I'm
her.
here.
Okay. Hey, Ms. Davis, just sit tight. You need to speak with Ms. Davis.
But this will be a plea today, Judge.
Okay, all right. Let's prioritize this as a plea, maybe even ahead of Mr. Wolf, since Ms. Davis is in a hospital. When we finish the call of the calendar, you can reach out to Ms. Davis and we'll figure out what we're going to do. Okay? All right.
I'm so sorry. Am I like free to go right now or?
So it doesn't sound like you're going anywhere in particular. I would stay on the Zoom and then Ms. Wood will reach out to you. You can turn the video off and you can mute, but just take guidance from Ms. Wood, okay?
All right, awesome. All right, thank you.
Thanks. Gustavus Johnson is in custody and that's Mr. Adams?
That is my understanding, Judge. I reached out to Mr. Adams last week and he was supposed to be meeting with his client and getting back to me. I have not heard from Mr. Adams this week, so I'm not really sure where we are.
I'm not sure where he is. All right. Where is? All right. We've got some phone calls to make. Mr. Abate, Mr. Tuitt was not brought over. He is in the midst of a medical emergency. We weren't going to do anything for a couple reasons, Mr. Melnick's case and the outstanding DNA, but he didn't get brought over. And so far, someone asked you about that. William Cody, Mr. Brown, this is your other client.
Yes, yes, sir.
Okay, and did you say non-negotiated plea?
Yes, sir. I was just like a few moments, just confirm nothing has changed.
Okay, great. You and Mr. Jordan can talk and then you can get back and talk with Mr. Cody and we'll try to get you out of here soon this morning.
Thank you.
All right. Bria Walker. Hey, Ms. Walker. Have you seen or heard from Ms. Taylor recently? Okay, but you expect her to be here? Okay. Mr. Jordan, I think my notes say this is likely a plea.
Yes, Your Honor, the last that I spoke to Ms. Taylor, she said it was most likely gonna be a non-negotiated.
Okay, so Ms. Walker, you're welcome to try to reach Ms. Taylor. I know she'll be here, but we can't do anything with your case till she gets here, okay? Thanks. Mr. Camden, I don't know if he's up. He was brought over. This is one that I know both the state and the defense are ready to try, and likely one of the ones we'll try, depending on what flows from Wolf and MacGyver.
We are ready.
Okay, got it. And I believe Ms. Hall will be handling that.
Yes, Judge.
Okay. And finally, we get to Kenneth Hill. And that is one I would love to try. I know Mr. Shapiro is still with Judge Emerson. They got to be getting close to the end of that trial.
I believe that they're close today.
Okay. Ms. Pass. Here. Her leaves of absence are only for Fridays, so we can try this case, assuming she's not specially set somewhere.
I do have an announcement from, on behalf of ADA Shapiro, Your Honor, just to put the request before the court that the state does have 2 witnesses that are teenagers that are currently in high school, because it would be in their best interest to not disrupt the school year. ADA Shapiro would like to request this case to be specially set for sometime in November. I know that Ms. Pass has, as you previously stated, leaves of absence every Friday, I believe, until the end of the year. But we would ask for this case to be specially set for sometime in November.
What is November? My kids will be in school in November, except the week of Thanksgiving when I won't be here. How is November better for their school? I know you're not Mr. Shapiro, but I'm just playing through that, and they'll be learning math and English and whatever else just as much in November as they are in October.
I think just guessing here, Your Honor, but just the fact that the first semester is winding down at that point, that they could possibly even give their teachers advance notice that they'll be out of school at that point.
Okay.
To testify in any case.
More notice is better.
Yes.
Got it. All right. Appreciate it. That was the whole calendar. I see that Mr. Bastian, you've made it. Thank you, sir.
Yes.
Two questions, or 2 cases. You have Mr. Thompson, who is here, and you and Mr. Peoples are going to need to talk about that a little bit, and then you and Mr. Thompson will need to talk about it, and then let me know what's happening with that. And then you have Mr. Spence, who is in custody. That's a plea. Fantastic. So we'll take that this morning. So when I step off the bench to talk with Ms. Clark Palmer and Mr. Abate, hopefully you can catch Mr. Peoples and then meet with Mr. Thompson, who, as always, is here in court. And then I see that Ms. Mignot made it.
Yes, Your Honor, good morning.
Good morning.
Being tardy this morning?
No, not a problem. We were able to press on. The one who is tardier would be your client, unless she's here. Oh, she's here now. All right, excellent. So no one's tardy in the McBurney case. Tell me, Ms. Mignot, what's happening with that case? Are you
ready, willing, and able to try that case? The second and third week is best for me. I have a leave for the first week of your calendar. And all of that, Judge, is subject to negotiations with the state.
That's a thorough answer. So ready week 2 or 3, but you and Mr. Peoples are going to talk. Ms. McBurney will wait patiently while you 2 talk. And then before anyone can go, I'll just need to know what the answer is. Hey, it's a plea today. It's a plea. It's Friday. It's nope. We are so far apart that we're ready to go week 2 or 3. Excellent. Thank you so much. Anyone else show up? So, pardon me? 20, Ms. Vila.
Yes, sir.
Hey, how are you?
Good, I was on my way here.
You made it. Okay, so your lawyer is in trial. So we are working with his schedule to figure out when we can get him here. He has said, and the prosecutor has said, that your case is going to be a plea. Hopefully that's not news to you. And so as long as Mr. Melnick has a good way of reaching you, you haven't moved or changed phones, then you are free to go. And when we can finally get Mr. Melnick in here and not in trial elsewhere, then we'll take that plea. Okay? You bet. So let me call a couple names that we were missing before since people are trickling in. Did Octavius Price make it? All right, still a no-show. And how about Charlie Neal? Okay, so Ms. Wood, you can work your phone. And that covered it. Okay. I'll have my office reach out to Ed Adams. And if Ms. Clark Palmer and Mr. Abate, if you want to go to the jury room, I can meet you over there. Were there other things I needed to do? I guess Mr. Hiles is taking care of the SC number. Was he going to ask on your behalf too? I think you were waiting on an SC number.
No, we just received it, Your Honor.
You did? Well, then he better have one too. Uh-oh, Mr. Rao's going to be in there also. Do you need someone else, Ms. Clark Palmer? Are you good?
But it's my.
Well, because they have two.
Oh, yeah.
Okay. All right. So the plan would be to do the Wolf plea, although Ms. Wood, if you would talk to hospital, because it might be good to free that one up as well.
Absolutely.
All right. Was it, before I go, anyone here who had a case they thought was going to be mentioned and they didn't hear anything about it?
In the trial count?
No? Excellent.
Are you?
Ms. Nelson, were you trying to reach me?
This is,
I can't hear you, but I'll come back and talk to you. Okay. There's room up there for him? Excellent.
I'm sorry. So how do you guys bring up?
Just write down and come.
We did that good,
it's really not that. Prosecutor. No. Okay. She must be. Okay. Hopefully she pick up her phone. Thank you.
What's that?
Yes, awesome. Tips.
Okay, now.
He's gonna be. And we're ready now.
Yes, sir.
Okay, I appreciate it.
Oh, he's not up yet? Okay. Okay, thank you.
He's not up yet. I did, I thought that. And then y'all. June or. You'll get what you were on the original Hughes. I don't think we can. Thank you. I'm not predicting. I think we just start talking about global.
Some extraordinary amount of provisions.
Yeah, give it to you on that part.
Attorney for Spence. Conley. Hey, they outside, Gordon. Spence and Conley.
Got a case number, Judge.
Pardon?
Got a case number.
Fantastic. So here's my thought of what we'll do. I think we should bring Mr. MacGyver out and have a quick discussion about his situation. And then if do we know, Ms. Feely, did Ms. Wood connect with the young lady in the hospital?
She did. I don't have an update, but she was on the phone with her when I was in the hallway.
Okay. I'm kind of anxious to take that plea, given her situation. And otherwise we pivot back and we would do Wolf and then Batten. So we know we don't have a speedy trial. Ms. Taylor, good morning.
Good morning, Judge.
You remind me, you represent.
Walker, Judge.
All right, let me find that. Number 27.
And Judge, we're going to try and negotiate a plea. You had indicated at the last calendar you would hold the final plea open, but we're going to go to the non-negotiated plea, see how that works out.
Okay, number 27. I'm just looking for it on my other list. Yes, okay. We'll do that this morning. We got to deal with Mr. MacGyver. We've got one defendant who's actually dialing in from the hospital. And if that's lined up, we're going to take that plea. And then I have someone who's got a speedy trial. And so that plea would clear up a bunch of things. Then I'm happy to turn to you. If you have another courtroom in the building, if you want to do that, that's great. We've got that. And we're going to try to get Mr. Brown out of here as well. I'm trying to get our private practitioners on their way because they're in demand. So if you do step to another courtroom, just let Ms. Walker know, because when I call it, she can say, oh, Ms. Taylor's in courtroom X. And then we'll just pick you up right when you come back. All right. So that's the plan. All right. But I need my deputies. Maybe they are back there. Do you mind knocking on the, oh, there he is. We're going to bring Mr. MacGyver out, have a quick conversation, and then see if we can do the plea with the young lady in the hospital. If not, then we'll do Wolf and Batten. But if we can bring Mr. MacGyver out first.
This is going to take 1 minute.
Ms. Willingham, Mr. Adams will be here at 11. You know that you knew. All right. Neil? Mr. Neil? You're here. All right. Have you let Ms. Wood know that you're here? Okay, you stay put. We will not do a bench warrant. Ms. Wood,
Yes.
I know you're juggling a lot of things. I want to let you know that Mr. Neal did make it.
Wonderful.
Wave your hand, Mr. There he is. So you're down to Mr. Price as we don't know where he is.
Thank you, Judge.
Okay. Oh, and while we're waiting on Mr. MacGyver to come out, are we able to do the hospital plea?
Yes.
So we'll do that, I think, right after I chat with Mr. MacGyver. And then if that's okay, just so she can do her thing. And then we'll go to Wolf and Batten.
Yeah. We're just making a quick announcement.
You're welcome.
Exit right here. Okay.
All right. Good morning, Mr. McIver.
Good morning.
Mr. McIver, I just had a conference with Ms. Clark Palmer, one of your lawyers, as well as two of the prosecutors, and we discussed your case and the posture and everyone's readiness to move forward. And the lawyers jointly, as in they agreed, that it would be better in terms of everyone being, I think people are ready to go, but to be prepared on all fronts if we moved your case to a later trial calendar this year. I have 3 more trial calendars in 2023. And based on what Ms. Clark Palmer shared with me and the prosecutors, I agree with them that it is in the best interests of both the state as well as the defense to move your trial from this calendar to one of the subsequent calendars this year. Ms. Clark Palmer, I know will be meeting with you soon to continue to talk about this, and I'll engage in a couple things that should help move things forward. Do you have any questions about anything that I just said? Hopefully it's not a surprise to you because Ms. Clark Palmer told me she had been speaking with you about this very question about when in 2023 do we actually get together to say, let's pick a jury and move the case forward. Do you have any questions about any of that?
Let me ask her first, which might save my question for you.
Great, please do.
No, just on the regular calendar. Yeah. Okay, I think we resolved his question.
Great. Okay. Mr. McIver, thank you for being here, and we will see you at whichever of the calendars. I'll be sharing those dates with your lawyer as well as the prosecutors. I think they're going to look at their schedules, and obviously Ms. Clark Palmer will confer with you, and then we'll lock it in with a special setting for whichever one of those dates we select. And that will be the latest I would see you. We may need to have some hearings in connection with this case anyway. Your lawyers have been filing a series of motions in limine that we need to talk about. None of that we do without you being here. So I may see you before that trial calendar date. Otherwise, it would be on that date, just like we did today. Okay?
Yes, sir.
All right. Mr. Abate, anything from the state?
That's from the state.
Ms. Clark Palmer, anything else on behalf of your client?
No, thank you.
All right. Thank you all for being here. Ms. Wood, should we try to do the Brittany Davis plea now? Or would you prefer, for logistical reasons, that we pivot to Ricky Wolf and then, and Mr. Hiles, would we do Wolf first or Batten first?
I think we best do Wolf.
First? Okay.
Judge, if I may, I'm gonna draft Ms. Feely to handle Ms. Davis's plea. Ms. Davis is cool with that.
Okay.
And then I'll finish wrapping up with Mr. Batten.
Fantastic. So Ms. Davis, if you could activate all your equipment, we're going to go forward with your plea right now.
Okay.
Yes, sir. I'll do the usual email about where Lewis is on the 3 weeks.
I'm gonna check in on this really around this time.
Okay. Okay. Mr. Jordan, you're going to be at the witness camera?
Yes.
Okay. All right, Ms. Feely, are you ready? Ms. Rivers, are you ready?
Yes, I'm ready.
Okay, that's Ms. Davis. Ms. Rivers, are you ready?
Oh,
Yes.
I'm sorry.
Okay, great. Let's go on the record with position 23. It's indictment 23 SC 187021, State versus Brittany Davis. Ms. Davis, tell me, you don't need to tell me exactly what's going on, but are you in a hospital right now?
Actually, yes, I am. I'm in like the lobby. I'm just sitting here because it's quiet because like I have a lot of people in my room. I have COVID.
Okay. I'm sorry to hear that.
I told Miss Wood when I got discharged today, I'll send her over all the papers.
Okay. I'm not doubting you, and I wasn't asking to try to prove anything up. I have two concerns.
Just so. I'm sorry.
Okay. I have two concerns. One, I want to make sure you're not on any medication right now that makes it.
I am not.
Okay. Make sure you let whoever is asking you questions finish the question, because the court reporter can't write down two people talking over each other. But it sounds like you're not on any medication right now.
No.
Okay. Number two, you have a right to be here in court with your lawyer by your side. You're in a much safer place given what you just described. Are you comfortable moving forward, not being here in court and not having Ms. Wood or Ms. Feely right by your side?
Yes, I am.
Okay. If at any point, Ms. Davis, you need to speak privately with Ms. Feely, who's going to handle the plea for you, let me know and I'll have her step outside and she can call you on your phone. Okay.
Okay.
All right. Mr. Jordan.
Yes, Your Honor. And before we begin.
Why is this your plea?
Mr. Peoples is still transitioning between crimes against children and the trial unit, so I'll be handling most of his pleas today, Your Honor.
Okay, great. Glad you're here.
And Your Honor, this I'm glad to be here, Your Honor. This will be a
say it only if you mean it.
This will be a reduction to disorderly conduct, Your Honor. OCGA 16-11-39.
Okay, so Ms. Davis, your plea is to a misdemeanor, not to a felony. You understand that?
Yes, sir.
Okay.
Ms. Davis, can you please raise your right hand?
Yeah.
Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
Brittany Michelle Davis.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you and how far have you gone in school?
I'm 34 and 11th grade.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you are today pleading to one count of reckless conduct?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss the case with your attorney?
No.
Are you satisfied with her services?
Yes, most definitely.
Ms. Feely, are you satisfied that your client has a full understanding of this proceeding?
Yes, and I didn't want to interrupt, but I heard you say reckless conduct, but I think we had decided on disorderly conduct.
Disorderly conduct. My apologies, Your Honor. Let me see if that is the correct.
It's what you said initially was disorderly. That's what I jotted down, but I understand it's plea to a misdemeanor disorderly conduct.
That's correct, Your Honor. My apologies. Have you reviewed the indictment in this case? Have you reviewed the indictment in this case?
Yes.
Ms. Feely, do you waive formal reading of the indictment?
We do.
Do you also waive any and all defects in the indictment, including any with respect to your client's name?
We do.
Ms. Davis, do you recall being arrested originally under the charge of burglary in the second degree?
Yes.
Your Honor, the state is unaware of any outstanding warrants that are related to this charge. Ms. Feely, do you know of any outstanding warrants that are related to that charge?
No.
Ms. Davis, do you understand that you're entering a guilty plea to one count of disorderly conduct?
Yes, I understand.
And Your Honor, just for the record, the minimum for disorderly conduct is 1 day in custody and the maximum is 12 months. Ms. Davis, did your attorney advise to you the minimum and maximum sentence for that charge?
Yeah,
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, as previously stated, the state is reducing the burglary in the second degree to disorderly conduct. The terms of the negotiated plea for that count is 12 months probation and to stay away from the incident location, which I will give during the factual basis.
All right.
Is that what was communicated to you, Ms. Davis?
yes,
Do you understand that the court does not have to accept that recommendation?
yes, I understand that.
Do you understand that the court can sentence you to the maximum on that charge?
Yes,
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
yes, I understand.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes,
Are you currently on probation or parole?
I am currently on probation from a charge that was connected to this charge.
Do you understand that your plea of guilty may affect your probation that you are currently on?
Yes,
Are
but
you
I
a
have
United?
spoken with my officer about it, so.
Understood. Do you understand that if you are not a United States citizen, a guilty plea conviction may affect your immigration status?
Yes,
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
yes,
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
yes, I understand.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes,
Do you understand that by pleading guilty, you are giving up the following rights, which I will now list off? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
yes,
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
no,
How do you plead to one sole count of disorderly conduct in indictment number 23 SC 187021?
guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charge against you?
Yes,
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
yes,
Do you understand that since you are pleading to a misdemeanor charge, you have only 12 months from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
yes,
And Your Honor, for a factual basis, on, I believe that's July
7th of 2020.
Yes, on July 7th of 2020, an officer responded to 4375 Baker's Ferry Road in reference to a burglary. Upon arrival, he made contact with the victim, Mr. Gregory Edwards. Gregory is spelled Gregory. Last name Edwards has normal spelling. Mr. Edwards stated that on that same date, at approximately 8:54, his employee, Thomas Davis, stole $1,600 worth of copper wire from his business. Mr. Edwards, who is the sole owner of the listed business, was able to show a still photo of the company truck that Mr. Davis is assigned with the copper wire lodged in the rack attached to the bed. Mr. Edwards stated that he had video footage of Mr. Davis pulling the truck into the yard near the particular area with nothing loaded on the truck. Mr. Davis then pulls the truck into the building where there are video cameras. When the truck exits the building, being driven by Mr. Davis' girlfriend, the defendant, the copper is loaded on the truck. The victim told a detective that the suspect in the camera footage was his employee, and that that suspect was also accompanied by the defendant, Miss Brittany Davis. Miss Davis was eventually arrested and charged with the offense of burglary in the second degree.
Do we know what happened with the gentleman?
Your Honor, if you'll give me 1 second, Your Honor, I do apologize. I do believe that they were able to eventually recover the items that were taken. They were able to recover a toolbox that Miss Davis had pawned earlier that morning. And I believe that they were able to get all of the items back.
Okay.
Nothing further from the state, Your Honor.
All right. Who do we have from pretrial today?
I'm here, excuse me, I'm here, Your Honor.
Hey, Ms. Hardy, can you share with me whatever criminal history information you have for Ms. Davis?
Okay, this defendant has a total of 4 arrest cycles with arrests out of Georgia and Arizona. No felony convictions, FTAs, or probation violations to report.
Okay, thank you so much. Ms. Feely.
Thank you, Your Honor. Ms. Davis is 34 years old. It sounds like she's very motivated to get this behind her, obviously from 2020. And it's my understanding that the main actor was not charged. So she kind of got roped into this, hanging out with maybe people she shouldn't have, but she has since moved on. If the court's inclined to accept the plea as negotiated, we're ready to move forward.
Okay, and the main actor would have been Mr. Davis. Okay, and that was actually the question I was asking is, not did they get stuff back, which is important, good to know, no restitution, but what the heck happened to Mr. Davis? But that's for some other court on another day. All right. Ms. Davis, do you have any questions about anything that we've been discussing?
No, sir.
Okay. Mr. Davis is your husband, is your brother? How are you connected to Mr. Davis?
Ex-boyfriend.
Ex-boyfriend. Got it.
Yep.
Is he in your life anymore?
No, he is not.
Okay. All right.
We haven't written, not since that day I got arrested for this. I have not spoken to him.
All right. Well, Ms. Davis, I find there's a factual basis for your plea and that your plea is knowing and voluntary. I will accept the plea. I'm going to sentence you to 6 months probation. I appreciate what the recommendation was, but this was 3 years ago. And in hearing from Ms. Hardy from pretrial, it's clear that this was an aberration for you. While you are on probation for 6 months, you need to stay away from Southwest Plumbing and Heating at 4375 Bakers Ferry Road. And I'll waive your probation supervision fees for the first 2 months. You will get contact information for misdemeanor probation through Ms. Wood or Ms. Feely, but probably Ms. Wood. She's going to let you know who you need to call and when you need to meet with them, and you need to make sure that you actually engage with those folks, okay?
Yeah, of course.
Ms. Feely, may my staff sign the indictment indicating Ms. Davis's misdemeanor plea on your behalf?
Yes, sure.
Mr. Jordan?
Yes, Your Honor.
And Ms. Davis, can we sign it for you too?
Yes.
All right, that's it. You are free to go. Good luck with the COVID.
Thank you, Your Honor. You have a great day.
You too. All right, if we could do Mr. Wolf next, please. Give me 1 second, Mr. Wolf, and we'll get going. All right, this is actually several positions on our trial calendar. Page. Positions 14, 15, and 16, all involving Mr. Wolf. Mr. Wolf is here in court. Good morning, sir. Good morning. And Mr. Wolf's attorney, Mr. Manetis, is on the screen. You see him there on the screen? Yes. Mr. Wolf, you have the right to have your lawyer right by your side in case you have any questions for him. Mr. Manetis told me that he's spoken with you and that you knew that he'd be appearing remotely. If for some reason you need to speak with him in private, we'll figure out a way to do it. It'll be a little complicated. I may need to get everyone out of the courtroom, but Mr. Manetis assures me that he's talked to you about what we're doing today and that you're ready to go forward. Is that correct?
Yes, sir.
Okay. If at some point you've got a question for me or for your lawyer, just let me know and we'll work through that. All right. Okay. As I understand it, you are going to be entering a plea to a new case that wraps up your 3 other cases. And that new accusation number is 23 SC 189496. And if I accept your plea to the charges in this document, then the state will be dismissing or null processing your other 3 cases. Is that correct, Mr. Hiles?
Yes, Your Honor.
Okay. Then I think I'm oriented to what's going on. When you're ready, Mr. Hiles, let's get started.
Okay, and we outline the plea for you, and I know the family is on, and they would like to address the court. I will let them know when it's time to speak. And just since they're on, I want them to know that this is not a new case per se that he's pleading to. It's a new case number that encompasses 2 of the 2 separate incident dates.
Sure. And to be clear, it's not new charges. I mean, they may be written in a different way, but it is a different way of charging, of accusing some of the alleged criminal conduct for which Mr. Wolf has already been charged and for which he's been in jail for 1.5 years or more. Okay.
Okay, and Your Honor, this will be a plea to 4 counts of violation of Street Gang Terrorism and Prevention Act, with the count 1, the underlying act being murder, count 2, the underlying act being aggravated battery, count 3, the underlying crime being theft by receiving, and count 4, the underlying crime being possession of a firearm during the commission of a felony. The negotiated plea, and we'll elaborate in the factual basis as for the reason for the negotiations, is 25 years to serve the first 15 years in custody with the balance of 10 years on probation. The special conditions are that the defendant have no contact with any known criminal street gang members, that the defendant do not refrain from any participation in criminal street gang activity, that he possessed no weapons or replicas thereof. In the negotiations, I did speak with Attorney Manetis and agreed that after 5 years of the probated sentence, not including any potential parole, after 5 years of the probated sentence, he could petition the court for early termination if he has no violations of special conditions nor any violations of the law.
Okay.
Mr. Wolf, will you please raise your right hand to the best of your ability? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth.
Yes.
Okay, you can put your hand down. I know you're a taller gentleman, so if you could please speak into the mic, and I need yes or no answers.
Oh,
just
yes.
Because there's a court reporter that is taking down everything else, okay?
I got you.
All right. Will you please state your true, correct, and legal name?
Ricky Wolf.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take that you have not been given today?
No.
How old are you?
26.
What is your highest level of education that you have completed?
Freshman year of college.
Are you able to read, write, and understand the English language?
Yes.
Have you gone over the 4 charges that you will be pleading to with your attorney, Mr. Menendez?
Yes.
And do you understand that each of the 4 counts of the violation of street gang terrorism and prevention acts carry with it a potential sentence range of 5 to 20 years?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
And do you understand that if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
And have you discussed the fact that you are proceeding? Well, the judge just discussed that with you, but you are acknowledging that and waiving your right to have your attorney present, correct?
Yes.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this accusation 23 SC 189496?
Yes.
You need any more time to speak to your attorney?
No.
Are you satisfied with your attorney services?
Yes.
Mr. Menendez, do you waive formal reading of this accusation?
Yes, sir. So waived.
And Mr. Menendez, do you waive any and all defects in this accusation, including any with respect to your client's name?
Yes, sir. So waived.
Mr. Wolf, do you understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense will be the sentence of 25 years to serve 15 years with the balance on probation and the special conditions just relayed to the court before the plea? Do you understand?
Yes.
Do you understand, however, that the court does not have to accept the recommendation and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts? Do you understand?
Yes, I do.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea? Do you understand?
Yes.
You understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of your sentence. Do you understand?
Yes.
Do you understand that you are absolutely not allowed to possess nor use firearms while on probation, and that your status as a convicted felon prohibits you from possessing firearms unless and until your rights are restored? Do you understand?
Yes.
Mr. Wolf, are you a United States citizen?
Yes.
Mr. Wolf, do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, you will be guilty of a subsequent felony that carries with it a potential sentence of 1 to 5 years? And do you understand?
Yes.
And do you understand that if you, from going forward, if you use a firearm during the commission of a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison. Do you understand?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty? Do you understand?
Yes.
All right. I'm going to go through a series of rights individually with you, one at a time, that are known as your Boykin rights. Mr. Wolf, do you understand that by pleading guilty, you are giving up the right to trial by jury?
Yes.
Mr. Wolf, do you understand that by pleading guilty, you are giving up the right to remain silent and not incriminate yourself?
Yes.
Mr. Wolf, do you understand that by pleading guilty, you are giving up the right to confront witnesses against you?
Yes.
Mr. Wolf, do you understand that by pleading guilty, you are giving up the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case?
Yes.
Mr. Wolf, do you understand that by pleading guilty, you are giving up the right to the presumption of innocence?
Yes.
Mr. Wolf, do you understand that by pleading guilty, you are giving up the right to testify on your own behalf and present other evidence? Do you understand?
Yes.
Mr. Wolf, do you understand that by pleading guilty, you are giving up the right to subpoena witnesses and compel the production of evidence?
Yes.
Mr. Wolf, do you understand that by pleading guilty, you are giving up the right to have the charges against you proved beyond a reasonable doubt? Do you understand?
Yes.
And Mr. Wolf, do you understand that by pleading guilty, you are giving up the right to appeal if convicted of these charges after a trial? Do you understand?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
Mr. Wolf, how do you plead to counts 1 through 4 in accusation 23 SC 189496, each count being a violation of the Street Gang Terrorism and Prevention Act?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that unless counsel is substituted or permitted to withdraw, Mr. Menendez, your defense attorney, will represent you until either the end of the current term of court or 30 days from today's date, whichever is later? Do you understand?
Yes.
You understand that you have only 4 years from today for these felony charges to file what is known as a habeas corpus petition challenging the voluntariness of this guilty plea. Do you understand?
Yes.
Do you understand you have until the last day of the current term of court to file a motion to withdraw your guilty plea? Do you understand?
Yes.
Do you understand that any of the filings we've just discussed must be filed by your counsel unless you are representing yourself? Do you understand?
Yes.
Okay. Your Honor, counts 1 and 2 are from an incident date that occurred on September 23rd, 2019. Counts 3 and 4 are from an incident date that occurred on December 15th of 2019. I'm going to start with the September 23rd, 2019 incident.
Okay.
Your Honor, on September 23rd, 2019, at approximately 1300 hours, Ricky Wolf and an unidentified male fatally shot Melvin Robinson in the parking lot of the Lowe's hardware store at 3625 North Commerce Drive in East Point, Georgia. Also shot was Melvin Robinson's friend, Mr. Clint Flakes. When officers responded to the scene, they found Mr. Melvin Robinson unresponsive in the parking lot of the Lowe's with several .40 caliber shell casings surrounding him. Mr. Robinson was clinging to life and was taken to Grady Hospital, where he passed away from his injuries 3 days later. Investigator Ricky Mashad of the East Point Police Department was the lead investigator. I'm sorry, Mr. Ricky Mashad was the lead investigator.
Can you spell his last name for the record?
Michaud. And so during his investigation, Mr. Mashad initially spoke with Tommy Clerkley, who was in the vehicle with both Clint Flakes and Melvin Robinson just prior to the shooting. While the three individuals were in Mr. Robinson's pickup truck, an unidentified black male attempted to open the car door that was occupied by Mr. Robinson, Mr. Flakes, and Mr. Tommy Clerkley. The perpetrator quickly realized that the car was occupied and then got into a black Nissan Maxima and drove to the opposite side of the Lowe's parking lot. It's a very large parking lot. Mr. Robinson then called police to report the attempted break-in. Mr. Robinson then drove his pickup truck to the other side of the parking lot where the individual that got out of the black Nissan Maxima was attempting to break in to another pickup truck. Mr. Robinson and Mr. Flakes exited the vehicle, and Mr. Robinson had positioned his pickup truck in a way that the black Nissan Maxima was blocked in between a concrete lamppost and the Dodge Ram driven by Mr. Robinson. At which time, 5 shots rang out. 5 .40 caliber shell casings were recovered, and along with another handgun, which was recovered from the scene. Mr. Clerkley stated that he was asleep or not paying attention in the back seat, and that when he heard the gunfire, he quickly ducked down and was unable to identify any of the perpetrators. It was later determined that the firearm that was recovered was the firearm belonging to Clint Flakes. Mr. Flakes later gave a statement stating that he had given the firearm to Mr. Melvin Robinson to encourage him to stop the robbery. After Mr. Flakes was shot, he was shot in the face and he went into the Lowe's department store to seek help, where as he entered, he dropped a machete-like object on the floor, which was recovered next to the blood trail. Mr. Flakes was unable to identify any of the perpetrators and stated later that the perpetrators were possibly wearing a mask. There is a pole camera from the parking lot that is grainy and distant, but it does show the sequences of events that happened. However, there's not any identifying indications of the potential 2 suspects in the Maxima. In an attempt to try to figure out the perpetrator, Investigator Mashad was able to get the cell tower logs of all of the major cell phone carriers in the area of the Lowe's parking lot. At a later date, he then discovered that the particular Maxima that was suspected in the shooting at Lowe's was involved in a entering auto where a purse was stolen, and that Maxima was also itself stolen 2 days prior in Union City. While Investigator Mashad was waiting on the returns from the cell phone tower dumps, the Maxima that was suspected in the murder was burned at a rail yard in city of Atlanta on October 3rd, 2019, for which fellow gang member Emery Batten was charged. Emery Batten, before Mr. Wolf became a suspect, was the original suspect in the homicide. He was seen in a silver stolen Range Rover on Instagram the day the car was burned on October 3rd. And then the silver Range Rover was seen following the black car into the rail yard in the early morning hours, just after 1:30 a.m. I'm sorry, yeah, just after 1:30. Where rail worker Johnny Campbell saw the cars enter, heard an explosion, and then saw the cars burning and the Range Rover speeding away. That Range Rover later hit a LPR about 6 miles away as it fled. Emery Batten's cell phone records put him away from the homicide at the time of the homicide. However, Emery Batten received a phone call from a number that was later determined to belong to Ricky Wolf. Once the cell phone tower logs were returned, that same cell phone number that called Emery Batten directly after the murder appeared in the area of the stolen Maxima, in the area of the entering auto, in the area of the homicide, around the times of the homicide. Officer or investigator Mashad then went and got the cell phone records of that particular number, and that cell phone was registered to Mr. Ricky Wolf. Getting more detailed copies of the records directly before the homicide, the phone number was bouncing off a tower in the parking lot of the Lowe's convenience store or department store, and it was in that area for about 45 minutes prior to the homicide. Directly after the homicide, the car flees westward, makes an immediate phone call to Emery Batten, and then 2 hours later, that phone number is disconnected permanently. Your Honor, Investigator Mashad was able to determine that both Emery Batten and Ricky Wolf were members of the 27 Uno's criminal street gang. In trying to figure out additional leads, he was able to obtain both of their Instagram records, which then led to obtaining Instagram records for about 19 other 27 Uno's co-defendants, which led to several other auto theft arrests and convictions. However, Mr. Wolf was not apprehended until much later in December of that year. And at the time he was arrested around December of 2019, he was not yet developed as a suspect. It took another 2 years for police continuing to look for additional identifying information, additional evidence, whether that be ID, fingerprints, or a tip, before they didn't believe that they were not going to get any more evidence. And charges were brought in 2022. That would be the factual basis for the charges in counts 1 and 2 of the accusation. I should also say that Mr. Flakes was shot in the jaw and tongue, rendering his jaw useless for several days. Moving on to counts 3 and 4, on December 15th of 2019, Ricky Wolf and one of his fellow gang members were spotted on Instagram in a stolen Kia Sorento. Officers went to the area they believed the car was located. A police officer found the car traveling on I-20 and tailed the car from a distance, believing that the car would potentially run. When it was blue lighted, the officers waited for the assistance of the Phoenix helicopter. This being December 15th, 2019. Phoenix helicopter was able to get in the air. The car did flee once it was blue lighted. The car drove to the area of Hollywood Road and Spink Street in Fulton County, where it then all the passengers inside abandoned the vehicle. The other passengers were juveniles, Terrence Cole, Desmond Lindsay, and Rontavious Johnson. The driver of the car was followed the entire time by the Phoenix and was captured, and driver was Ricky Wolf. The other three juveniles were recovered in the crawl space of a garage apartment in the area at the same time. The car, in the front seat of the car, and specifically the driver's seat, there was a handgun and a window punch commonly used in the entering autos. There was also mail from several individuals that was not belonging to any of the individuals in the car. The owner of that Kia Sorento had the car stolen from her out of Union City days prior, that being a 2016 black Kia Sorento owned by Gabrielle Davis. Your Honor, Mr. Wolf is a 27 UNOS member. They are known for slider crimes, for stealing autos, and then using those stolen autos to commit further crimes, much like the incident outlined here. The Emery Batten is a confirmed member who was his co-defendant in the homicide and the destruction of evidence, as well as the Mr. Desmond Lindsay, Rantavious Johnson, and Terrence Cole, all confirmed members of 27 units. Your Honor, that would be the factual basis should this case have gone to trial.
Very thorough. Thank you. Does Ms. McKinney or anyone else want to be heard now?
Yeah, I think now Ms. McKinney did email me a written statement, but if she wants to speak, this would be her time to speak, or if she would prefer that I read the statement, I can do that as well.
Sure. Good morning, Ms. McKinney. This is Judge McBurney, and I'm happy to hear from you directly, or if you would prefer that Mr. Hiles read your victim impact statement into the record. Either one works for me. This is your opportunity to share with me and the public that's plugged into this hearing the impact that these crimes have had on you and your family. And as I said, I can hear that directly from you or from Mr. Hiles.
Good morning, Your Honor. I would prefer to speak directly.
Okay.
So, Your Honor, this is a collective statement on behalf of our family. Our family believes it's important to remind the court of who Melvin was as a person, and the fact that he was murdered during an act of bravery. He was performing a good deed on behalf of an innocent shopper in the Lowe's parking lot. You know, Melvin was a protector of his community, his family, his friends. He was loyal to his family as an involved father to two of his young sons, who, you know, really looked up to him as, you know, their everyday hero. He was loyal to his friends who looked up to him as for guidance as a leader, and he was loyal to his community as an admired businessman. You know, he also was a student obtaining his PhD, and then his life was cut short. On Monday, September 23rd, you know, he went about his daily routine of dropping his 7 and 8-year-old sons off at school. He spoke to his fiance, his parents, his sister, his brother, his employees, just like any other day, you know, except that that day was the last time. In 3 days, it will be 4 years since Melvin was stolen from us. And the void in all of our lives from Melvin not being here will never be filled. There's a hole in our chest with relentless silence and spaces that used to be filled with joy and laughter. His children continue to struggle with understanding why their father was taken from them. He was doing something right. Melvin made daily choices to use his life to create an impact that made a positive difference for himself and those around him. The defendants made the choice to use their life to join a gang and participate daily and kept causing chaos, disruption, violence in their community for no reason other than just something to do today. They made the choice to be career criminals and jeopardize the safety of innocent people that were just going about their daily lives. And they are in this courtroom before you today because they, like countless other days, made the conscious decision on September 23rd to not just steal property, but to permanently take Melvin's life. Three months after taking Melvin's life, the defendants were involved in performing the same criminal acts. In December 2019, that proves they had no remorse for anything they had done just 3 months prior. The defendants need to be held accountable for their actions and made to face the consequences for causing irreparable havoc to the community and our family. There is no limit to the years of prison time that will equate to the worth of Melvin's life. While in prison, the defendants will be able to speak to their family and friends, laugh at their jokes, participate in birthdays, Christmases, and tell and see others that love them. They have rights to a quality of life that will allow them to continue to enjoy the world around them, while Melvin has no life. He can't experience the same for his life and his family, and that is due to the decisions of these two defendants. We, the Robinson family, ask that you please take all of what you learned today into consideration and make the decision to ensure the defendants face the maximum possible sentencing so they don't get the opportunity to make the choice to violate and the safety and freedom of another family. Thank you, Your Honor. Thank you.
Thank you, Ms. McKinney. Can you please share with me two things? One, what was your relationship, sibling, friend, what, to Mr. Robinson?
His fiance.
Fiance, all right. And
his children.
how many children?
He has
I'm sorry.
two.
Two, how old are they?
They were 7 and 8 at the time, and now they're 11 and 13.
Okay. And you all are now outside the state of Georgia?
Yes.
Okay. And I'm assuming that's Mr. Robinson that we see on the screen?
Yes.
Okay. All right. Ms. McKinney, thank you for sharing. What you've helped me understand is sort of a composite reflection of friends and family members and the impact this has had on all of them, not just you and your children, and the loss that everyone continues to experience.
Thank you, Your Honor.
Okay, thank you. Ms. Hardy, can you share with me, please, the criminal history information you have, if any, on Mr. Wolf?
This defendant has 10 arrest cycles out of Georgia, no felony convictions and 1 probation violation. Nothing further to report.
So it would be a misdemeanor probation violation?
Yes, Your Honor.
All right. And Ms. Tucson, do you have any records for Mr. Wolf? I'll take that as no. Mr. Manettis, what do you want to share about Mr. Wolf and his situation and all that we've heard this morning?
Yes, thank you, Your Honor. I do appreciate the state for engaging with us and allowing us to resolve this. It's my understanding, I advised Mr. Wolf that he'll be pleading guilty to these gang charges. Now he'll be sentenced under a level 5 severity where that'll follow the parole guidelines of the time, not the ones that changed this past July. And then there'll be subsequent parole after that for the rest of the 15 years, and then subsequent probation for 10 years, the last 5 of which might terminate if he's had no violations. And Mr. Wolf is not going to come before this court again, Judge. It's been a very intricate negotiation process with the state, and we appreciate them and this court for that platform, and we just accept this honorable court to accept the plea as negotiated.
All right. Mr. Hiles, what is the sentencing range for these 4 charges?
Each charge carries with a sentence range of 5 to 20 years.
So I'll need to stack something to get to 25 to do 15?
Yes, Your Honor. So I guess count.
I'll structure it however, but what you've negotiated doesn't bind me, but what you all have negotiated is 25 to serve 15. And I need to do some kind of consecutiveness to make that work across the 4 counts.
That's correct. Your Honor.
Okay, got it. Mr. Wolf, this is your plea and sentencing hearing, not anyone else's. And in the very same way that it was important for me to hear from Ms. McKinney on behalf of Mr. Robinson's family, I want to give you the chance to say anything. If there's anything you want to say, you can rely on what Mr. Manettis had to say, but you have a right to be heard as well.
I just want to say I apologize to Mr. Robinson's family for what happened. And I'm a changed person.
What's changed?
People died around me in jail. Like a lot been going on, people being stabbed. Like, it's changed my life.
How long have you been at Rice Street?
19 months.
Okay. Anything else?
That's all.
All right. Well, Mr. Wolf, yes, sir.
If I could quickly add, I can't remember if I failed to say this or not, but that the negotiation is with credit for time served for those 19 months.
Okay, yeah, I think he's entitled to that. I'm familiar with the progression of these cases, and Mr. Wolf has been in custody in connection with these allegations and a related case for all those months. And so I think he is legally entitled to that as credit. So, Mr. Wolf, I find there's a factual basis for your plea. You're pleading to one case, this case ending in 496. And it's my understanding, Mr. Hiles, that when we're done here today, you are making an oral motion to null pros the 3 cases on the calendar, going in numerical order: 19 SC 173484, 20 SC 177222, and then 23 SC 186399. Is that correct?
Yes, Your Honor.
Okay, so those will all go away. Mr. Wolf will enter a plea, is entering a plea to the case ending in 496, and he'll move forward with the sentence that he gets. Okay.
And you're just to perfect the record that lastly, the dismissals are with prejudice, is my understanding.
Sure. I mean, I don't know that we do that on the criminal side. I will be signing a null pros. And so they are dismissed.
They were made as part of the negotiations, so they cannot be brought back.
Okay, that would be inconsistent with the state's negotiations if they sought to pursue those charges in some other format. All right, back to where I was. I do find that there's a factual basis for your plea. I also find that your plea is knowing and voluntary. Voluntary means no one's threatened you to enter this plea, but you've decided after consulting with your lawyer and maybe family members that the right way forward for you, Mr. Wolf, is to plead guilty. Is that correct?
Yes, sir.
Okay, and a knowing plea means that you've understood all the things we talked about because you've had a chance to speak with Mr. Menettis. Do you have any questions about anything we've discussed so far?
No, sir.
All right. I'm sentencing you pursuant to the Probation Option Management Act, which means that when you are on parole or probation, and you'll likely be on both over time, if you have a minor violation of your probation, you miss a meeting or something like that, that will go to probation for you to work out. But if it is more serious, you get arrested, anything like that, or you violate any of the special conditions that I'm about to set, that will come back to me. Mr. Menettis, may we sign your name electronically to this new accusation to which your client is pleading guilty?
Yes, Your Honor, you may.
Mr. Hiles, can we sign for you?
Yes, Your Honor.
And Mr. Wolf, is it okay if we electronically sign your name to the new case to which you're pleading guilty?
Yes, sir.
All right. Mr. Wolf, I am going to sentence you on counts 1, 2, and 3 of this accusation to 18 years to serve. And on count 4, I'm going to sentence you to 10 years. That'll run consecutive to count 1, and that will be probated. So your total sentence is 28 years to serve 18 years with a balance on probation. 3 special conditions of probation. Number 1, no contact with folks who you know to be in gangs. 2, no participation in gang-related activity. And 3, no possession of actual firearms or replica firearms while you are on probation. I am sentencing you this way because I think it more accurately reflects the seriousness of what happened in this case. I mean, in one respect, a life was taken and a sentence of life is what would be appropriate. It was helpful to hear the state's evidence in this case. I think there are defenses that Mr. Menettis would be able to bring on your behalf if this went to trial in terms of identification, and the fact that your cell phone is present doesn't mean that you're present at the scene of the killing of Mr. Robinson and the aggravated battery against Mr. Flakes. But what I do see unequivocally and very clearly is that you were in this mix and being connected with a situation which resulted in the death of someone didn't deter you from doing the same kind of stuff. I don't mean shooting people, but breaking into cars, driving stolen cars, high-speed chase with the police. It wasn't a one-off for you. It was a way of life. And so I actually take some reassurance from you saying not just you're sorry, which you should be, but that you're going to live your life in a different way. The life that you were leading back in 2019, 2020 is one that was dangerous to others and frankly dangerous to you. I'm confident that people you know were shot and killed because of the way they were living their lives. It's not easy to make change. You knew what you knew because you grew up in it and you lived in it. But I am hopeful that when you complete your sentence, and there's light at the end of your tunnel. I mean, the big contrast that Ms. McKinney drew for us is an important one because there isn't light at the end of Mr. Robinson's tunnel. His tunnel ended in that Lowe's parking lot. You're going to get out. You're going to get out and you're going to plug in with people. And I hope for you, it's a different set of people than you were plugged into when you committed these crimes. I can't bring Mr. Robinson back. I can't fill that hole in the heart of all the folks who loved and cared for Mr. Robinson. But what this process is hopefully doing for his family is bringing about some closure. They know that people have listened and people care. And there are consequences for the actions that resulted in his senseless death. That'll be your sentence. You will get credit for every day that you've been in custody. We're on past 500 and something, but all those days will be credited to your sentence. Mr. Menettis, anything else on behalf of Mr. Wolf?
Yes, Your Honor, I would just ask this honorable court to reconsider the confinement aspect of the deviation that the court's made. The 15 years was part of a pretty intricate bargaining process that involved a lot of moving parts. And we do hear the court in terms of everything that the court feels and heard. And we'd ask, could we please have the 15 years stay the same and then add some kind of special conditions or probation to the back end instead of altering the confinement portion, because that was a pretty big centerpiece of the negotiation process.
Okay, Mr. Hiles, anything you want to add?
I'm gonna leave this to the board's discretion.
Okay. I didn't think you were going to disagree with Mr. Monetis. I understand that you all have been negotiating this. One person who was not part of the negotiations, appropriately so and necessarily so, would be me. And having heard everything I heard, I believe that this is a reasonable sentence that reflects the seriousness of what happened and is where we end up. So, Mr. Wolf, I wish you the best. You will get out of Rice Street real soon. I'll make sure that you get on into DOC custody, so you are out of the environment where you have seen the kinds of things that hopefully will help shape the way you move forward. Okay. Thank you. Thank you, Mr. Monetis, for plugging in from wherever you are. You are free to go, and we'll take care of the null process. All right.
Thank you, Judge. Thank you for allowing me to appear by Zoom, and it's good to see you.
You bet. Take care.
I grab a quick drink of water.
Yeah. Yeah. Ms. Wood, is Ms. Wood? She's back there. All right. Ms. Mignot, do you have an update on Ms. McBurrows?
Yes, Your Honor, that is going to be a negotiated plea with the state. We just respectfully request that we're allowed to take that plea the Monday of the second week of your trial calendar, only because my client has a medical issue that needs to be addressed today, and I wanted her to be able to go take care of that first. Also, an offer from the state was just conveyed, a different offer was just conveyed to her this morning, so it'll serve two purposes: to take the plea at the second week, she'll have an opportunity to think about it. We're not gonna, I don't think there are gonna be any changes, Judge, and in all fairness to the state, my concern is that there's not gonna be an ambush by trial. So we're not gonna show up the second week, and I think that was one of the concerns of the state. That's why I wanted to make the open court announcement that it is going to be a negotiated plea.
Okay.
Unless the court has a plea calendar that it could go on.
Yeah, so here's the dilemma. I'm open to working with schedules, and I certainly don't want to stand in the way of Ms. McBurrows getting to a medical professional. Number one, what I'll be doing the morning of October 2 is picking a jury and not delaying that so we can take a plea. I guess if you all were here at 8:30 on Monday, we could do that. That's early. It's not a problem for me. I dropped my kid off. I got to be here before then.
You can do 8:30, Judge, or if you want to do Friday the 22nd, are you open Friday the 22nd?
I will be here taking a bunch of pleas. And so why don't you check with Ms. Nelson? You can just go on back, get buzzed in and look at her sketch. She knows that there's a bunch of stuff happening on Friday, but that was gonna be my next suggestion, assuming Ms. McBurrows can deal with what she needs to today. Everyone else is gonna be in here. All the prosecutors will all be here doing some pleas on Friday. And so I'm very open to that. Plus, that gives everyone the comfort of, yep, the plea went through, so we know there's not the last minute surprise of, you know what, October 2 is actually a trial. Does that work?
That works.
All right, so Ms. McBurrows, if you don't mind just taking a seat, I'll have Ms. Mignot go back and talk with Ms. Nelson. And if she gets the green light for some time on the 22nd, then you two can both go, and we'll see you back here on the 22nd. Okay, Mr. Bastian, do you have any updates?
Yes, I do. So it's gonna be, both of them, please, please, we're ready for number 3 and for Mr. Sept, which is number 10.
Fantastic. So what I guess we should do is see if Ms. Wood is in the middle of something, we'll pause on Batten. and we could start taking some of these other pleas because you're ready. Mr. Brown, do you have an update?
Yes, I confirm it's gonna be a non-negotiated plea. I just need the indictment and the plea paper.
So we won't have the indictment, excuse me, we'll do electronic signatures. But there is a plea form. If you want to grab that, you're welcome to come right on up. I think it's, or Deputy Gordon will hand you one. And Mr. Muhammad, I think I saw you, there you are. We just need to have that conversation about the continuance. In fact, we'll probably do that first. Let me just see, Ms. Wood is here. Hey, do you want to, are you ready for the Batten plea?
He needs to be brought out and spoken to by the court judge.
Okay, we're going to pause on that then. Why don't we have, is it Ms. Willingham? Do you have, or you're representing Ms. Marsh for purposes of the continuance? Okay, so let me find the case. Hold on one second.
It's position 21.
Thank you. All right, Mr. Russell, you here? Great. You can stay seated. Just want to make sure you were still here. So Mr. Muhammad, tell me, before we get into that, Ms. Mignot, did you get good news?
Yes, Your Honor, 11 o'clock Friday morning.
Okay, so you let Ms. McBurney know that situation and we'll see you guys then.
We'll be here, Judge.
All right, Mr. Muhammad, you had filed a motion to continue. I wasn't ignoring it. I was wanting to have a conversation with a prosecutor present as well. And so you can be right there. We don't need to make a record of this. I'm happy to just hear informally from both sides. Tell me what your concern is and why. I think it had to do with the health and well-being of Mr. Russell's mother, or at least a close family member.
His mother passed away on the 6th.
Okay.
And when we were here last time, she had went into hospice and we had asked for continuance on that basis. You said that it's possible we could keep asking if she stayed in hospice for a long period of time over multiple calendars.
Right.
And that if anything changed, to come in, and to file a motion for continuance and to let you know. And then she did pass away on the 6th. This is not based on something in his schedule that he has to do. It's just based on the thought that something like that happens, to give a little time.
To grieve and process and because things did change for the worse for Mr. Russell and his family.
Right. And
okay.
I understand that it's like a 3-week calendar or something, but I'm thinking that 2 weeks or 3 weeks isn't the time that I think would be necessary. So I think if we got a continuance off of the calendar, it would be appropriate.
So another thing you had asked about was who's the prosecutor, who should I be negotiating with, et cetera. And we identified that as Ms. Marsh. Have you and Ms. Marsh been in discussions about resolving the case?
We had a very good discussion. I'm very hopeful that this is not going to go to trial. But the ball's in their court, and then we're going to hear back from them because they're doing some things. Okay, and I think Ms. Willingham, that's what you alluded to, that in fact your office is looking into things, and if the trail leads where you think it might be going, and not you personally, but the office does, then there might be a non-trial resolution.
Yes, Your Honor.
Okay, so the next trial calendar, I think, is one that we call on October 27th, and then it runs that week that has Halloween in it. So it's the week of October 30th. That's as far out as I'd be comfortable moving it. That would have the dual benefit of allowing Mr. Russell and his family to continue to process the loss of Mr. Russell's mother and give the state a little more time to be pursuing the information they're pursuing based on the conversation you had with Ms. Marsh. Does that work for you?
Yes, it does.
Mr. Russell, if I move the trial to that week that has Halloween in it, is that letting you work through the things you need to? Okay. I'm not going to be inclined to continue it again for reasons in that space. They'll always be grieving, and it's a big loss to lose a parent. These are serious charges, and we need to get closure on the case. And I'm confident Mr. Russell wants closure on this case anyway. But I view that as enough time for the state to pursue what it needs to pursue. So I'll view this as everyone's ready to go if it is going to be a trial the week of October 30th. Again, we call the calendar on the 27th.
That's fair.
No discovery concerns?
No.
Okay. I know you're speaking on behalf of a colleague, but okay with that?
No objection, Your Honor.
Okay, all right. Then we'll continue this. I'll grant the motion. I'll do it in writing so it's in the record. And we'll move this to the October 27th trial calendar. Mr. Russell, I'm sorry for your loss.
They would be excused.
Yes, sir. Just now? Mr. Price? Hey, Mr. Price, where you been?
I had to drop my son off at school, and I also had another case today that I had to handle with generation. And I mixed up the case times, and I apologize.
Okay. All right. Did you let your lawyer know?
Yes, we spoke.
Okay. All right. Because she was nervous for you, because if you're not here, that makes it complicated for you. But now you're here. Please stick around until Ms. Wood talks with you. I think your case is one we were going to be able to resolve today. Is that still true?
Yes, Judge, I just need to talk to him.
Okay. So stick around. Do you think, Ms. Wood, it benefits Mr. Batten just to sit tight for a little bit, or it'd be better if he came out now and we had a conversation? Because I'm happy to pivot and take some of these other pleas while he ponders things. But if you think pondering is not productive, then we can get him out here.
I think we should bring him out now, Judge.
Okay, let's do that.
Yeah, she's right there.
All right, Mr. Batten.
Yes, sir.
I'm Judge McBurney. We've met before. It's been a while. I know this case has been sitting around for a while, and even worse, you've been sitting in jail for a while. But we just sorted out Mr. Wolf's situation. He entered a plea they structured it with some not new charges as in new conduct, but they basically took old charges and put them in a new indictment. He just pled to that, and I've closed out all his cases. That leaves you, and you're still in a case with some real serious charges. I've now learned more about it because Mr. Hiles, the prosecutor, gave me a lot of the factual background to that stuff. And what he had shared with me, and your lawyer, Ms. Wood, echoed it, was that you were ready to work your case out as well. But then Ms. Wood came out looking a little frustrated. I know she'd been talking with you, and you guys are having a robust discussion, which you should, saying, now maybe it's not working out. And so I just wanted to hear from you, and then you need to hear from me about where we are and what might happen next. So tell me, I don't want you to talk about the facts of your case. That's you and Ms. Wood. But tell me where your head is and what you think is going on.
I know like how stuff gonna go. I don't have no win, but I just wanted to be fair. Like, you know what I'm saying? I did my time. I'll do my time for the stuff that I did. Like, you know what I'm saying? I wanted to be fair. Like, you know what I'm saying? I don't want to just be taking the fall for somebody else's situation. And I know that what I did I didn't do.
And Judge, I don't mean to interrupt you, Mr. Batten, but I think some of the confusion is that Mr. Hiles and I have talked about if a plea goes through, it'll only be to certain charges. So I would ask that Mr. Hiles say that so that Mr. Batten is clear.
Right. I was going to say that first. Mr. Howes will know more about it, but your indictment lists a whole bunch of stuff, and there's some real serious stuff. And I just heard about this gentleman being shot and killed, another guy getting his jaw shot. And I heard in that as well that your cell phone was far away from there, which in prosecutor speak means you were probably far away from there as well. But you're connected to some stolen cars and other things and 27 Unos and things where you've got a little bit of what we call conspiratorial liability. You may not have been right there, but maybe that's your crew. Maybe you know what's going on. I don't know. We'll hear from Mr. Hiles on that. But what I understood to be the case was that not you were going to have to plead to everything. You were pleading to pieces. An indictment's 1 million pages long. But that you were pleading to pieces of it. So why don't I do this? Why don't I have Mr. Hiles tell you and me, because I'll be hearing it for the first time. I don't get in the middle of negotiations. The counts to which you'd be pleading, and really more important, I would think, what he's going to recommend. Because if he's recommending 1,000 years to serve, I feel you, because Mr. Wolf did not get 1,000 years to serve, and he seemed to be a whole lot closer to the murder of Mr. Robinson. If he says 5 years to serve, I'm going to feel you a little less because it's going to be somewhere in between. Who knows? But let's hear what Mr. Hiles has to say about the counts and what the state's recommendation is going to be. And then let's keep talking. No one's forcing you to do anything other than you're on a trial calendar. You've been in jail for over 400 and something days on these charges. And I want to get closure on this. And that means we bring in 12 people and they hear all about you and look at you and figure out what they're going to do. Let's let them do that. If it means you've worked something out because you got a good lawyer, then let's do that instead. Mr. Hiles, to which of the counts would Mr. Batten be entering a guilty plea? And you don't need to say the number so much as the events underlying them, because that seems to be what Mr. Batten is focused on.
Right. So he is only pleading to, and he was never charged with homicide or anything of that nature, but he would be pleading to counts 14 through 16, which are all violation of Street Gang Terrorism and Prevention Act counts that carry with it a sentence range of 5 to 20 years each. Those counts involve the arson of the Maxima that was involved in the.
Heard all about the Maxima getting burnt up and a silver Range Rover with maybe you driving it to the scene and from the scene. So burning up a Maxima, no one's hurt unless you're a Maxima.
And the incidents around that. And then he would be pleading to charges 22 through 26. Those are incidents that occurred between let me make sure. January 5th and January 12th of 2020. They are each a one count of violation of criminal street gang activity. The underlying charge associated with that is a theft by receiving for stolen cars, all of which were stolen between October 5th and January 5th and January 12th, 2020. They were all stolen from the Buckhead area, either with the keys left in the car or a lockbox that was broken into from a valet at a local restaurant. the recommended sentence.
So that's it for counts.
That's it for counts.
So conduct would be burning up the maxima and some stolen cars.
Correct.
Got it. No shooting anyone, no stabbing anyone, nothing like that.
No weapons charges.
Okay.
Those were based off of, well, he's already admitted to and pled guilty to some conduct around that time frame, which he was sentenced to. And he's actually been in continuous custody on these related charges since.
Which is why he's wearing the red jumpsuit.
Right.
Okay.
Since January 17th, 2020 would be his credit date.
So he'd be getting credit for 3.5 years.
Yes.
Okay. And what is your recommendation if this goes forward?
The recommendation was 15 years to serve 8 years with the balance on probation. And I had discussed with Ms. Wood that the special conditions being no contact with known gang members, no participation in street gang activity, no weapons or replicas. But if he successfully completes the first 3 years of the probated term, that he could petition the court for early termination.
Got it. And Ms. Wood, is this a negotiated plea or non-negotiated?
Negotiated, Judge.
Okay. So Mr. Batten,
Yes, sir.
I now better understand the little slice they're pulling out of that indictment, saying this is what you're pleading to. I pretty clearly understand what the recommendation is. And more importantly, I had you down here as having been here, as in Rice Street, for 430, 440 days. That's just a piece of it. You've actually been in custody for which you'd get credit all the way back for more than 3.5 years, because here we are in September. So not a lot left on whatever the custodial portion would be before you'd be eligible for parole. But we're getting way ahead of things. Having heard what Mr. Hiles is describing, is this something you want to go forward with, or do you want us to figure out which of the 3 weeks starting next Monday, we ought to bring a jury in to hear about your situation?
Yes, sir. I was just wondering, is I'm eligible for like a program or anything?
You may be eligible for a lot of things. What your lawyer was able to negotiate, my assumption is that when Mr. Hiles first started talking with Ms. Wood, he was talking bigger numbers. And Ms. Wood has highlighted, hey, let's not lump Mr. Batten in with Mr. Wolf. There's no gun, no one shot, and they're connected, but not in that way. And so Ms. Wood has gotten the state to go in a direction you'd want it to go. And Mr. Hiles has said, we're not going any lower. So that's where they got. I can sentence you to whatever I want. That's a legal sentence. So I couldn't give you 1 million years because it doesn't add up to 1 million. I could give you time served. Ms. Wood, because she's negotiated, is not going to advocate for time served. She might be thinking it. I know you're thinking it. But I'm not bound by the negotiations. I could learn more about you in this situation and say, I don't think 8's enough. I think it should be more. I could learn more and say 8 seems like a lot for some stolen cars, and give you a little bit less. The notion of a program is a great one, but that's just not where the negotiations get you, given everything that's going on. Okay. So I'm going to leave it up to you, and you don't need to decide right now. We're going to be here all day if you want to think about it a little bit more and talk with Ms. Wood. But today is the day for you, through Ms. Wood or directly to me, to say, I'm not interested in this. This police stuff is for the birds. Bring me a jury. And then we'll get you into street clothes. You don't have to wear your red jumpsuit for the jury. But we'll get your jury in here. And are there counts that you'd be dismissing?
No. If we go to trial, it would be on the entirety of the indictment, which would be counts.
You don't need to dive into it, but there are counts that you're not going forward on now that if we went to trial, the jury would hear about.
Absolutely. Yeah.
Okay. I don't know what Mr. Batten's charged with in the indictment, if he's charged with all of it or just some of it. But the critical point is there are things you're dismissing in exchange for the plea that you would not be dismissing if we go to trial.
Yeah, I'm dismissing the counts for the underlying activity, the arson, the tampering with evidence, and then the actual theft by receiving themselves, which do not merge with any of the gang charges that they're associated with. So the
Okay.
record is much higher.
Got it. Okay. So Mr. Batten, do you want to have a little time to talk with Ms. Wood about it? You know what you want to do, or tell me where you are? I know you're not happy. You don't like your choices. You want that third choice of can I have $100 and get out of jail now. But guess what? That's not on the menu.
I already know it.
Yeah. So tell me what you want to do. One choice is, hey, give me some more time. Check back with me at 1 o'clock. I'm happy to do that.
It won't make no difference.
Talk to you in the back.
All right.
You want a little time to talk?
Yeah.
Okay.
Yeah, I talked to her for a minute.
Good. Hey, I respect that. This is a big choice you're making. Then let's do one of the pleas. You're ready to, let's do Spence. I mean, I assume it's better to be knocking out the ones back there, or? Okay, wait, is Spence Ms. Wood?
No, Spence is me.
Oh, right, because you're a defense attorney. Okay. Who else? Ms. Taylor is here. You ready to go, Ms. Taylor? Okay, we'll take care of you as well. We are going to take a lunch break. No one panic. Yep. Okay.
Okay, thank you.
You bet. Let me give you all a little more light. Great. All right. Hello, Mr. Spence.
Good afternoon, Mr. McBurney.
Good. It's still morning. We got a few more minutes. So good morning to you. How are you doing?
I could be doing better.
Okay. Well, I'm hoping that we're going to bring to a close a real long chapter for you. You've been in jail for a long time, been stuck a little bit because we couldn't get a lawyer for you. Mr. Bastian has very helpfully gotten involved as your counsel, and I think you're ready to enter a plea. Is that correct?
Yes, sir.
Okay. So what's going to happen in just a moment is that Mr. Peoples is going to put you under oath, and he's going to ask you some questions about your case. I need you to answer those questions truthfully. And if you have questions about anything, because you can't hear it or it doesn't make sense, whatever it is, let your lawyer or me know so we can help you out. Okay.
Yes, sir.
All right, Mr. Peoples.
Thank you, Your Honor. Will you raise your right hand? Solemnly swear the testimony you give in the proceedings before you today will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
Thank you. You can lower your hand. Restate your true, correct, and legal name.
Terry Spence.
Can you spell it for the record?
TerrySpence.
Thank you. Now, are you now under the influence of any drugs, medication, or alcohol?
No, sir.
Is there a medication that you normally take that you have not been given?
No, sir.
Excuse me, Mr. Peoples, please adjust the microphone.
Are you able to hear me?
Much better, thank you.
Thank you. I'll sit a little closer. I'll ask it again. Is there a medication that you normally take that you have not been given today?
No, sir.
And how far did you go in school?
12.
Are you able to read, write, and fully understand the English language?
Yes, sir.
So you completed high school?
Yes, sir.
Okay. Have you had the opportunity to review the document that charged you in this case, which was the indictment?
Yes, sir.
Do you fully understand the nature of the charges that are pending against you?
Yes, sir.
Do you understand that by pleading guilty today that there are certain rights that you give up, which include the right to a trial by jury, the right to be presumed innocent, the right to confront the witnesses against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right not to incriminate yourself? Do you understand all these rights?
Yes, sir.
You understand that if you were to plead not guilty or remain silent and enter no plea at all, that the state would be required to have a trial on these charges by jury?
Yes, sir.
You understand that you're charged with the following offenses. Count 1, aggravated assault, which carries a sentence range of 1 to 20 years, aggravated battery, which carries a sentence range of 1 to 20 years, battery, substantial physical harm, which carries a sentence range of 1 day up to 12 months, and misdemeanor obstruction of law enforcement officer, which carries a sentence range of 1 day up to 12 months. Do you understand that?
Yes, sir.
You understand that this is a negotiated plea of guilty, which means that the recommendation of the state and the defense will be a sentence of, Your Honor, we will be asking for a sentence of 10 years to serve 3, the balance on probation, completion of an anger management course, and a stay away. I believe that Mr. Spence has already spent well over 1,000 days in confinement already. You understand that the court is not required, also, Your Honor, completion of an anger management course.
You mentioned that.
And stay away from the victim as well.
Yep.
You understand that the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law.
Yes, sir.
Should the court's sentence include a period of probation, you will be required to obey both the general conditions of probation and special conditions of probation. You'll be required to follow the general conditions of probation that probation will give to you when you meet with them, including but not limited to that you are not to violate the criminal laws of any governmental unit. Do you understand that a violation of any special condition of probation could lead to a revocation of your probation?
Yes, sir.
Are you entering your plea of guilty with an understanding of everything that we've just talked about?
Yes, sir.
Has anyone used any force, threats, or promises which has caused you to enter this guilty plea against your will?
No, sir.
Are you satisfied with what your attorney has done for you in this case?
Yes, sir.
Do you have any more questions for your attorney before we move on?
No, sir.
Have you understood everything that I've asked you so far?
Yes, sir.
Understanding all of your rights, do you wish to enter a guilty plea to these charges today?
Yes, sir.
Did you in fact commit the offenses to which you are now pleading guilty?
Yes, sir.
Are the facts? Are you a citizen of the United States?
Yes, sir.
If you wish to challenge this plea for legal error, you may do so in one of 2 ways. Your lawyer can explain to you what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal in which you have 30 days from today's date, from the date of the sentence to file this appeal. And the second way is a habeas corpus petition in which you have 4 years for felonies and 12 months for misdemeanors to file. Do you understand these time limits?
Yes, sir.
Your Honor, if this had proceeded to trial, the state would have expected to prove beyond a reasonable doubt that on July 5th of 2020, law enforcement responded to 990 Piedmont Avenue Northeast in Atlanta in Fulton County in regards to a person stabbed. Upon arrival, they met with the victim, Bryant, B-R-Y-A-N-T, Newkirk, N-E-W-K-I-R-T, who had a laceration to the left side of his upper back. When asked who had stabbed him, he pointed at the arrestee, Mr. Terry Spence, who was being detained by a security officer. Law enforcement informed him that an ambulance was en route to render aid. They spoke with the officer who stated that Mr. Spence had confessed to stabbing him on body camera footage. Counsel, do you stipulate there's a factual basis for this plea?
I do.
Your Honor, we've attempted to make make contact with Mr. Newkirk several times, but have been unable to do so. I believe that he may be unhoused, but we were unable to make contact with him.
Okay. Ms. Hardy, do you have any criminal history information on Mr. Spence?
Yes, this defendant is a multi-state offender with arrests out of Georgia, New Hampshire, Florida, North Carolina. 2003, a felony conviction for aggravated assault. Another one in 2007. 2010, obstruction of law enforcement. 2010 financial card transaction fraud, 2010 aggravated assault and possession of a firearm by a convicted felon and possession of a firearm during the commission of a felony, 2016 theft of lost or mislaid items, 2017 theft by taking, 2 FTAs and 4 probation violations. Nothing further to add.
Thank you, ma'am. Ms. Tucson, is Mr. Spence on active probation on any of those cases we just heard about?
Can you hear me this time?
Yes, ma'am.
Okay, he is not. It ended in March.
In March. Okay, he basically served out his probation while in custody on these charges.
Yes.
Okay, Mr. Bastian.
Yes, Your Honor. Met with Mr. Spence on several occasions, had negotiations. I can see that, well, I didn't know him before, but from what I've seen that the 3 years this time has changed him and made him think a lot. He's serving as counsel to many people, and he's anchored many bruises and stuff that he didn't want to, but still stayed away because he knew that that would cause him problems, including this arm here that he has. So I recommend that I'm asking the court to accept the negotiations so that he may be able to take this new chapter in his life and we may never see him in this situation again.
All right. So, Mr. Spence, your criminal history is a little concerning. Sounds like you've had a few aggravated assault convictions before, and here we are again. Tell me what you think is going to be different when you get out.
Oh, I have to say something else.
Sure.
And he claims that you knew about it because he said that on that day, he's very sorry that he was not on his meds and that he had a lot of things going. And his daughter was also killed right before that. So there was a lot going on, and that he's hopeful that this is not going to happen again for those reasons.
Okay. Mr. Spence, when you it's been a while since you've been out. Do you have a place to stay?
Yes.
And where is that?
I'm going to be staying with my daughter temporary.
Okay.
She stays in Sandy Springs.
Okay. And she knows you're getting out soon?
She's going to be happy.
Okay. And she's going to let you stay there at least initially.
Matter of fact, she's going to be at the jail.
Okay. All right. Tell me what medication you take that helps you not have situations like this happen.
I take Effection, Respidol, and Remeron.
And tell me what diagnosis they help you with.
Bipolar, schizophrenia, PTSD, borderline personality disorder, ADHD.
Okay. Have you been getting medications like that, either those exactly or similar ones while you've been in jail?
Yes, sir.
Okay. Does your daughter know? You say you're staying with your daughter?
Yes, sir.
Does your daughter know about the medications you need to take?
Yes, because I'm connected with Mercy Mobile.
Okay. Because, my next question is going to be, how do we make sure they may give you a few when you leave the jail, usually generously gives you a few, but I need to make sure you're plugging in with a new prescription. Your daughter's going to help you with that?
Yeah. My daughter's going to take me down on Mercy Care, and they're going to get me all the medications I need.
Okay. All right. Do you have any questions about anything we discussed?
No, sir.
All right. Mr. Peoples, I believe from hearing your factual recitation and my review of the indictment that count 1 merges into count 2. The aggravated assault would merge into the aggravated battery. It's the same incident. And I think all the elements of the aggravated assault fold into the aggravated battery. And any disagreement with that?
No, Your Honor.
Okay. I assume you have no issue with that, Mr. Bastian?
None at all.
Okay.
I was thinking about that. No, I'm just kidding.
So, Mr. Spence, I find there's a factual basis for your plea, and also that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this, and knowing means you've understood the things we talked about. Is that correct?
Yes, sir.
You initialed next to a whole bunch of lines here with your lawyer's help using a purple pen, indicating that you did understand everything. Is this your signature on the 4th page?
Yes, sir.
Okay, you had a chance to talk about it with your lawyer?
Yes, sir.
And Mr. Bastian, you signed it as well on the final page.
I did, Your Honor.
Okay.
I felt like he understood.
Good. I'll make that a part of the record. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, if you have a small problem, you and probation will sort that out. If it's a big problem, you get arrested again, you get off your medications, that's going to come back to me. Yes, sir.
I go to classes as well for anger management. Someone Cares on Forsyth Street, 236 Forsyth Street. It's called Someone Cares.
Okay.
So I've been connected with them before.
Good. Well, I want you to keep doing something like that.
Okay.
All right. Mr. Bastian, may my staff sign the indictment on your behalf indicating your client's guilty plea?
Yes, they may.
Mr. Peoples?
Yes, Your Honor.
And is it okay, Mr. Spence, if we sign it for you? The indictment's back there and we just have people do the signing. Great. Well, Mr. Spence, count one merges into count two. So you'll only have a sentence for count two of the felonies. And I will sentence you to 10 years to serve 3 years with the balance probated. You will get credit for all the time you've been in. You've been in for more than 3 years. So you ought to get out. If not today, then tomorrow. If it's Friday and you're still in, you call Mr. Bastian. He'll let me know and I'll reach out to the sheriff's folks to say, get this guy out. Okay?
Okay.
So it may not happen today, should happen tomorrow. For counts 3 and 4, I'm sentencing you to 12 months to serve. Those will run concurrently with, at the same time, with count 2. So the total sentence is exactly what your lawyer negotiated, 10 served 3, balance probated. You're going to need to stay away from 990 Piedmont. That's the intersection of 10th and Piedmont. There's some restaurants there. It's kind of near Piedmont Park. Don't be around there, okay?
Okay.
You'll also need to have no contact with Mr. Newkirk. I think he's a stranger to you, but I don't know. Maybe you knew him. He needs to be a stranger to you now. Leave him alone. It will be a special condition of your probation that you take all medications that a doctor prescribes. You don't pick your own drugs, but if a doctor says take Remeron, you take Remeron. Okay. And if you're not, that's going to get you sideways with probation. I'm going to ask probation to assign you a mental health probation officer, someone who's particularly fluent in making sure you've got your medication. Maybe you're going to classes, things like that. And it sounds like you're already doing anger management courses at the place you mentioned, so I won't make that a requirement. You just keep doing that. Mr. Peoples, was there anything else in Mr. Spence's case?
Nothing further, Your Honor.
Mr. Bastian?
No, Your Honor.
Ms. Toussaint, do you have questions for Mr. Spence about where he's going to be living? Ms. Toussaint's with probation, so she's going to need to get your daughter's address.
Yes, I'll need a phone number and an address.
Okay.
It's in my property. Yeah.
Okay.
I got it on hand.
Okay, can you get that to me? He says it's in his property at the jail.
The address, or you don't know the address?
Not off the hand.
Okay. Ms. Toussaint, tell me not why, I know why you want an address. So how should we handle this? Mr. Spence doesn't know the address other than that it's in Sandy Springs.
Do you have a good phone number where I can call your sister?
I have 2 numbers.
Okay.
My own, they connect my own phone number.
Go ahead. Tell me.
We'll need to know who you live with anyways.
Okay.
You can put that one, and that one.
Okay. I'm going to give you, Ms. Toussaint, I'm going to give you 3 numbers. They all work. One for him and one is for his daughter. He's hoping to reconnect this phone. 404-398-2333.
And whose number is this?
This is his number.
Yeah, I know some.
And then the other's number is 404. Is that a 4?
849.
849.
4936.
4936. And there's another alternate number, that's another one that the daughter has, which is 470-585-0095.
And this is where you will be living with your daughter?
Yes, ma'am.
What is her name?
Rebecca.
Is it Spencer?
Same last name?
No, Rebecca Ann Griffin Taylor Spence.
Rebecca Ann Griffin Taylor Spencer. Did I get it right?
Yeah.
But the last name is Spence?
Yeah.
Okay.
Okay, and that's 404-585-0095 for her.
Yes, ma'am. Is there a number that you want me to give to him to contact you? Or there's,
For probation?
yes,
Yes, in Sandy Springs, is that Fulton County?
yes.
Yes, it is, okay.
Because I usually tell them if they don't hear within a certain time to call that number.
Right. So, Mr. Spence, when you get out, you're going to hug your daughter, you're going to be happy, but pretty soon you need to make sure you connect with probation. And by pretty soon, I mean within the first few days you're out.
Within 48 hours.
There you go. By the end, if you get out tomorrow, it really should be by Friday. Hopefully you've called them or they've called you. So Mr. Bastian is going to get you a phone number that you should call. If it's Friday lunchtime and you haven't heard from probation, hey, it's me, Mr. Spence. What do I need to do?
Yes, just call, because they do intake now where they call and set up first. So if you call first, that will be good. The phone number is 404-463-0410.
Thank you.
Okay, no problem. And I will call your sister for the address. I mean, your daughter.
Sounds good. Mr. Spence, good luck out there. Stay on those medications. It's going to just get more complicated for you if something like this happens again, okay? You've been in jail for a long time. I hope that you appreciate being on the outside. All right, take care. Yeah, let's get you out of here, then we'll do Ms. Taylor, and then we got to break for lunch so that court reporter doesn't quit on us. We got to give our deputies a break as well, and all the lawyers.
I believe Attorney Clark is.
All right, Attorney Clark. Thank you.
Are you making your debut?
Mr. Coach should be finished with the paperwork by now.
Okay. If I would love to get you and Ms. Taylor out of here before lunch. So let's see if let's take this plea. And then if the team can fit in 2 more pleas, we'll still give everyone an hour for lunch. We'll just slide it. All I have today is this trial calendar. It just means that poor Ms. Feely and Ms. Wood will be here later today.
Thank you.
Just give me 1 second. We'll get started.
Yes, sir.
All right, Mr. Bastian, you ready?
Yes, I am.
Okay.
That'll be an Alfred plea.
An Alfred plea. Thank you. Let's get on the record. This is position 3 on our trial calendar, State versus Jamariel Thompson, 19 SC 165316. We have Ms. Clark representing the state and Mr. Bastian representing Mr. Thompson. Mr. Thompson, you ready to go forward with an Alfred plea, which is a plea where you basically tell me I didn't necessarily do the things the state said I did, but I do want to work the case out in the way that my lawyer has been able to negotiate it. Does that describe your situation?
Yes, sir.
Good. Well, that's what we're going to do. Ms. Clark will put you under oath. You'll need to answer all her questions and mine. If you have questions, it's important that you bring them up. Let your lawyer know or let me know. Will you do that?
Yes, sir.
Excellent. All right, Ms. Clark, when you're ready.
Thank you, Your Honor. Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently pending before the court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. State your name, your age, and your date of birth.
Jamaria Thompson, April the 22nd, 1985.
How old are you?
38.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
How far did you go in school?
GED.
Can you read and write in the English language?
Yes, ma'am.
Have you had an opportunity to review the document called the indictment, which lists the charges in this case against you?
Yes, ma'am.
Do you fully understand the nature of the charges pending against you?
Yes, ma'am.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right not to incriminate yourself. Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, then the state would be required to have a trial on these charges by jury?
Yes, ma'am.
You're pleading guilty today to the, Your Honor, in this negotiated plea, the defendant will be pleading to criminal attempt to commit armed robbery under OCGA 1641. The state intends to recommend no processing the other counts, count 1 armed robbery, count 3 aggravated assault with intent to rob.
So he'll plead to count 2.
Yes.
And you are null processing all remaining. He's charged in 1 through 6 and 9, and you're going forward with just count 2.
Yes, Your Honor.
Got it. Okay.
And the minimum and maximum for criminal attempt to commit armed robbery is 1 to 30 years. Do you understand you're not required to plead guilty to the charges unless the grand jury has heard sworn testimony and then charged you in an indictment?
Yes, ma'am.
Are you now serving any other sentence in confinement, or are you on probation or parole for anything anywhere?
No, ma'am.
You understand that you are entering what is called a negotiated plea of guilty. The state will recommend the following sentence to the court. For a plea of guilty to count 2 of the indictment, criminal attempt to commit armed robbery, the state's recommendation is 3 years probation. The defendant, special conditions of probation, weapon forfeiture. The defendant is to stay away from the co-defendants. Your Honor, the state is of the opinion that based on the age of the case and the fact that co-defendants have accepted responsibility as far as the armed robbery and a plea. Additionally, also the defendant in this case has offered mitigation so that we could actually offer or work something out short of trial. And so we feel that if the defendant does plead to the terms, that this is a acceptable just sentence in this case.
Okay.
Do you understand that the court is not required to follow this recommendation, but can sentence you to the maximum sentence permitted by law?
Yes, ma'am.
Do you understand, however, that if the court does not accept this negotiation, you have the right to withdraw your guilty plea today?
Yes, ma'am.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and the special conditions of your probation. You understand?
Yes, ma'am.
You're required to follow the general conditions of probation that probation will give to you when you meet with them, including but not limited to that, you are not to violate the criminal laws of any governmental unit.
Yes, ma'am.
You are also required to comply with the special conditions of your probation. And the special conditions are a weapon forfeiture. You are to stay away from your co-defendants. You do understand?
Yes, ma'am.
You understand that a violation of these conditions could lead to a revocation of your probation?
Yes, ma'am.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, ma'am.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes, ma'am.
Do you have any more questions for your attorney, Mr. Bastian, before we go on?
No, ma'am.
Have you understood everything that I have said to you thus far?
Yes, ma'am.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes, ma'am.
Is it your decision to plead guilty, made freely and voluntarily?
Yes, ma'am.
Are you entering your plea of guilty pursuant to North Carolina versus Alford? Meaning that you may not admit guilt to every element of the crime charge, but believe it is in your best interest to plead guilty today?
Yes, ma'am.
Are the facts of this case, Your Honor, at this time, the state will provide a factual basis for the guilty plea in this case.
Okay.
If this matter would have went to trial, the state would have been able to prove beyond a reasonable doubt that on the incident date of February 5th, 2019, at approximately 11:58 p.m., officers were dispatched to a pedestrian robbery at the incident location of 518 Peg Road Southwest. Officers arrived on scene and made contact with the victim, Antoinette Frazier and Darius Bussey. Victim Bussey, spelled B-U-S-S-E-Y, stated that he and Ms. Frazier were walking on Peg Road Southwest towards Pomona Circle Southwest when a black Dodge Neon with a spoiler and paint missing off the rear end pulled up in front of them. Mr. Bussey stated that three unknown black males got out of the vehicle and approached them on the road. Mr. Bussey described the driver of the vehicle as a black male that was light-skinned, approximately 6'2" in height, having an average build with a mustache and short dreads with blonde tips. That was suspect number one, was wearing a red sweatshirt with something shiny written on it with dark colored pants. Mr. Bussey described the front passenger as a black male with dark skin, approximately 6'4" in height, having a skinny build with short black hair. Suspect number two. Suspect number two was wearing a black hoodie with dark colored pants. Mr. Bussey described the rear passenger sitting behind the driver as a black male, approximately 5'9" in height, having an average build with a mustache and goatee, as well as having a short afro, which is suspect number three. Suspect number three was wearing a black hoodie and dark colored pants. Mr. Bussey stated the suspect number one had a silver and black handgun, and suspect number two had a black handgun with an extended magazine. They pointed the handguns at himself and Ms. Frazier. Suspect number two stating, "Giving everything you have," Mr. Bussey stated that he handed over his wallet containing $45, a Chase bank card, Ms. Frazier's ID and his driver's license, and his cell phone, which is a black Motorola E-5, to the suspects. Mr. Bussey stated that the suspects then attempted to take the backpack off of Ms. Frazier's back by pulling on it. However, they were unsuccessful by Ms. Frazier not taking the backpack off. Mr. Bussey stated that suspect number one stated that they were just going to have to take this loss and that they better not snitch. All suspects then got into the vehicle and drove away towards Metropolitan Parkway Southwest. Officers gave a description of the suspects over the vehicle radio. Ms. Frazier provided a verbal statement which coincided or was similar to the statement that victim Bussey provided. Officers contacted investigations and informed them of the incident. And the G.I. Bacon, which is an investigator and robbery investigator Maldonado, stated that they had 2 black males detained matching the description of suspect number 1 and suspect number 2 located at 3901 Camilton Road Southwest. Investigator Monaldo stated that he observed the 2 suspects while working on a separate robbery at the location. Investigators took recorded statements from the victims. Zone Supervisor Wolf arrived on scene and was advised of the incident. The officers conducted a show up with the victims, Mr. Bussey and Ms. Frazier of the suspects, and the defendant was identified as one of those. Arrest warrants were issued, and the defendant in this case was arrested.
All right, thank you very much. Ms. Hardy, do you have criminal history information for Mr. Thompson?
Yes, this defendant has 8 arrest cycles in Georgia, a felony conviction in 2009 for criminal damage to property and possession of tools for the commission of a crime. They received first offender status and it was sealed in 2017, and 1 probation violation. Nothing further to report.
Thank you. Mr. Bastian.
Yeah, 2 things. As far as the recommendation is concerned, I think we're doing 3 years and a date in 18 months.
A what in 18, a behavioral incentive date?
Yeah.
Did you, correct?
Yes, Your
Okay.
Honor, that's correct. My apologies.
No problem.
And as far as Mr. Jamarian Thompson is concerned, the facts are complicated. Unfortunately for him, he was found in the vehicle, but everything else doesn't match.
So I'm pretty familiar with Mr. Norris's situation. That's the co-defendant here. So I'm intrigued as to what an alibi would have been, or he's in a car. That neon was pretty distinctive, and there was, in fact, another armed robbery that same night. And I think some of the belongings of someone were found in, and probably Mr. Bussey's stuff was found in it. So folks are pretty clearly implicated. Tell me the angle as to why Mr. Thompson was merely present.
Okay, so the robberies occur. They live in the same neighborhood at the time, at least. Car pulls up and they tell him, listen, can you go up and go get something at the pharmacy with me? He goes there. This is before the police officers come. He comes back around. The cops are there. Bang him in. And he's like, listen, check this. So for his benefit, we tried to do the cell phone records to try to ping it. It pings places, but we don't know what the jury is going to say because it's still not
It's nearby.
It's only like
yeah.
And the other stuff is finding out the car, in the car. So who knows? And of course, the co-defendant is not saying it's not him. Right. So here we are.
Okay. Got it. Mr. Thompson, is there anything you want to add? You don't need to talk more about the facts of the case, but you've been on bond now for a bunch of years and you did just fine on bond. Have you been working or what have you been up to?
I've been working up on the table, but now I'm working on.
He's been working.
Okay. No, but I'm intrigued. You're not going to get more trouble because you were up under the table. Are you now above the table?
Yeah.
All right. Well, it's better to be above the table.
Yeah.
What is going on above the table?
Well, warehouse work.
Cool.
That's all.
Is it through a temp agency or are you full-time?
Through a temp.
Okay. Well, good for you. And you have a stable place to live?
Yes. Yes,
Okay.
sir.
Good. All right. Any questions about anything?
No, sir.
Mr. Thompson, I find there's a factual basis for your plea. This may have been the worst coincidence ever in your life, or maybe you knew what Mr. Norris, the kind of guy he was, and you don't need to respond. I'm just playing out scenarios that a jury would work through, and like, that's too much of a coincidence. He might have thrown you some money to grab something from the pharmacy and you knew what kind of money he had and you were in on it. Who knows? I also find that your plea is knowing and voluntary. No one's forcing you to enter this plea, and you're entering it with your eyes wide open, having had a chance to talk with Mr. Bastian and having had a chance to go over with Mr. Bastian the plea form that has your initials next to all your rights. Did you initial these and then on the fourth page sign the document?
Yes, sir.
And Mr. Bastian, you've signed it as well?
I have, Your Honor.
Great. I will accept this as an offered plea, which is a plea where you're saying, maybe I didn't do everything Ms. Clark said, but I like this offer. I'm going to take it. Is that you?
Yes, sir.
Okay, that's how we'll do it. Mr. Bastian, may my staff sign the indictment on your behalf?
Yes.
And Ms. Clark, can we sign for you?
Yes, Your Honor.
Is it all right if we sign the indictment indicating your guilty plea to count 2?
Yes.
Offered plea to count 2. Yes, great, we'll do that. I'm going to sentence you on count 2 to 3 years of probation. Insofar as there was a gun seized in this case, you're not going to make any claim for it. That'll be forfeited. You will need to stay away from Peg Road. Is that going to be all right? I don't know where you live.
Yes, sir.
You don't need to be near Peg Road? No?
No.
Good. All right. And no contact with Mr. Norris. He's going to be in custody for a while longer. And no contact with these alleged victims. And if you do well on probation in, let me do the math, 25, on March 21st, 2025, probation can say, Mr. Thompson did a great job and we're going to scale this back. Okay?
Okay. Yes, sir.
So that's an incentive to do all the things you need to do. Mr. Bastian, anything else in Mr. Thompson's case?
No, Your Honor.
Ms. Clark?
No, Your Honor.
Ms. Tucson, what information do you need from Mr. Thompson so he can get signed up with probation?
Address and phone number?
3901 Camilton Road,
One second.
Southwest.
Do that one more time.
3901 Campbellton Road.
3901 Campbellton.
Southwest,
Okay.
zip code 30331.
And do you have a phone number, Mr. Thompson?
Yes.
And
47.
it's directly to you?
Yes, ma'am.
Okay, and your number?
470
Mm-hmm.
250
Mm-hmm.
5828.
470-250-5828. Okay, I will call you with further reporting instructions, but an officer I'll call you after that sometime in the next week or two for intake setup, okay?
Yes, ma'am.
Okay.
You're done. I feel like I got to know you. Came to court 700 times. This case is so old. Mr. Bastian, thank you for plugging in with it and helping us close this one out. Thank you, Ms. Clark.
Thank you, Your Honor.
So, Ms. Taylor, are you ready to go?
Yes, Judge.
Ms. Rivers, if we take 2 more pleas and then take a 40-minute, whatever the team needs for a break, are you okay doing 2 more pleas?
Yes, Judge, I'm ready.
Okay, great. Mr. Adams, did you end up connecting with your client?
No, I ain't, he was supposed to be, he's still in line. I'm on now.
He's here in the,
He's not. I called upstairs.
he didn't get brought here. Oh, okay. So let's see if we can get him brought here today. If we can't, I don't mean for you to have to wait around. Had he been here, did you expect this to be a plea?
I believe so. He has a pending case. I think we can go along.
Okay, well, let's get that update from Deputy Gordon. If he can be here soon, I'll ask you to wait. If he can't, we'll do it another day. All right, Ms. Taylor, if you're ready, you and your client should come on up. And if you'll remind me who we're working with here.
Jordan, I think, Judge.
Oh, I meant your client is?
Bria Walker, I'm sorry.
I just need to find it on the calendar. Number 27. All right, Mr. Jordan, you got this one?
Yes.
Okay.
Your Honor, if you.
Oh, Mr. Cody, should we do these together?
We can, Your Honor.
It would be fine.
That'd be much more efficient. Okay. Can we bring Mr. Cody out? Thank you, Mr. Bastian.
You're welcome, Jan.
Great, we'll do two at once.
Yes, brother, I had to plead guilty.
Okay, I'll take that.
It would be awful.
Okay, thank you.
And Your Honor, just for the record, for Ms. Walker, she is pleading to only one count of false statement, and Mr. Cody is only charged with cruelty to children.
In the second. Okay, great. Ms. Taylor, are you okay? Well, I'm gonna let Deputy Gordon figure out who's standing where.
I'm sorry, Judge.
No, you're good.
Okay.
Switch. All right, let's get on the record with positions 26 and 27, 22 SC 183856. We have Mr. Cody out here with his lawyer, Mr. Brown. We have Ms. Walker here with her lawyer, Ms. Taylor. Mr. Cody, Mr. Brown tells me you're prepared to enter an offered plea where you say, in effect, I didn't do everything the state says, but I'm interested in taking the state's offer. Is that a fair statement?
Yes.
Okay. When you answer, you're going to need to answer a little more loudly because through that microphone, your voice must go all the way to the court reporter. So speak up. I'm not asking you to be enthusiastic. I am asking you to be loud. Ms. Walker, my understanding is that you're pleading as well to one count of false statements. Is that correct?
Judge, yes, so that would be under the terms of offer versus North Carolina as well.
Also an offered plea. Is that right, Ms. Walker? Okay, great. And you don't need to speak even louder because the microphone is further from you, but I need you guys to stay standing the way you are. When you are asked questions by Mr. Jordan or me, he's going to start out by saying, Mr. Cody, and he will answer, and then Ms. Walker, and you will answer. Same questions for everyone, but this way we can take it as one plea rather than having to do this twice. If at any point, Mr. Cody, you need to speak privately with Mr. Brown, or you've got questions for me, will you let me know?
Yes, sir.
Good, speak louder. And Ms. Walker, same thing. If at any point you've got any questions or concerns, will you let Ms. Taylor or me know?
Yes, sir.
Sounds good. All right, Mr. Jordan.
Thank you, Your Honor. Mr. Cody and Ms. Walker, can you please raise your right hand? Do you both swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Yes, sir.
Thank you. You may place your hands down. Starting with Mr. Cody, can you please state your true, correct, and legal name for the court, please?
William Cody.
And Ms. Walker, can you please do the same?
Bria Walker.
Ms. Walker, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there a medication that you normally take that you have not been given today?
No, sir.
Mr. Cody, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
Ms. Walker, how old are you and how far have you gone in school?
I'm 31 and I have my GED.
And Mr. Cody, how old are you and how far have you gone in school?
27. I ain't graduate.
So how far did you go in high school?
9th grade.
Mr. Cody, are you able to read, write, and understand the English language?
Yes, sir.
Ms. Walker, are you able to read, write, and understand the English language?
Yes, sir.
Starting with Mr. Cody, do you understand that you have been charged with the offense of cruelty to children in the 2nd degree?
Yes, sir.
And do you understand that the sentencing range for that particular count has a minimum of 1 year in custody and a maximum of 10 years in custody?
Yes, sir.
And Ms. Walker, do you understand that you have been charged with one count of giving a false statement?
Yes, sir.
And do you understand that the sentence range for that particular count is a minimum of 1 year in prison and a maximum of 5 years in prison?
Yes, sir.
Ms. Walker, do you understand that you have the right to plead either guilty or not guilty to that charge? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes, sir.
Mr. Cody, do you understand that you have the right to plead either guilty or not guilty to the charge of cruelty in the 2nd degree? And if you pled not guilty or remain silent, you will receive a jury trial?
Yes, sir.
Mr. Cody, have you had enough time to speak with your attorney, Mr. Joe Brown, about all of the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss the case with your attorney?
No, sir.
Are you satisfied with his services?
Yes, sir.
Mr. Brown, are you satisfied that your client has a full understanding of this proceeding?
I am.
Ms. Walker, have you had enough time to speak with your attorney, is it Beverly Taylor? Ms. Taylor, about all of the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses? Do you need any more time to discuss the case with your attorney? Are you satisfied with her services? And Ms. Taylor, are you satisfied that your client has a full understanding of this proceeding?
Excuse me,
Yes.
Hold on one second. Yes, ma'am, Ms. Rivers.
I did not hear the last two responses from Ms. Walker.
Speak up, Ms. Walker, because you're away from the mic,
Okay.
so the court reporter can hear you.
Okay.
Can you ask those questions again, please?
Yes. And does the court reporter need me to go back to, do you need more time to discuss the case with your attorney?
No, the last two were yes answers.
Okay. Your Honor, just in the interest of time, I'll just go back to if she has had enough time to speak with your attorney.
Yes, sir.
Do you need any more time to discuss the case with your attorney?
No, sir.
Are you satisfied with her services?
Yes, sir.
Ms. Taylor, are you satisfied that your client has a full understanding of this proceeding?
Yes, I just want to be sure that we're on the same page. This is a non-negotiated plea, Judge. Is my understanding from the last calendar that we were reserving the final plea issue, and that Ms. Walker would be able to withdraw her plea if not satisfied with.
That's my recollection.
Yes, thank you, Judge. So she does understand.
Thank you. And Ms. Taylor, do you waive formal reading of the indictment?
We would waive formal reading of, well, I'll tell you what, especially her charge. Let's read her charge out.
John, if you can give me 1 second to pull up the formal language for that charge.
I'll get it.
Thank you, Your Honor. And while.
Because that's the issue here.
Understood. Mr. Brown, do you waive formal reading of the indictment?
Yes, we do.
And do you also waive any and all defects in the indictment, including any with respect to your client's name?
So waive.
Thank you. Your Honor, would you like me to proceed or would you?
No, I've got it right here. So Ms. Walker is charged in count 2 of the indictment with false statements. And the allegation is that on the 4th of July, 2021, Ms. Walker did knowingly and willfully make a false statement to the Atlanta Police Department in the investigation of Bella Grace Walker contracting a sexually transmitted infection, a matter that was within the jurisdiction of the Atlanta Police Department. And specifically, it is alleged that Ms. Walker told the officers that Mr. Cody's test for a sexually transmitted infection came back negative. So I guess I'm going to hear during the factual basis that either Mr. Cody didn't have a test or it came back positive. But the specific alleged false claim is Ms. Walker told the police, hey, Mr. Cody tested negative. That's what you're alleged to have done. Okay.
All right. We would waive any defects for purposes of this plea.
Thank you, Ms. Taylor. Ms. Walker, do you recall having been arrested on the charge of giving false statements?
Yes, sir.
Your Honor, the state is unaware of any outstanding warrants that are related to that charge. Ms. Taylor, do you know of any outstanding warrants that are related to that charge?
No, I do not.
And Mr. Brown, Mr. Cody, do you recall having been arrested on the charge of cruelty to children in the 2nd degree?
One more time.
Do you recall having been arrested for this charge? Cruelty to children.
At some point in this case, you got arrested. The police put handcuffs on you. Do you remember that happening?
Yes.
Okay.
Your Honor, the state is unaware of any outstanding warrants related to that particular charge. Mr. Brown, do you know of any outstanding warrant that is related to that charge?
I do not, and I think the confusion was that he was actually came from another jail and transported here.
Got it. Okay. So it may not have been your typical arrest of the police roll up in a police car, but you got moved from one place to another.
Yes, sir. Mr. Cody, do you understand that you are entering a guilty plea to one count of cruelty to children in the second degree?
Yes, sir.
Has your attorney advised you the minimum and maximum sentence for that charge?
Yes, sir.
Ms. Walker, do you understand that you are entering a guilty plea to one count of giving false statements?
Yes, sir.
Have you been advised the minimum and maximum sentence for that charge?
Yes, sir.
Do you, Ms. Walker, understand that this is a non-negotiated plea or a blind plea and the state will recommend a sentence to the court?
Yes, sir.
Were you made aware of the state's prior offer in this case?
Yes, sir.
In your honor, I believe that when ADA Shapiro had this particular case, the last communicated offer that he gave was 10 to serve 3. I gave an offer, I believe, to Ms. Taylor earlier this week of 5 to serve 1, and that is the recommendation that the state will be presenting today for Ms. Walker's case.
Okay.
And that will be only 2 counts too, because I believe she is charged as a party to a crime to the cruelty to second.
Correct. I mean, she doesn't say party to the crime. She and Mr. Cody are charged together in that.
Understood, Your Honor. And the only special conditions of probation would be that she have no contact with her co-defendant. I do
Okay.
believe that the victim child in this case, I don't believe that the victim child was ever out of Ms. Walker's custody.
Okay.
Do you understand that the court, Ms. Walker, can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on that charge?
Yes, sir.
Do you understand that if you do not accept the court sentence, as you still have your final plea rights that are instilled, you may withdraw your plea?
Yes, sir.
Mr. Cody, do you understand that this is a non-negotiated or blind plea and the state will recommend a sentence to the court?
Yes, sir.
Were you made aware of the state's most prior offer in this case?
Yes, sir.
And Your Honor, the offer for this particular, for Mr. Cody has remained the same. It is 10 to serve 3 with the balance being probated. The special conditions of probation that Mr. Cody have no further contact with his co-defendant and also no contact with the victim child.
Okay.
Mr. Cody, do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on that charge?
Yes, sir. Yeah.
Ms. Walker, do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Mr. Cody, do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Ms. Walker, do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, sir.
And Ms. Taylor, I believe that
We will be asking for first offender treatment.
understood, and I'll go through that part of the plea litany as well. Mr. Cody, do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, sir.
Mr. Cody, do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Could you ask that again, please?
Absolutely. Mr. Cody, do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
What that means is in the future, if you got in trouble for some other case, a prosecutor could say, hey, judge, I think you should sentence Mr. Cody even more because look what he did in Fulton back in 2023. Understand that?
Yes, sir.
Okay.
Mr. Cody, are you currently on probation or parole?
No, sir.
Ms. Walker, are you currently on probation or parole?
No, sir.
Ms. Walker, are you a United States citizen?
Yes, sir.
Mr. Cody, are you a United States citizen?
Sir.
Mr. Cody, do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, sir.
Do you understand that your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, or your ability to obtain employment?
Yes, sir.
Ms. Walker, do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, sir.
Mr. Cody, do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, sir.
And Ms. Walker, do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm during the commission of a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, sir.
And Ms. Walker, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, sir.
Have you ever pled guilty or nolo contendere, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, sir.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No, sir.
Has your lawyer explained the First Offender Act to you?
Yes, sir.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for the charge in this indictment?
Yes, sir.
Mr. Cody, do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
Ms. Walker, do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
Ms. Walker, do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
Mr. Cody, do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
Ms. Walker, do you understand that by pleading guilty, you are giving up the following rights, which I will now list off? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Mr. Cody, do you understand that by pleading guilty, you were giving up the following rights, which I will now list off? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial. Ms. Walker, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea under North Carolina v. Alford?
No, sir.
Mr. Cody, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea under North Carolina v. Alford?
No, sir.
Mr. Cody, is it your decision to waive these rights? My apologies, I understand that you're both entering that plea. Are you pleading guilty under North Carolina v. Alford, Mr. Cody, because you have decided that it is in your best interest to do so?
Yes, sir.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, sir.
Ms. Walker, are you pleading guilty under North Carolina v. Alford because you have decided that it is in your best interest to do so?
Yes, sir.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, sir.
Ms. Walker, how do you plead to one count of giving a false statement in indictment number 22 SC 183856?
Guilty unto offer.
Thank you. Is this guilty plea under North Carolina v. Alford freely and voluntarily given with the full knowledge of the charge against you?
Yes, sir.
Do you understand that you only have 30 days in which to appeal your conviction based on today?
Yes, sir.
Do you understand that since this is a felony charge, you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
And Mr. Cody, how do you plead to the sole count of cruelty to children in the second degree in indictment number 22 SC 183856?
Guilty under Alford. Under Alford.
Thank you.
Under
We got it, under Alford. It's a best interest plea.
Is this understood? Thank you. Is this guilty plea under North Carolina v. Alford freely and voluntarily given with the full knowledge of the charge against you?
Yes, sir.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes, sir.
Do you understand that since you are pleading to a felony, you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
And Your Honor, for a factual basis for both of these co-defendants, on July 16th of 2021, an officer from the Atlanta Police Department was dispatched to 1405 Clifton Road Northeast, which is the, I hear it pronounced as Eggleston or Eagleston.
Eggleston.
Once again, I'm not from Atlanta, so I do apologize. Hospital in reference to a possible sexual assault. Upon arrival, he made contact with the mother, the co-defendant, Ms. Walker. Ms. Walker advised about 2 weeks ago, the grandmother was washing up the victim, whom is the daughter of Ms. Walker, and discovered discharge leaking from her vaginal area. Ms. Walker advised that her child never made an outcry and acted completely normal during that time. Ms. Walker had the baby get checked out and found out that the child had gonorrhea.
How old would the child have been at this time?
I believe the child would have been, Your Honor, I do have the date of birth. This was, she would have been 3 years old at this time, Your Honor. Her date of birth is January 20th of 2018, and this is a 2021 incident date. Ms. Walker was advised by doctors that the child only could have gotten that sexually transmitted disease from sexual contact with the penis of an individual that already had that STD. Ms. Walker advised that she was unsure of whom might have sexually assaulted her daughter and where it happened. She did advise that her daughter is surrounded by family, and the only males that have ever been around her were her brother and her boyfriend of 2 years, the co-defendant, Mr. Cody. Ms. Walker advised that they have a small circle of a family and will proceed to get themselves checked out as well as her boyfriend. Mr. Cody was tested. His results did come back positive for the same STD. But Your Honor, and I'll be able to provide a timeline here essentially to what happened. Your Honor, on August—
How old was the brother? You said there were basically two males who had regular close contact with the little girl. One is the defendant, who, meaning Mr. Cody, who was Ms. Walker's boyfriend, and it sounds like Ms. Walker had a son. How old was your son at the time? When your daughter was 3, how old was he?
I have 2. My oldest was 13, and my youngest son was 10, so he was 7.
7. So the 7 and the 13, was he, your oldest is 13 now, or he's 16 now?
He's 16 now.
All right, so 13 and 7, were they routinely around your daughter also?
Yes.
Okay.
So, Your Honor, the timeline here is that on August 5th of 2021, while the co-defendant, Mr. Cody, was in custody in the DeKalb jail, there was a jail call that was recorded in which Ms. Walker and Mr. Cody discussed that a detective was trying to get the results of the STD test. During that call, Ms. Walker stated the lady called and asked for the first test results we took. Mr. Cody responded, "Just tell them folks you can't access that shit no more." Ms. Walker replied, "I don't think I'm gonna be able to do that." Mr. Cody said, "I don't care. I ain't did shit. I don't give a fuck, bro." He then said, "Tell that bitch you can't access that shit no more. Tell her that." Ms. Walker said, "I ain't fixing to do that. It is what it is if I get in trouble." Mr. Cody then says, "They just can't access our shit like that. I told you from the beginning, I don't like this." Ms. Walker says, "I know we already talked about this already." Mr. Cody then said, "Can you really log back into the account?" Ms. Walker says, "I think that they can pull it too." Mr. Cody said, "What y'all trying to access my shit for?" Ms. Walker then replied, "I feel like she already knows because she told me the place of the lab. I didn't tell her the lab. I only told her that we ordered it online." Your Honor, then there was a recorded phone call on August 6th of 2021 in which Ms. Walker said, "I have the results, but before I send them, I'm just gonna tell you, the first one, I never saw it, but it was positive, she told me. My test was negative at first, but when he got his test, we had to go back to the hospital because his test was not ready. He told me to give the test result because he didn't have anything to hide. I didn't want y'all to feel like just because you saw this, this is what happened. It was all on me as far as why I didn't give it. I'm going to send it, and if I get in trouble, I'll take the fall for it because I should have given it to y'all. Honestly, didn't want y'all to end the investigation because if he had it, he had to do it. I wanted a full investigation to make sure it is the right person. I am wrong for not giving it to you, but I'm wrong for not giving it to you, but I am going to give it to you. I'm not going to lie about it." Your Honor, then there was a final.
This second call confuses me. That's Ms. Walker talking to whom?
This is talking to the detective.
Okay, this not, the first call is Cody and Walker.
Yes,
I gathered that. So the second one is Walker and detective.
Correct.
Okay.
Then on August 10th, there was a statement in which Ms. Walker said, Ms. Walker said that she hid her boyfriend's positive gonorrhea results because she did not want anyone to think that her boyfriend had given her daughter an STD. Ms. Walker stated that she did not know why Mr. Cody asked her to lie to law enforcement about not having access to the STD test results. Ms. Walker told Mr. Cody that she was not going to hide anything else and that she knows that she was wrong for hiding the results. Ms. Walker stated that she does not believe that her boyfriend would do anything like that and did not understand how she would not have gonorrhea also. Ms. Walker stated that she had been having sex with her boyfriend for almost 2 years and that she went to Atlanta Medical Emergency Room and told the doctor her boyfriend had tested positive for gonorrhea and they gave her a shot. Your Honor, the child was brought to a forensic interview and did not disclose that any sexual abuse happened. Your Honor, that concludes the factual basis for this particular case. I do believe that the state's recommendations are appropriate in both situations. It is an extremely unfortunate situation that we don't know exactly how the victim contracted this sexually transmitted disease, but it is a very alarming situation. We believe that the jail call on August 5th shows I believe at least for Ms. Walker's portion, that she was in a really bad situation given that she's still dealing with the fallout of her daughter being so young and having a sexually transmitted disease. But at least for Mr. Cody's part, that there was a deliberate effort to try to hide the results or at least delay the investigation. So we believe that the 10 to serve 3 for Mr. Cody is appropriate. And we understand that Ms. Walker does not have a large criminal history, but we do think that the statement that was false that was given to the police is alarming, given that her daughter was the victim in this situation.
Okay, thank you. Let me get a little more information and then I'll hear from the lawyers for the defendants. Ms. Hardy, do you have any criminal history information? Let's start with Mr. Cody.
Mr. Cody has 9 arrest cycles in Georgia, felony conviction in 2016 for possession of cocaine, in 2017 for burglary and possession of a firearm by a convicted felon, and 3 probation violations. And that's all that I have for Mr. Cody.
Okay, and how about Ms. Walker?
Ms. Walker has 3 arrest cycles in Georgia, no felony convictions, no probation violations or FTAs.
What's her most recent arrest?
Bear with me one moment, I'll pull that back up. Okay, before this, it was a 2018 arrest out of East Point for theft by shoplifting.
So the most recent is the arrest in this situation.
Yes, Your Honor.
Thank you so much. Ms. Tucson, is Mr. Cody on active probation now?
No, Judge, not on active probation.
Okay, thank you. Mr. Brown, let's start with you on behalf of Mr. Cody.
Yes, Your Honor. Mr. Cody had, as you heard in the Cobb County case, I believe it was a burglary case, and he was on, was it parole or probation? Probation. While on probation, he called another DeKalb County case that by taking it, that's by receiving it, and which resulted in a violation of probation warrant. When he submitted to the buccal swab in this case, and he did so voluntarily, APD detained him because of the violation of probation warrant. And he served 271 days in DeKalb County before being brought over to Fulton.
All right.
And
then he's done 400 plus. I mean, we're getting close to 500 here.
477 days in Fulton.
Okay.
As of today, for a total of 748 days. And while here in Fulton, while at the FCJ, he's been stabbed over 20 times. He's lifted up his shirt, showed me bandages in front and back. We're asking, I just believe that as far as punishment goes, he's been punished enough. We're asking for time served on this charge. And it's kind of a mystery how, there's no allegations that my client had any type of sexual misconduct with this child, this baby. Otherwise, I imagine he would have been charged with child molestation also. This is just a mystery how this baby got gonorrhea, but I do believe that that the offer plea is in my client's best interest. He's got family here today. He's got his grandmother, if you can stand, please. The mother of his child is here, and his brother, and they're all supporting him. If you need to hear from any of them, you don't need to.
No, I mean, the fact that they're here and they've stayed here all morning on into the afternoon says they're clearly behind their son, father of their child, brother, and that they're continuing to be there for him.
Absolutely. So I'll sit down. So I just feel like time served would be an appropriate sentence for Mr. Cody.
Okay, appreciate it.
Also, I just wanted to mention, he worked at the airport loading carts that go on the planes, and he also worked at CNS Wholesale Meats. He believes that job will be available if he were to be released.
Okay, that's a long time they hold that job open for you. Sir? Through you? Is CNS is your company? Okay. Got it. Okay. So for the record, because my guess is the court reporter couldn't hear you, Mr. Cody's brother is willing to hire Mr. Cody through his trucking company. Do you have a CDL, Mr. Cody? Oh, his brother will help him get one. Look at that. Your brother is standing behind you. Let's pivot to Ms. Taylor. What do you want to tell me, Ms. Taylor, about Ms. Walker? I'm not so sure why it's an offered plea. I understand why Mr. Cody's plea is an offered plea for the very reason Mr. Brown said. That little girl got sick. The doctor made it pretty clear the only way she could get sick. And if we assume that it's not your client's little boys, then Mr. Cody is the most likely suspect, but there's not direct proof. It's a circumstantial case. Your client is pleading only to having lied to the police, and I'm not seeing I see the stress involved and whatnot. I'm not seeing I don't know what you're talking about. I had nothing to do with this.
Yeah, Judge, it wasn't that. I wasn't, Mr. Jordan, the way he explained it in here today was not how I saw it in the discovery.
Got it.
And how in my discussions with Ms. Walker, I actually recently got the tape from Mr. Shapiro of all the statements, the jail calls and the statements to the police. And then reviewing those, I still was trying to put it together, what they were saying as far as the false statements were concerned. And I'm hearing, like you said, a little clearer from Mr. Jordan today. Even I actually been talking with Mr. Jordan about the case. It wasn't outlined to me like he outlined it today, which is much, much clearer.
Yeah.
It's part of the recordings that I got were not intelligible or not clearly audible, so I couldn't understand them. I did understand obviously some of the jail call, a lot of that was not audible. So I understand the court's position about because it appears from what is now being said that Ms. Walker was admitting that she kind of misled the police investigator based on some communication, some stress from Mr. Cody from the jail call about not revealing anything. What she had indicated to me was about her access to his results was not, she initially did not have access to his results. He had to give her that access by giving her his access code. But once she got that, so I didn't know the timeline between what she had said to them versus when she actually had access herself to the results. He had told her that had tested negative. At first, it was supposed to be inconclusive or something, then had tested negative, and then we told her the truth that it was positive. I don't want him to know, but bottom line, she did, as the court sees, cooperate with the police.
Eventually, yes.
Eventually, with the police and with DFACS, totally in this investigation. She has 4 children. The oldest is 16 years old. As you heard, Ms. Walker is 31 years old. So this would mean that she had her first child at 15 years old. That child is in the custody of her mother. For obvious reasons. I mean, when he was born, she was a 15-year-old girl, and the mother got guardianship or custody of him. And he stays with her, but obviously visits with Ms. Walker and the other children. She has 3 other children, 10 years old, 8 years old, and Bella, in this case, is now 5 years old. Those 3 children have always been in the custody of Ms. Walker. DFACS never took them away. They never, during this case, during this investigation, never took the children away from Ms. Walker. They have always been in her custody, other than when she was in jail, waiting to get bond. I believe she spent about 3 months in jail on this case, waiting to get bond. The grandmother of 2 of the children was actually living with Ms. Walker at the time. She is not able to care fully for these children. But she's obviously good with babysitting or whatever. So she has that network. Her mother is actually working today, is not able to be here with her, but certainly has indicated that the whole family is in support of her. Ms. Walker is, told me at the time and that her daughter, 3 years old, was a very smart little girl, but not one of those kids that doesn't understand things. And that she took her to the doctor. At first they said it was some type of urinary tract infection. Then it came back and says, no, it's this sexually transmitted disease. And of course she was shocked. She says she had never even left her kids alone with Mr. Cody. Mr. Cody was obviously around the children. He didn't live with her. He spent the night on occasion, but didn't live with her.
Is he the father of any of Ms. Walker's kids?
No, Judge. Always treated all of her children fine. In the forensic interview, my understanding from my interpretation of it, that Bella did not indicate in any way that there had been any sexual contact with anybody. I don't believe that there was any indication physically that she had been sexually assaulted, but some kind of way she got, this disease. But at any rate, Judge, it was obviously a very, very stressful situation on Ms. Walker. Her concern is that her children are her life. And that's always been her situation. She was employed at the time with the company that I think it was Gates that provides the food for the airlines and put the food on the planes, et cetera. After she got arrested in this case, she lost that job. She did become employed again, matter of fact, with MARTA, driving the short bus, the mobility bus for the people that have disabilities, et cetera, because she doesn't have a CDL. And she did that until she had an accident. And because I guess she was still in the probationary period, she got terminated from that. She's now working with Walmart in the warehouse. She's obviously looking for other employment, or say she wants to kind of see how things progress with Walmart and how she can advance in the Walmart hierarchy, the Walmart system. But she's the only caretaker for her 3 children, these 3 kids, 10, 8, and 5 years old. Bella is now in kindergarten. She's doing fine. And just an aside, talking about how smart she was, Bella had been around other people. It's just that they talk about a small circle. That was the small circle was, hey, just her family, just her kids. But bottom line, she had been around. The mother had babysitted her. Other family members had been at the mom's house. Bella had a godmother. So bottom line, again, we don't know how she contracted this. Obviously, I know how it looks. Mr. Cody tested positive, but she never made any outcry that or saw anything in that light. She was not trying to not protect her child or her children. Like I said, this has been very, very stressful for her, that it appears that she was maybe trying to cover up for Mr. Cody, because that was not the situation. And as you heard the statements that she made, I'm not covering up for you. I'm going to be, I'll tell the truth about what I know about your test results. And she did that. I've had many cases of people making false statements and people that had no felony convictions, and I understand the state's recommendation, but I just think it's more punitive here. I think not only punitive to her, but it's going to punish her, these 3 little kids that I remember. I've had this case from the beginning. In other words, I'm the one that did the bond hearing for Miss Walker, and I can remember visiting her out in Union City and how she was just crying and talking about how her children were crying every time she talked to them on the phone, which was daily, wanting her back home. Again, they were never taken from her. They've been with her. And she is their only caretaker. They don't have any any support from the fathers. So she to go to jail for a year or any period of time obviously is going to impact them, I think, more than her. And I believe that obviously this has been something very painful. She said since this incident, since this time that she has kept very, very close eye and contact on her kids. It was trying to visit with the cousin. Bella even says, I don't want to go there because they're mean. And she said this at 3 years old about visiting with the cousins. So this that's why when she told me that Bella was smart, that she could talk, that she was understood things, that's why I was puzzling to her why when I explained to her when they do these forensic interviews, these people are professionals and they know how to get information out of children.
Unless they're really scared.
Yeah,
Ms. Walker,
So
how many days a week do you work?
I work Monday through Friday.
Monday through Friday? So Saturday, Sunday you have off? Okay, and this is the job that's at the Walmart warehouse?
Yes.
How long have you been there?
I just started this job 2 weeks.
2 weeks ago. What were you doing before that?
I was at another, being since this case, it's hard for me to get jobs, so I just been with temp services.
Got it. So you're bouncing where you can bounce through temp agencies?
Yes.
Okay.
Other than the martyr.
Right, which ended with a crash. Okay. Mr. Cody, I find there's a factual basis for your plea. I understand that it is an offered plea. You have a defense at trial, but you also run a big risk going to trial. So I understand why you're interested in entering an offered plea. I also find that your plea is knowing and voluntary. Voluntary means no one's forced you to enter this plea, and knowing means you've understood the things we've been talking about. Do you have any questions so far?
No, sir.
Okay. Ms. Walker, I find there's a factual basis for your plea. I'm not inclined to take an offered plea now that I've heard a little bit more about the conversations you had with law enforcement. But again, you're only pleading to the false statements piece. You're not pleading to the cruelty to children. Are you comfortable going forward with a non-offered plea?
Yes, sir.
Okay. I will treat you as a first offender. You qualify for that. I think it's appropriate. That is mostly a benefit. It carries a risk. If you get in trouble while you are under sentence, not only would you have your new situation, but I could revoke your first offender status and resentence you without a trial. There'd be a hearing. You'd have a lawyer with you. Ms. Taylor would help you, but it's a different standard of proof and there's no jury or anything. So you need to be pretty comfortable that over the next few years, you're not going to be getting in trouble again. Do you feel like that's a safe bet for you?
Yes, sir.
Okay, then I'll sentence you as a first offender. I am sentencing both Mr. Cody and Ms. Walker under the Probation Options Management Act, which means simply when you two are on probation, you're both going to have probation. If you have technical violations, you test positive for something, not gonorrhea, but marijuana, or you miss a meeting, you and probation will work through that. I don't need to get in the middle of that. If you get arrested again, that will come back to me as a significant probation violation. Mr. Brown, do you authorize my staff to sign the indictment on behalf of you?
I do.
And Ms. Taylor, can we sign on behalf of you?
Yes, Judge.
And Mr. Jordan?
Yes, Your Honor. And I have something very brief, if Your Honor doesn't mind.
I don't mind, but let me get through the signature piece first.
Yes,
Mr. Cody, is it okay if someone on my staff puts an electronic signature on your behalf indicating your offered plea to this case? Rather than you physically signing it, we just like when we put Mr. Brown's signature on mine, or if we put your signature on there.
Yes, sir.
Yeah. Ms. Walker, can we sign for you?
Yes, sir.
Mr. Jordan?
Yes, Your Honor. And Your Honor, I just wanted to apologize to Ms. Taylor. I know the last time that we spoke, we mainly talked about the jail call. I am fairly new to the caseload in here. I did not see until this morning that the particular false statement really derives from the August 10th conversation, not so much the jail call. The jail call itself is very contextual only if you know the details of what comes later. So I
Okay.
do apologize, Ms. Taylor.
I think Ms. Taylor has been very gracious in adapting to the evidence as it has unfolded, and I think we've cleared up the hiccup. I didn't, based on your presentation, understand why it's an offered plea. It's not going to change your sentence at all. I just want you to be honest, and it sounds like you're being honest. Ms. Walker, I am sentencing you to 5 years to serve 1 month with a balance on probation. Special condition of probation number 1 is no contact with Mr. Cody. Special condition number 2 is that you're going to serve 6 weekends in jail. You will turn yourself into the Fulton County Jail by 5 p.m. When time do you get off work?
7 in the morning.
Oh, so when you say you work Friday,
I get off Saturday morning at 7, so I can be there by 5.
you get off 7 in the morning
On Saturday morning.
on Saturday. So you go to work at what time? 11 p.m. Friday? Okay, so then what I'll need you to do is be to the jail by noon on Saturday. You'll be released by noon on Monday. That's 2 days. So that's not going to interfere with your job because you need to report for work at 11 on Monday, right? 11 p.m. So you need to be to the jail by noon on Saturday. You'll get out by noon on Monday. We won't start with this weekend. We'll start with the weekend of September 30th. And it's 6 consecutive weekends. Do not miss a weekend. If you miss a weekend, that's going to be a violation of your probation. I'll probably just say, I'm going to give you 30 days. That's going to mess up your job. More importantly, that's 30 days where you're not there to help out with your kids. And I know they need you around. I know you want to be around. But that's going to be your sentence. And you'll get credit. You've already served more than a month. You served 49 days. So you're not going back in for a month. You did that month. So it's 5 years to serve 1 month, balance probated. But as part of your probation, you're doing those 6 weekends in jail, starting the weekend of the 30th. If for some reason you can't make it, your kid is sick, your leg is broken, you blow up Ms. Taylor's phone because she needs to let me know. If I get a report from probation that you didn't show up, even if you had a good reason, you need to let us know in advance. Okay, but hopefully you knock those 6 out and then it's just plain old probation. Any questions about that?
No, sir.
Did I miss any conditions, Mr. Jordan?
No, Your
All right, Mr. Cody.
Judge, that is, you said on the First Offender Act.
Yes.
And Judge, I would ask if I could submit an order for record restriction. As you've heard, she's obviously had having difficulties trying to find.
Just make sure you run that proposed order by Mr. Jordan so I know if he has any objections.
All right, Judge. Thank
Mr.
you.
Cody.
He's indicating he does.
No objection.
All right. Well, you should read it before you don't object to it.
Right.
All right. Mr. Cody, I'm sentencing you on count 1 to a term of 8 years to serve 2 years with the balance on probation. You will receive credit for all the time that you served. And your special conditions are number 1, no contact with Ms. Walker, and 2, no contact with any of her children. So when you get out, you're going to be heading in a different direction. It sounds like there are people here who are happy to fill your hours, but Ms. Walker isn't one of those people anymore. No, nor are her children. I think we've covered everything. Mr. Brown, anything else on behalf of Mr. Cody?
No, Your Honor.
All right, thank you for your service on his behalf. Ms. Taylor, anything more in connection with Ms. Walker's case?
No, Judge.
Mr. Jordan?
No, Your Honor.
All right, both of you need to stay right here. Ms. Tucson, what information do you need? Let's start with Ms. Walker. And if you could move Ms. Walker a little closer to the microphone. What information do you need from Ms. Walker for probation?
Phone number and address for both.
Let's start with you, Ms. Walker.
470-331-1274. And my address is 201 Maury, Moury Avenue, apartment 202, Atlanta, Georgia 30315.
Okay, I'm going to read that back to you. Phone number 470-331-1274. And your address is 201 Maury Avenue, Moury, number 202-30315.
Yes, ma'am.
Okay. Go ahead, Judge.
I was going to say, you want Mr. Cody's info now, or did you have more for Ms. Walker?
Well, if that's the unverifiable address, I will reach out to you, Ms. Walker, to confirm that, and you will be contacted by probation within about 10 business days for the initial intake, okay?
Okay.
All right, you want to talk with Mr. Cody?
Yes, Mr. Cody,
Yes.
do you have an address and phone number that I can put on file so we can contact you?
I don't have no phone number right now, but I got an address.
So let's start with address, and then we're going to get a couple phone numbers from your fan base back there, okay? So you give address.
658 Quillen Avenue, Quillian, Decatur, Georgia, 332.
Whose house is that?
My uncle.
Your uncle? Okay.
Okay, and then could I have your uncle's phone number?
Yes.
Yes, ma'am, if you'll say it real loud.
It is. Oh, my Lord.
Pressure. We're getting it.
470-564-0501.
Did you hear that, Ms. Tucson?
470-564-0501.
Yes.
And that's the phone number for the uncle who has the house in Decatur where Mr. Cody will be staying.
Yes.
Okay.
What is his name?
Demetrius Mooney.
Demetrius Moody.
Okay, and do you know where the probation office is in for DeKalb County?
Yes. Well, no.
It's in Conyers.
I don't know. I know it changed though.
Yeah, if he does not know where it is.
You want me to call Mr. Moody and give him that information?
Yes, please.
Okay, yeah, it is in Conyers for DeKalb County.
All right.
Your Honor, if I may, I just want to clarify, the 271 days in the cab, is that going to count towards this?
TBD. I don't get to make that decision. I don't know. He'll certainly get every single day he's been here. And there is a good argument to be made that the DeKalb day should be there as well. But that's a DOC decision and not a MCB decision.
Yes, Your Honor.
Okay. All right. Thank you, everyone.
Thank you. That's my only case, may I please?
You may, and Ms. Taylor, you're free to go. Mr. Adams, we'd like to take your client's plea tomorrow. If you don't mind going around to talk to Ms. Nelson, to talk to her about your schedule. He's not here. And by the time they get him here, it would be late. And I got a bunch of other pleas to take. So I'm wondering what your schedule is like tomorrow. That's what we're talking about, tomorrow morning. So if you don't mind, just go around, buzz in. Ms. Nelson will give you a time tomorrow and we'll get your client produced, okay?
Okay, thank you.
Ms. Wood, I think one of your clients needs to go. He can go as long as we can do a Zoom plea later. Is that Price?
Yes.
Okay. All right. So if you'll manage him, make sure you've got super good phone numbers for him or whatever. I don't want there to be, we can't find him at 3 today or whenever it is.
Yes, Judge, and I do have one other client who needs to leave, Mr. Rouse.
Okay. I think that is that the one that's PTI?
Yes, Judge.
Okay. Yeah, and then she bounced it back because she said there are mystery yellow dates on it.
I emailed her back. I don't know if she saw it yet. I've never done a PCI for you before, so I didn't know if you wanted the dates for status and all that, so they can be either.
Okay, I can modify those. Okay, if Mr. Rouse knows what the conditions are, he's good to go. All right.
Thank you, Judge.
I need to give everyone a break now. We are going to reconvene at 1:45 for whatever else we've got. But we're going to shut down right now so people can take a breather, except you guys. I'll deal with this.
Yes, sir.
Horton, I got your stuff. I don't know. I looked through yours. There's a little bit more, but everyone else, feel free to take a break. Which one is your case?
Position 4 and 5, Raheem Conley.
Okay. Oh, this is the one where we're doing both you, Olaloye, and Wood, which it's the tag team. So why don't we do that first when we get back?
That's fine, Judge.
1:45. Sorry to keep you sticking around.
Thank you.
All right. Okay. So you all can be at ease. I'm gonna mute the microphone, and I'll work through. I don't know why these didn't go to McAfee.
Yes, sir.
Yeah.
I think Judge McAfee had something, some type of meeting.
Good afternoon, everyone. Ms. Rivers, you ready to get us back on the record in a moment?
Yes, Judge, I am.
Great. Hope you had a good break.
Thank you.
I think what we were going to do next, if I remembered correctly, was Mr. Conley, so that we could get one of his lawyers out of here. And then I'm happy to take direction to get birthday dad or birthday lawyer out of here, or however you want to do it, or based who's been waiting in the courtroom now. The folks who are in lockup aren't going anywhere right away anyway, so we could take care of Mr. Rosario and others. But let's do Mr. Conley first.
And Your Honor, I'll be taking the rest of this evening.
Look at you, letting him go be with the big kid.
Judge, do you want both of us up there? I think
We can have Mr. Olaloye up there, and then you can chime in from council table for your piece,
Thank you.
if that works for you.
That's fine.
Yes, sir.
All right, Mr. Conley, how are you?
Hey, how you doing?
I'm all right. My question was, how are you?
I'm not so good, right?
Okay. Are you good enough that we can take pleas in your cases?
Yes.
All right, you've got two cases on the trial calendar, positions 4 and 5. One charges you with aggravated assault and having a gun, and the other charges you with criminal damage to property. Mr. Olaloye represents you on the aggravated assault case. Ms. Wood represents you on the criminal damage to property case. And they both told me that you're prepared to go forward with pleas. Is that correct?
Yes.
Okay. We'll do them together. I'm going to have Mr. Olaloye serve sort of as main counsel for you. Your lawyers are equal and they're equally skilled, but he's standing right there next to you. I'll have Ms. Wood chime in whenever there's something specific to your second case about criminal damage to property. Okay?
Yes, sir.
If you at any point need to talk with either or both of your lawyers, let me know and we can get you back into a room where you can speak privately, or it may just be a procedural question. You can ask me, but I need you to speak up. I can't read your mind. So if there's something bugging you, you need to let the lawyers or me know. Will you do that?
Yes, sir.
Great. Mr. Peoples is going to put you under oath and we will be on our way.
So I swear the testimony you'll give in the proceedings before you today will be the truth, the whole truth, and nothing but the truth.
Yes.
Thank you. You can lower your hand. Please state your true, correct, and legal name.
Raheem J. Conley.
Can you spell it for the record?
Raheem. Spell my whole name.
The last name also. Yeah.
Oh, DRECONLEY.
Thank you. Are you at this time taking or under the influence of any drugs, medication, or alcohol?
No.
Is there a medication that you normally take that you have not been given today?
No.
How old are you?
30.
What is the highest level of education that you've completed?
9th grade.
You have your GED?
No.
Are you able to read, write, and fully understand the English language?
I would say some things.
If there's anything we talk about that you don't understand, let me know. I don't think, other than talking with Mr. Olaloye and Ms. Wood, that you've had to read a whole lot. But if there's anything that you're not picking up on, just let me know.
Okay.
You understand that you're charged with the following offenses in 21 SC 178070. Count 1, aggravated assault with a sentence range of 1 to 20 years. Count 2, possession of a firearm during the commission of a felony, which carries a sentence range of 5 years to run consecutively. And count 3, possession of a firearm by a convicted felon, which carries a sentence range of 1 to 5 years. And in 22 SC 181526, charged with 1 count of criminal damage to property in the second degree with a sentence range of 1 to 5 years. You understand that?
Yes.
You understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
You understand that if you plead not guilty or remain silent and enter no plea at all, that you may receive a jury trial?
Yes.
Have you had enough time to speak with your attorneys about all the facts and circumstances known to you regarding the charges in both of these indictments, including any potential defenses?
Yes.
Do you need any more time to discuss this case with your attorneys?
Not my
I'm not following you.
not my aggravated assault, but
You want to talk with Ms. Wood a little bit more about the criminal damage?
I just want to know, like, okay, so there was a credible video of them saying that I didn't do the felony criminal damage. I'm just trying to see when is this gonna get.
When you say of them saying, who would the them be?
Whoever the machine's supposed to belong to, Mr. Ali.
Okay, I don't know any of the facts of the case. You're saying that someone, I'll learn about the case today. I don't research your case in advance because then I might learn something that the lawyers haven't talked to me about. But at some point, Mr. Peoples is going to tell me a little bit about the criminal damage to property. You're saying that the guy who owned the machine made a video saying, hey, it wasn't Mr. Conley?
Yes.
Where would that be?
It's on file.
What does on file mean?
Where they have the video. My attorney had the video. Ms. Wood had the video. I guess the DA had the video too. But
so why don't we do this? I'd be very interested to hear what Mr. Peoples has to say about that, and Ms. Wood. We're not there yet. At a certain point in this conversation, we'll have a discussion about the evidence that the state has. And if the state also has a video of Mr. Ali, whoever he is, saying Mr. Conley didn't do it, they'll need to help me understand why they think you did do it. Because I have to find that there's a factual basis for your plea. Okay?
Okay.
So hold that thought and we'll discuss it. But the question before you was, do you need more time to speak with Ms. Wood about the criminal damage to property case?
No.
Are you satisfied with their services?
Yes.
Counsels, do you waive formal reading of the indictments?
I do.
So if,
Do you waive any and all defects in the indictments, including any with respect to your client's name?
I do waive.
Ms. Wood?
we do.
You understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense to the court would be a sentence of, Your Honor, we would ask for a global sentence of 10 years to serve 1, the balance probated, a weapons forfeiture, a stay away from the victim in the indictment ending in 070, named.
Jonathan Williams?
That's correct, Your Honor. And a stay away from the location in indictment ending in 526, 3221 Martin Luther King Jr. Drive.
It's where the Quick Mart is?
Correct, Your Honor.
Okay.
You understand, however, that the court does not have to accept that recommendation, but the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other.
Yes.
You understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts.
Yes.
You understand that if you are placed on probation of any kind, that you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence.
Yes.
You understand that you are not allowed to possess nor use a firearm while on probation.
Yes.
Are you a citizen of the United States?
Yes.
You understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty.
Yes.
There's certain rights that you give up when you enter a plea of guilty, which include the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney in a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. You understand all these rights?
Yes.
Has anyone used any force, threats, or promises which has caused you to enter this guilty plea against your will?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
You said what?
Is it your decision to waive all of the rights that I just listed because you are guilty?
Yes.
This guilty plea freely and voluntarily given with full knowledge of the charges against you.
Yes.
You understand that you may have only a limited right to appeal this guilty plea conviction.
Yes.
You understand that unless counsel is substituted or permitted to withdraw, the defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later.
Yes, so I have 30 days to withdraw my plea.
It's not quite like that. You'd have, why don't you repeat what you said?
You understand that unless counsel is substituted or permitted to withdraw, that defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later.
I don't understand what you're saying.
So unless you get a different lawyer, and I don't think you're planning on hiring a different lawyer, we're not going to appoint a different lawyer. Mr. Olaloye is going to continue to represent you on the shooting case and Ms. Wood on the video poker case for the next 30 days, which is the window you would have to file any type of appeal or challenge to your plea and sentence.
Okay.
The question makes it sound more complicated than that, but that's basically, you shouldn't be filing things yourself. You have these two lawyers representing you for the next 30 days for purposes of, hey, I want to challenge this, I want to do that. Okay?
Okay.
You understand that you have only 12 months from today for a misdemeanor, 4 years for felonies to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes.
You understand that you have until the last day of the current term of court to file a motion to withdraw your guilty plea.
Yes.
You understand that any of the filings that we've just discussed must be filed by your counsel unless you're representing yourself.
Yes.
Your Honor, if this had proceeded to trial, the state would have expected to prove beyond a reasonable doubt that in indictment ending in 070 on
October 19th, 2020?
Correct, Your Honor. Law enforcement responded to 3599 MLK Junior Drive in Fulton County. They were dispatched to a person that was shot inside of their vehicle. The individual identified as, the victim identified as Mr. Jonathan, common spelling, Williams, met with officers and said that he was shot at by a male that he knows. He was leaving the parking lot of the Quick Mart at 3221 Martin Luther King Jr. Drive when a male that he knows as Rhodey fired several shots at him from a handgun. Mr. Williams advised that the suspect was upset with him about an incident between them that occurred at the same location during the summer. Officers were able to retrieve video from the store showing a male dressed in all black exiting the store with a handgun in their hand. The male takes aim at a blue Audi and fires several times at the vehicle. Mr. Williams said he felt something was wrong and he tried to hurry and leave the area because of the past confrontation with the male. Law enforcement spoke with Mr. Williams and he showed them a social media picture of the suspect on his phone, and the male in the photograph was identified as Mr. Raheem Conley. An indictment ending in...
Before we move to 526, Mr. Williams said he was shot at. He was not actually hit. The indictment doesn't say he was hit. And of course, the APD responds in a generic way. He said it was a person shot call, but Mr. Williams wasn't actually hit.
Correct, Your Honor.
Okay.
Just shot at.
Right.
And then an indictment ending in 526. On May 17th of 2020, law enforcement responded to the Quick Mart located at 3221 Martin Luther King Jr. Drive in Atlanta, Georgia, in Fulton County. The store clerk, Mr. Syed Ali, Syed, S-Y-E-D, Ali, A-L-I, advised that the gaming machine was checked earlier in that day, and there was found to be extensive damage to the front facing of the machine at the location where the cash is inserted. There was no money inside of the machine, but there are no receipts to also verify the amount of the transaction. The video for the store clerk was reviewed, and a Black male, who Mr. Ali described as a regular customer known to the clerk as Raheem, can be seen on the store's video cameras in front of the machine, working with a pry tool, attempting to open where the money is deposited. There were no other customers seen at the machine after Raheem was there. Mr. Ali indicated that Raheem is a regular customer at the store and the employees are familiar with his identity. Law enforcement was able to research the name Raheem with the phone number. Would you like me to state it on the record?
No, just a phone. Well, what's the significance of the phone number?
I believe it's a phone number that had been associated with him. I don't know if it's another case or somehow they became aware of a phone number.
Okay.
That the clerk, Syed Ali, has for him, and the name Raheem Conley was discovered. Photos of the person damaging the machine and the driver's license photo of Raheem Conley matched. Counsel, do you stipulate there's a factual basis for this plea?
And so this would be Ms. Wood.
We do, Judge.
And in case ending in 070?
Yes, we do.
And that would be all from the state, Your Honor. Before I hand it over, though, there's to address the court as it concerns Mr. Conley's assertion that there's a video saying that Mr. Ali is saying it's not him. That is unknown to the state. I'm not sure where that would have come from specifically.
Okay, well, I'll let Mr. Conley talk to me more about it. Frankly, this is the less concerning of the cases, and your recommendation, in my mind, is pretty generous, given that he shot at Mr. Williams a couple times. So we can focus on the trying to pry open the video gaming machine, but that's not the case that, in my mind, is moving the needle. It would be shooting a gun. Coincidentally, right nearby the Quick Mart. But I'm going to give Mr. Conley, and more importantly, his lawyers, a full chance to flesh that out.
And I've attempted through last week and earlier this week to reach out to Mr. Williams. I did not receive any calls back.
Okay, but he's someone who, at least at some point, had a fixed and known address.
That's correct.
If he owned a blue Audi, I'm assuming he wasn't too transient.
Yes, Your Honor.
Okay. Ms. Hardy, thank you for rejoining us. Can you share criminal history information on Mr. Conley, please?
Okay, this defendant has 12 arrest cycles in Georgia, a felony conviction in 2016 for robbery, criminal attempt to commit a felony, and theft by taking, and 1 probation violation. Nothing further to report.
And his most recent arrest?
One moment.
Battery.
Most recent arrest, August the 2nd, 2022 for battery out of APD.
Okay, and that's still open as far as you can tell?
Yes, Your Honor.
Thank you. Ms. Tucson, is Mr. Conley still on probation for that robbery case?
No, Judge, no active probation.
Thank you. All right, let's start with you, Mr. Ololoye, on the case involving the shooting at Jonathan Williams.
Yes, Your Honor. Mr. Conley is 30 years old. He actually has been incarcerated from quite some time. From my understanding of speaking with him, he had been incarcerated from November 6th of 2020 to February of 2022. He was then released. Then he was picked back up in August. He was out, and then he was.
Okay, released is bonded out.
I bonded out.
Okay, you're saying the same thing. Keep going.
And then he was arrested again back in August of 2022 till today, Your Honor. So he has spent quite some time incarcerated, Your Honor. And again, this was a case that both the state and I have been kind of negotiating back and forth with. Mr. Conley is here accepting responsibility. We went over the discovery, including statements made by Mr. Williams, the video that was shown on of the alleged shooting, Your Honor. We are asking, I do understand, obviously, with the recommendation, and the facts are serious, but given that Mr. Conley is here accepting responsibility in this matter, again, he does have kids that he would like to get back to. He would like to get back into the community, Your Honor. So we are asking that the court does accept the agreed upon recommendation between the state and I.
Okay. Yeah, I see the booking in November of 2020, and Mr. Conley served 484 days before he bonded out, and he's now on 414 days for the more recent arrest, which was the August 2022. So that's a fair amount of time.
Yes.
Ms. Wood?
Thank you, Judge. And it does total 902 days. So he is entitled to that time. And Judge, for my case, I think it would be tricky for the state to prove beyond a reasonable doubt. What Mr. Conley was referencing is, this case is from 2020. Before it was indicted and assigned to me, one of our pre-indictment attorneys had an investigator from our office go out and find Mr. Ali and talk to him. There was a language barrier. In full disclosure, so he did say, I'm not sure if I would be able to identify Mr. Conley. However, it's anyone's guess if at trial with a refreshing recollection if he would be able. And so in discussing this case with Mr. Conley, we decided that it was risky and that he's ready to go, given that he's done 902 days in the Thunderdome, that is Rice Street. So it was his decision this morning to move forward, even though he does dispute some of the facts as alleged by the state.
Was your review of the discovery, Ms. Wood, that Mr. Ali did identify back when it would have been fresh, May of 2020, Mr. Conley? He may have called him just Raheem, not I know it's Raheem Conley, but hey, that guy in the video who's trying to pry open my machine, that's Raheem. In other words, what Mr. People said that connected the dots. He said, here's his phone number, and that connected the dots to Mr. Conley.
Correct, Judge. From the police report, there is mention of a video that I was not given, that they apparently reviewed when he was talking to the police, but yes, that is, I do have that.
Okay, but you also have a statement from Mr. Ali, much more recent, to your investigator, where he expresses some uncertainty as to whether he'd be able to identify Mr. Conley now if he walked in the room.
Yes, Judge.
Okay, I understand the different pieces. Mr. Conley, is there anything you want to add now that I've heard more from both your lawyers about these two cases?
No, sir. That's all I was concerned about.
Okay, I appreciate you flagging that for me. Mr. Conley, I find that there's a factual basis in both your cases. I also find that your pleas are knowing and voluntary. You know what voluntary means? Knowing simply means in this context that you've understood everything that was discussed and you don't have any questions about anything. And you just told me you don't. So I find that your pleas are knowing. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, if you have a minor violation, you and probation will sort that out. But if you have something more significant, you get arrested for something new, that'll come back to me and we'll work through whether that constitutes something that ought to yield a revocation. Mr. Ololoye, may my staff electronically sign the indictment in case 070
Yes, Your Honor.
on your behalf?
Yes, Your Honor.
And can we sign for you, Mr. Peoples?
Yes, Your Honor.
Mr. Conley, we're doing electronic signatures now rather than passing a lot of paper around. Is it okay if we sign for you?
Yes, sir.
All right. And then Ms. Wood, in the case ending in 526, may we sign for you?
Yes, Judge.
All right. And again for you, Mr. Peoples?
Yes, Your Honor.
All right. Mr. Conley, I am going to sentence you in 21 SC 178070 to 7 years to serve 2 years with the balance probated on count well, let me do the math differently. I'm gonna sentence you on count 1 to 2 years to serve. Count 3, 2 years to serve. That'll run concurrently with count 1. And then count 2 has to run consecutive. It has to be 5 years, but I'm going to probate that. So it's a total sentence of 7 to serve 2 with the balance probated. Special condition of probation number 1, insofar as there was a gun seized, you are forfeiting that. You're not going to try to get it back. The next condition, I need to understand, when you get out, where are you going to go live? You're going to get it. You've done more than 2 years, so you're going to get out shortly. Where are you going to go live?
Oh, I'm going to live with my sister.
And where is that?
On Northside Drive.
Okay, so you're still going to be in Atlanta.
Yeah. I can't leave Atlanta. I'm on probation.
Well, meaning I'm putting you on probation?
Yeah, if you put me on probation, that means I can't leave.
Oh, actually, you could be anywhere in Georgia. And I was trying to simplify things for a lot of folks, so you're not hanging around the Quick Mart. And I was going to say, stay out of Fulton County. You can live in any other county you want. But if the place you're going to stay is in Fulton, I don't want to interfere with that because housing is hard to find.
Yeah, but I have different places to go, but I'm not really trying to move too far away from my children. I have 10 kids.
That's a lot of kids.
Yeah, and I'm not trying to move too far from them. So
holy smokes, where are they mostly? Are they all in Atlanta?
Yeah.
Okay.
Some of them stay out of town. One in Florida, one in Ohio.
Oh, so they're all over the place.
Yeah, they kind of spread it out.
So you could
most
go.
of them is in Georgia.
Okay. How many are in Fulton County of the 10?
7.
Oh, that's a majority. Okay. So you got an Ohio and a Florida.
And a New York.
And a New York. Everyone else is in
Georgia.
Okay, but not just Georgia, in Fulton
County.
Okay. All right. Any of them on MLK?
Yes.
Well, you're going to stay off MLK. So if you see them, they're going to need to come see you.
All right.
That's the bright line I'll draw. The easier one was going to be to say, hey, you can be in DeKalb or Gwinnett or anywhere you want, but stay out of Fulton. But if you've got 7 kids in Fulton, that's complicated. So, special condition of your probation will be stay away from MLK. That doesn't mean you can't drive across it, but if you get arrested and you were on foot and you were on MLK, not only do you have that new arrest for whatever, but you will have violated your probation, and we'll work through the consequences of you being back on MLK. Because for you, bad things happen on MLK.
Yeah, I got shot 7 times. I know.
Okay, so to you, bad things happen. To Mr. Williams, bad things happen. For Mr. Ali, bad things happen. All on MLK.
Yeah.
So you should have a pretty strong motivation to be not on MLK. And it's a condition of your probation now. But I also want to emphasize, because you seemed to be misinformed about this. Let's say you end up finding a good spot to live in Clayton, right near Fulton, but in Clayton County. You can move to another county. Probation will follow you. In other words, they'll just shift supervision to Clayton County. You can let them know when you move. You can't hide from them, but you can live anywhere in Georgia. So don't feel like if you get this great opportunity to be in Douglas County, oh, I can't move there because I got probation in Fulton. You have probation in the state of Georgia. And as long as you have a stable address you're moving to, you could go to Macon, you could go to Savannah, and you can stay in Fulton as long as it's not MLK Jr. Avenue. All right. I guess it's Drive. That is the case ending in 070. In 22 SC 181526, your sentence will be 1 year to serve, and you will get credit for the time you've been in, and that will run concurrently with your sentence that in the case ending in 070. So the big picture is 7 years to serve 2 years with the balance on probation. You're staying away from, you don't have any conditions on the other case because it's just time in custody. Mr. Peoples, anything else in Mr. Conley's cases?
Nothing further from the state, Your Honor.
There was no restitution amount that Mr. Ali was able to articulate?
No, Your Honor.
Okay. Mr. Ololoye, anything in the aggravated assault case?
Just one matter, not necessarily pertaining to the case itself. Mr. Conley did ask for, I would ask Your Honor, if they could recommend some type of, I guess, emergency release. According to Mr. Conley, there are times where I believe the process in getting inmate release can take days. I guess that's something he has also seen while he's there. I'm not sure what the court can do about that, but obviously I did let him know that I would bring that up to your honor. About
Sure. So I can do a lot, but only if there is in fact a delay. So if the sun comes up and it's Friday and you're still in jail, reach one of these two lawyers, reach both, don't matter, either one. They'll let my staff know. I'll pick up the phone and you'll be out that day. My guess is you'll get out tomorrow, but I hear you. There've been things that are delayed. I'm going to be signing your final disposition today. It'll get entered and it automatically shoots over to the jail. And as they come in, like, all right, Conley, get them out of here. So you may have heard of folks who got stuck because maybe the judge or the judge's staff didn't enter the final disposition right away.
No, Your Honor. It'd be like they'll have your paperwork, but they'll still hold you an extra 72 hours. For what reason, I don't know. They'll have your release papers and still hold you an extra 72
Yeah, for
hours.
what reason, I don't know either, given how full that place is. But you heard my invitation. If it's Friday morning and you are still at Rice Street, get in touch with one of these two lawyers. They'll reach my staff. I'm going to be here on Friday, and I know exactly who to call who will ensure that you get out on Friday. My hope is you get out tomorrow. Okay?
Yes, sir.
All right.
Yes, sir.
Ms. Wood, anything else in connection with your representation of Mr. Conley?
No, Your Honor, thank you so much.
All right. Ms. Tucson, what information do you need from Mr. Conley?
I'll need address where you'll be living, Mr. Conley. And can you also verify your date of birth for me? We have different date of births in the system.
7/10/93.
7/10/93. And where are you going to be staying?
Can I just give you my sister number so you can just call her and get the information?
Even better.
No problem.
Okay. Let me know when you're ready for the number.
I'm ready.
404-254-9577. Her name is Jasmine Thomas.
Jasmine Thomas.
Yes,
And what county she live in?
she live in Fulton.
Okay, so you do know where probation is
Yes.
in Fulton. Okay, I'll give her a call and give her the reporting instructions for when you are released, because they will be calling for intake. Do you have a phone number or you're using hers for now?
I'll have a number as soon as I get out. I don't have a phone number right now.
That's fine. Just make sure you give it to probation when you do get your phone turned on.
Okay.
I think that's it. Thank you, Mr. Oloroye, for your patience.
Thank you, Your Honor.
Thank you, Judge McBurney.
You bet, Mr. Conley. Good luck with that army of kids you have. That's more than a baseball team. Ms. Feely, what would you like us to do next?
I'm ready on Mr. Hughes.
Oh, before I should have, is there anyone out in the gallery that we could do? I see people sort of wilting out there.
Mr. Neal and Mr. Rosario are both ready to go, Judge.
Okay.
Mr. Neal has a childcare issue, so if we could do his first.
So let's do Mr. Neal. Ms. Feely, do you just have one case?
We'll discuss, yes. I only
Okay,
have
right.
one.
So maybe Ms. Wood could do that and you could go off
Birthday
to,
treat.
yeah. You going to Chuck E. Cheese?
I don't know, we don't actually have any plans yet, but I had a pool party on Sunday.
Excellent. So false alarm on Hughes. We're going to wait on that. Mr. Neal, come on up.
Yeah.
Yep. You going to Chuck E. Cheese?
No, not Chuck E. Cheese, we'll just do.
2 is a little young for Chuck E. Cheese.
Just a little something at the house.
Good. All right, we'll enjoy that little something. Bring us all cake tomorrow.
So is this a rule? If we have court on our birthdays, we can leave early?
If you can arrange it, I'm happy to accommodate that.
Perfect.
Yes, Ms. Willingham, you may.
Thank you, Judge.
You bet. All right. This is position 18 on our trial calendar, State versus Octavius Price. No, are you Mr. Neal?
Yes.
Sorry, position 19. I just Price flashed up on my screen and what we're going to do with that. This is position 19, State versus Charlie Neal, 23 SC 186913. Mr. Neal, you're charged with aggravated assault and possession of a firearm. And Ms. Wood tells me you are prepared to enter a plea. It may be the charges are going to be different in the plea. I just let you know what's in the indictment.
Yes.
Okay. Mr. Jordan is going to put you under oath in just a moment. You've now watched this process a few times. It's going to be very similar, except you're going to hear the name Mr. Neal a bunch of times instead of Mr. Cody or Ms. Walker or Mr. Conley. When you're ready, Mr.
Yes,
Jordan.
Your Honor, this is going to be a misdemeanor plea. 88 Peoples did inform me that count 2 would be dismissed and count 1 would be reduced to disorderly conduct. Is that correct, Ms. Wood?
That's correct.
And that's OCGA 16-11-39.
Got it. Misdemeanor plea.
Yes, Your Honor. Mr. Neal, can you please raise your right hand? Do you swear or affirm that the testimony that you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can place your hand down. Can you please state your true, correct, and legal name for the court, please?
Yes, Charlie Neal.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there a medication that you normally take that you have not been given today?
No.
How old are you and what is your highest level of completed education?
33 and high school graduate.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have been charged with 1 count of disorderly conduct?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes.
Have you had enough time to speak with your attorney, Ms. Lacey Wood, about all of the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes.
Ms. Wood, are you satisfied that your client has a full understanding of this proceeding?
I am.
Do you also waive formal reading of the indictment and any and all defects in the indictment?
So waived.
Mr. Neal, do you recall having been arrested originally on the charge of aggravated assault?
Yes.
Your Honor, the state is unaware of any outstanding warrants that are related to these charges. Ms. Wood, do you know of any outstanding warrants that are related to these charges?
We do not.
Mr. Neal, do you understand that you are entering a guilty plea to 1 count of disorderly conduct?
Yes.
Have you been advised the minimum and maximum sentence for that charge?
Yes.
And Your Honor, just for the record, the minimum is 1 day and the maximum is 12 months. Mr. Neal, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, I apologize, Your Honor. Mr. Peoples did send me the recommendation here. I believe that it's only a 12-month probated sentence and that the only special condition would be that he stay away from the victim and stay away from the incident location, I believe. Is that correct, Ms. Wood?
So I think it's a family situation. I think we were gonna ask for no violent contact, but I don't think that'll be an issue. If he needs to stay away, I don't think we have much contact anymore.
Understood. So the only condition, Your Honor, is that the state would ask for a stay away from the victim and no other special conditions.
That it was a no violent contact with the victim because it's a family situation.
My apologies.
Okay.
Mr. Neal, do you understand that the court does not have to accept that recommendation?
Yes.
Do you understand that the court can sentence you to the maximum on this charge?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes.
Are you currently on probation or parole?
No.
Are you a United States citizen?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you were giving up the following rights, which I will now list off? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Mr. Neal, how do you plead to the sole count of disorderly conduct in indictment number 23 SC 186913?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charge against you?
Yes.
Do you understand that you have only 30 days in which to appeal your conviction based on your plea today?
Yes.
Do you understand that since this is a misdemeanor charge, you have only 12 months from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
And Your Honor, I do apologize. My laptop just died. If I may borrow a laptop from
Sure. Or Ms. Clark, the power cord ladies got you covered.
Oh, that's excellent. I thank you. I appreciate it. Okay. I have thank you, Ms. Wood. On April 10th of 2022, an officer was dispatched to 637 Old Hapeville Road, Southwest, apartment 43C. Upon the officer's arrival, he was met with the caller, Miss Hayes Adriana. At the location, Adriana Hayes has normal spelling and Adriana is spelled Adrianna at the location. Ms. Hayes stated that her whole family members were at 50 Mount Zion Road, Southwest Apartment 2, due to her grandmother's funeral, and that an altercation got escalated and somewhat physical. Mr. Neal pulled out a handgun from his waist with his finger on the trigger and pointed the gun at her. Ms. Hayes stated that her husband, Mr. Hayes, intervened and broke up the altercation. Mr. Hayes stated that he was at the incident location with Ms. Hayes during this incident. Mr. Hayes stated that as soon as Mr. Neal pulled out a gun and pointed a gun at his wife, he grabbed Mr. Neal from behind, lifted him up, and placed him toward the opposite direction. I think he might have lifted him up, it sounds like.
Must be a big guy.
Yes, Your Honor. Mr. Hayes stated that as soon as he did that, Mr. Neal started to threaten him by saying that he's going to shoot Ms. Hayes. Mr. Hayes stated that he managed to push Mr. Neal towards his vehicle, and other family members were able to calm him down or make him leave. The officer did ask both Ms. Hayes and Mr. Hayes why they did not make contact with the police the day before when the incident happened. Both stated that a 911 call was made, possibly by their sister, but no officer showed up at the location. At that time, warrants were taken out for the offense of aggravated assault and possession of firearm during commission of a felony. Nothing further from the state, Your Honor.
All right. Thank you for sharing that. Ms. Hardy, do you have any criminal history information for Mr. Neal?
Yes, Your Honor. This defendant has 5 arrest cycles in Georgia, no felony convictions. There was an FTA in 2015. Nothing further to report.
Okay. And the most recent arrest?
One moment.
This is just your most recent arrest.
Okay, so the most recent arrest I'm showing is June the 13th, 2022, aggravated assault out of APD.
Got it. Okay, thank you so much. Ms. Wood.
Thank you, Judge. Mr. Neal is 33 years old. He is a high school graduate. He's gainfully employed. He works as a security guard. I will not squabble too much with the state's version of the event. I will just add that it was the grandmother's funeral, and I believe the emotions on all sides were high. And so Mr. Neal is ready to just put this incident behind him, and we ask that you accept the state's recommendation.
Mr. Neal, unless you have some real tough family members, why would you have a loaded gun in your waistband at a funeral?
Sir, technically, it was just like, I was actually leaving the whole situation because it started in the house.
Okay.
My sister ran up on me as I was leaving the situation.
So I know there are many sides to it. I'm not saying I'm taking one side over the other. I'm trying to process. I've been to a few funerals, and that's not the kind of thing I'd bring a gun to. And so I'm working through that. Not that it was illegal. You're perfectly justified.
Well, the neighborhood, it was the repast, not the funeral. It was the repast.
Okay.
The neighborhood is a bad area.
Got it. You weren't in a church where everyone was dressed in their Sunday finest. No. It was the repast in not the best part of town.
Right.
Okay.
It was right off of Cleveland Avenue.
Okay. All right. And then there was a squabble with you and your sister. Ms. Hayes is your sister? Okay.
She's married to
Mr. Hayes.
Yeah.
Who's big?
He kind of big, yeah.
Okay. Well, if he picked you up, if that part was accurate, he can't be too small.
Yeah.
Okay. All right. How would you describe your relationship with your sister now?
We're actually good now.
If she was in here, would she be nodding her head, or would she be rolling her eyes and say, "We are not good"?
She would actually be saying that we're good.
Okay.
Because right after we lost my grandmother, we actually lost my father as well.
Oof, I'm sorry.
Like literally 2 months, 2 months later.
Okay.
So we had to actually come together, and we put a lot of stuff behind us. Like we told each other we have to come together instead of actually fighting and doing this.
Okay. You are a security guard for what company?
EPS.
And where do you typically work?
I do apartments. I do a lot of apartments. I do apartments through like East Atlanta, far as the South, Enzo, Glenwood, 17th Street. I'm all over the place mostly.
Are you a security guard who's mobile, as in you're patrolling in a car, or are you on foot, or are you seated at a desk?
Mobile on foot.
Okay.
I walk around the property to make sure the property is good, checking parking garages and things like that.
Are you an armed security guard?
Technically, yes, we were armed. Yes, I was armed until actually the incident that happened. So I just stopped carrying my firearm to keep myself out of trouble, period.
Okay. All right. Wise move. Do you have any questions about anything we've discussed?
No.
All right. Well, I understand why the state has reduced this to disorderly conduct. I find there's a factual basis for a plea to that count. And I also find that your plea is knowing and voluntary. You don't have any questions. You're doing this freely. Ms. Wood, may we sign your name to the indictment?
Yes, Judge.
Mr. Jordan?
Yes, sir.
And Mr. Neal, is it okay if we sign your name to the misdemeanor plea? Yes. All right. I will sentence you to 12 months of probation. And the only condition of that probation is that you have no violent contact with your sister. But of course, violent contact with her would be a crime anyway. So it's pretty much don't break the law while you're on probation. Get this behind you, close the door, and move on in a good direction.
I know to walk. Keep walking now.
Yeah, there you go. There you go. Anything else, Mr. Jordan?
Nothing further.
Ms. Wood?
No, Your Honor, thank you.
All right. Mr. Neal, you're going to get contact information from Ms. Wood for misdemeanor probation. It's not through Ms. Tucson, whose voice you've heard a bunch of times today. You need to make sure you call those folks, because we're sending paper to them saying, hey, Charlie Neal, he's one of your supervisees. And if you don't make yourself available to them by calling or whatever the instructions are, then they just send me a warrant saying this guy never connected.
You ain't got to worry about that.
I don't feel like I need to worry about it. All right. Good luck with everything.
All right. Now. Okay.
So you're free to go.
All right, thank you.
I know we said we were going to do Mr. Rosario next, or we're gonna do Mr. Hughes. I thought you were gonna give your case to Ms. Wood.
I spoke with Mr. Hughes in the back and he is fine with that. So if I may be excused.
Yes, you may be excused. I noticed Ms. McKinney is still on the call. Is she staying on because of Mr. Batten, or did she just forget to?
She wanted to see the result.
Okay, but she's not gonna engage directly on
Yeah,
that.
but I don't think she was listed as a direct victim, so I told her, but she said she is interested.
Okay, and she's more welcome to be on. If she was gonna have a speaking part, like, oh my gosh, it's been hours. But we will get to that. What would the two of you like to do next? Mr. Rosario?
I'm fine with that, Judge.
Okay, come on up. Sir, in the blue shirt, did you come here for a case, or you're welcome to be here, public courtroom?
Henry Batten.
Okay. And were you here with Mr. Neal? You're here for Emory Batten also? Everyone is UPS or is that what that says? It's a UPS household. All right, well, we'll do Mr. Batten shortly. All right, we're doing position 9. All right, Ms. Clark, you ready?
Yes, Your Honor.
Okay, we'll go on the record. This is 23 SC 186842, State versus Ronald Rosario. Mr. Rosario is represented by Ms. Wood, standing by his side. We have Ms. Clark for the state. I want to just be extra safe. I'm not implying anything. You good going forward without an interpreter?
Yes.
Okay, good. Just want to make sure we got a good record.
Yes, sir.
So Ms. Clark's going to put you under oath. You've now heard what these questions are like a few times, but it's your turn to do that. So we're going to take care of that. And if you have any questions at any point, make sure you let Ms. Wood or me know.
Yes, sir.
Okay. Ms. Clark?
Thank you, Your Honor. For the record, the state will be reducing or recommending a reduction from OCGA 161331 trafficking in cocaine to possession of cocaine with intent to distribute under 161330.
Okay, thank you.
Defendant Rosario, please raise your right hand.
Yes, ma'am.
Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
You can put your hand down.
Thank you, ma'am.
Please state and spell your true, correct, and legal name.
Ronald Ruben Rosario Jr., RONALD RUBEN ROSARIO Jr.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you?
39.
What's the highest level of education or the last grade you completed?
High school.
Are you able to read, write, and understand the English language?
Very well.
And no one was implying anything. I do a bad job if we get partway through and then Ms. Wood said, hey, you know what? It turns out that because we're using some legal terms, we ought to have had an interpreter here. Better safe than sorry.
I understand.
That is all.
Thank you, sir.
Sure.
Defendant Rosario, do you understand that you've been charged with the following offense? The state will reduce the trafficking in cocaine to possession of cocaine with intent to distribute.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had an opportunity to review the waiver of rights form and the indictment with your attorney?
Yes, ma'am.
And did you understand the waiver of rights form as explained to you by your attorney?
Yes, ma'am.
Is it your decision to waive your rights today?
Yes, ma'am.
And did your attorney explain to you and review the indictment with you?
Yes, ma'am.
Have you had enough time to speak with your lawyer about all of the charges in the indictment against you, including the facts and circumstances relating to these charges?
Yes, ma'am.
Would you like more time to discuss the case with your attorney, Ms. Woods?
No, ma'am.
Ms. Woods, excuse me. Are you satisfied with your attorney's services?
Yes, ma'am.
Attorney Wood, do you waive a formal reading of the indictment for purposes of this plea?
We do.
Do you waive any and all defects in the indictment for purposes of this plea?
We do.
Your Honor, the state is unaware of any outstanding warrants related to these charges,
Okay.
to this charge. Defendant Rosario, do you remember having been arrested on this charge?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for the charge to which you are pleading guilty today?
Yes, ma'am.
For, the state will provide those to you. For the record, for possession of cocaine with intent to distribute, the minimum is 5 years in prison. The max is 30 years in prison.
Mm.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state and defense jointly will recommend the following sentence to the court?
Yes, ma'am.
For trafficking in cocaine, the state's recommendation is to amend this charge to possession of cocaine with intent to distribute. The state's recommendation is 10 years probation. The defendant must complete a alcohol and drug evaluation and treatment within 60 days of today's sentence. Forfeiture of any monies confiscated at the time of arrest, the amount $997 roughly. Is that your understanding of the terms of the plea agreement?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on this charge?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you do have the right to withdraw your plea of guilty?
Yes, ma'am.
Did Mr. Rosario preserve his, I don't remember if this is one with final plea rights preserved.
Judge, to be honest, I don't remember either because if you recall, he zoomed in from out of state. He had a newborn at his final plea hearing.
Okay, so we may have just, that's fine. And with Ms. Clark transitioning in, it's gonna be flexible anyway. So I'll just assume that that's a true statement.
Thank you, Judge.
Sure.
Are you currently on probation or parole?
No, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit, whether municipal, county, state, or federal?
Yes, ma'am.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes, ma'am.
You understand that doing so will result in new criminal charges for which you face a sentence of between 1 and 10 years?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes, ma'am.
Do you understand that if you were in the future to use a firearm in the commission of a crime, you would face up to a 15-year custodial sentence consecutive to the sentence for the underlying felony?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena any witnesses on your own behalf, the right to testify against yourself or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial? Defendant Rosario, is it your decision to waive these rights, which means not to use them, and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter the guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
As to indictment number 23 SC 186842, how do you plead to the charge of possession of cocaine with intent to distribute?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
Do you understand that for a felony charge, you only have 4 years from today's date to file that petition?
Yes, ma'am.
At this time, the state will provide a factual basis for the plea. Your Honor, if this matter would have went to trial, the state believes that the case, the facts would be able to prove beyond a reasonable doubt that on November 7th of 2021 at 3:20 p.m., APD officers responded to a domestic dispute at the incident location of 501 University Avenue Southwest in Fulton County. Upon arrival, they made contact with two parties. Miss Daraine Riley, Daraine is spelled D-A-R-I-N-A-E, Riley, advised that her live-in boyfriend, Mr. Ronald Rosario, assaulted her that day. When Miss Riley called 911, she also advised that Mr. Rosario had threatened her and her children and had a firearm on his person. Officers immediately patted down Mr. Rosario to check for firearms. Officers did feel an object in their right jacket pocket that he could not identify. Officer Bush then took this item out of the pocket, and it was a vacuum sealed package filled with a white substance. The white substance appeared to be cocaine based on the appearance and the packaging. The defendant, Mr. Rosario, was detained. Miss Riley told officers that she and Mr. Rosario went to get breakfast and that he had gotten upset about the fact that she had money at the from the ATM machine, that the defendant pushed her and reached into her pocket to grab some money, but she was uninjured. She indicated that the defendant flashed a gun to her and threatened her with that gun. Defendant Rosario was Mirandized by Officer Minor and asked if he wanted to speak with officers. Defendant Rosario advised that Ms. Riley pushed him in the kitchen and caused him to break the glass in his hand. He advised that he did not take any money from the victim, Ms. Riley, nor did he push her. He also advised that the jacket containing the suspected narcotics belonged to Ms. Riley instead of him. Officers weighed the suspected cocaine substance and it measured to be 5 ounces, approximately 141 grams. The defendant was taken into custody and arrested. A GBI lab was done on the substance, Your Honor, and it was in fact tested to be determined to be cocaine in the amount of 131 grams. Nothing further from the state.
Thank you. Ms. Hardy, any criminal history information on Mr. Rosario?
This defendant is a multi-state offender with arrests out of Georgia, Florida, California, and Pennsylvania, I'm sorry. No felony convictions. Their last arrest was July 10th of 2021 for battery family violence. Nothing further to report.
Thank you. Ms. Wood.
Thank you, Judge. Mr. Rosario works in the music industry. He's self-employed. He does have a high school education. I believe he grew up in Georgia. Is that correct?
Been 18 years.
But he has spent some time most recently out of state in New York. I believe he's planning to relocate down here. Judge, we would ask that you accept the state's recommendation. And as far as the special condition of the drug and alcohol evaluation and treatment, he had shared with me a few different facilities that he has been in contact with. So I believe that he'll be able to get that lined up within the state's recommended 60 days.
I missed that part, that he's supposed to have the evaluation within 60 days?
Yes, sir.
Okay. So you tried to palm the drugs off on Ms. Riley?
No, sir.
That's what the police said. They were mistaken?
I mean, everyone was intoxicated, so.
Oh, who knows who said what? Okay, all right.
There was a lot of liquor involved.
Are you and Ms. Riley still involved?
We are engaged and have a child.
Oh my gosh, I would call that involved. So you two have worked through the issues of November 2021.
Yes, sir.
Okay. What does it mean to be in the music industry?
I'm a Grammy award-winning recording engineer.
So if I were a musician, which I'm not, what would you be able to do for me because you're a recording engineer?
I'm the guy that records your music. So when you go to the recording studio, I'm the one that hits the button to make you sound good.
So you get a Grammy because you push a button?
I make you sound good.
No, you press a button. The machine makes me sound good.
We tell the machine what to do.
I got it. This is a machine with 9 million dials and this and that. And so you're tweaking it just right so that I sound even better than I normally do.
Yes, sir.
All right. Huh. Well, congratulations for you. How long have you been in that line of work?
Pretty much all my life.
Okay. Is that now the only line of work you're in, or are you still dabbling in other lines of work?
I do that full time.
Okay. All right. And you and Ms. Riley have one kid?
We have one child together. Yeah.
Okay. And do you still live at University Avenue or you moved?
No, sir. We moved to New York and we recently relocated back here to do this, to handle this case.
Okay, right, because your probation can be transferred to another state, but it's going to start out in Georgia and transferring it's kind of complicated.
We already moved back.
Okay.
We've been here 2 weeks.
Okay, you're freshly here. What county do you live in?
I live, what is it, Fulton County?
I don't know. What city do you live in?
I live off by Little 5 Points.
Okay, that'd be Fulton County.
Fulton County.
Probably. It might be DeKalb, but we'll work through that with Ms. Tucson in a minute. Okay. And do you have your own studio or you're in someone else's studio?
I work in different studios.
What's your connection to California?
I've worked in California for a while. It's music there.
Okay. Pennsylvania?
When I was a child, music there.
Okay. But you have an arrest out of Pennsylvania. How
over 18
much of a child were you?
18 years ago.
Okay. And Florida, I guess that's right next to Georgia. Okay. All right. Well, Mr. Rosario, I find there's a factual basis for your plea. The state has reduced this from trafficking to possession with intent. I also find that your plea is knowing and voluntary. You don't have any questions. No one's forcing you to do this. I'm sentencing you under the Probation Options Management Act, which means that while you're on probation, if you have any issues, but they're small ones, you and probation will solve those. If it's bigger, you get arrested, you test positive for drugs too many times, that'll come back to me and we will come up with an appropriate response to those issues. I will sentence you to 10 years probation. I will set a behavioral incentive date of September 20th, 2027, which means if between now and then, that's 4 years from now, you've had no issues on probation, they can close your case out.
Thank you, sir.
I'm not a big fan of multiple years of probation because weird stuff happens 7 years from now, you get a DUI and all of a sudden it's a revocation. But I am a big fan of a sentence this long. If 6 months from now, you're caught with however many hundreds of grams of cocaine in that jacket, you're gonna go to prison. You may not on the new charges, you will on this charge because I'll revoke you and we'll be wasting your recording engineering skills because you can't do that so well down in Paulding County Detention Center, wherever you'd end up.
Thank you.
You will need to submit to a drug and alcohol abuse evaluation within 60 days. If that results in any recommended treatment, going to classes, doing this or that, you'll need to follow that course of treatment. And it sounds like you had a chunk of change on you when they arrested you. That money you forfeit.
Yes, sir.
Ms. Clark, anything else in connection with Mr. Rosario?
No, Your Honor.
Ms. Wood?
No, Your Honor, thank you.
All right. Ms. Tucson is going to ask you questions about where you live now so she can figure out your probation reporting instructions. Ms. Tucson?
Good afternoon, Mr. Rosario.
Good afternoon, ma'am.
What city did you, I guess, move back to?
Atlanta.
What's the address?
Fulton County?
Yeah, I'm gonna give you the address right now. Hold on. Brand new address. We just got there. 675 North Highland Avenue. And it's apartment 306. Atlanta, Georgia, 30306.
And what is your phone number?
404-861-8510.
So that's 675 North Highland Avenue, number 106. I'm sorry, 306, Atlanta 30306. And the phone is 404-861-8510.
Yes, ma'am.
Okay, probation is at 276 Memorial Drive. However, you will be contacted for intake, and I will call you so I could email you reporting instructions.
Okay.
That it?
Yes, Judge.
Okay, welcome back to Georgia.
Thank you, sir.
Please go.
All right, thank you.
Take
You have a
care.
good day.
You too. All right, let's do another plea and then we're going to take a quick break and then we'll finish off everything else. Do you want to do Mr. Batten?
Yes.
Think we can make that happen?
I'm gonna do my best.
All right, me too.
No, you're fine. Come on. Okay. Thank you. So it's actually this one. It's just a different channel, okay? We're ready, Judge.
Okay. We're back with Mr. Batten, who came out earlier this morning. This is position 13 on our calendar, 23 SC 186399. When we spoke this morning, Mr. Hiles, you had identified the two sets of counts to which Mr. Batten would be entering a guilty plea. And there was going to be the recommendation of 15 to serve 8. I think now it's non-negotiated, but I'll hear from Ms. Wood in just a moment. You and Ms. Wood were talking about a bunch of other count numbers. Is it now a plea to more than just those two sets of counts?
Yeah, I've gotten some of his counts mixed up with Mr. Wolf's.
Okay.
So you got that straight, so I can, so it would be counts 14, through 16.
And that's the immolation of the maxima.
Yes.
Okay.
And then counts, make sure that exactly right. It's gonna be.
Mr. House, move the microphone in front of you, please.
Then it will be counts. $42, count 44, let's make sure the dates. Sorry, not count 44, count 42, count 46, count 48, count 50, and 51.
That's it?
I mean, yeah.
So 14 through 16, that's the maxima, and then 42, 46, 48, 50, and 51. Do those all relate to stolen cars?
Those are all separate stolen cars, yes. You're
Okay,
right.
got it. So we're still dealing with cars, either burning them up or stealing them.
Yes, and they were, the reason I selected those, that each charge for that stolen car had multiple gang charges associated with it. So you will just be pleading to one gang charge for each car that was stolen.
And so all of the pleas are to violation of Street Gang Act, not the underlying conduct.
Correct. The rest of the counts will be dismissed.
Okay, got it. So Mr. Batten, that's the plan. Ms. Wood, is this now non-negotiated?
Judge, I believe it is negotiated.
Negotiated. Okay. Well, let's let it unfold. You ready to go forward, Mr. Batten?
Yes, sir.
Okay. Mr. Hiles is going to put you under oath. And you should answer all his questions and mine. Just as important, you should let Ms. Wood or me know if you've got any questions because you don't understand something or it's not going the way you thought or just, hey, wait, I got a question. What just happened? And we'll do our best to answer them. All right. When you are ready, Mr. Hiles.
Yes. All right, Mr. Batten, will you please raise your right hand, best of your ability. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down now. Please state your true, correct, and legal name.
Emery Batten.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there any medicine that you normally take that you have not taken today?
No, sir.
How old are you?
22.
What is your highest level of education?
12th grade.
Did you complete the 12th grade?
No, sir.
So you've gone through the 11th grade.
Yes, sir.
Have you obtained your GED?
Yes, sir.
You have.
Yes, sir.
Okay. Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that today you will be pleading to 7 counts of violation of Street Gang Terrorism and Prevention Act? Do you understand?
I count 8 unless it's not also count 15. Is it 14 through 16?
It's 8. I apologize.
Okay.
Yes, 8. You will be pleading to 8 counts of participation in criminal street gang activity. Do you understand?
Yes, sir.
And those counts were just announced to the court. Do you understand that each one of those counts carries with it a potential sentence range of 5 to 20 years? Do you understand?
Yes, sir.
You understand that you have the right to plead guilty or not guilty to these charges?
Yes, sir.
You understand that if you plead not guilty or remain silent, you may receive a jury trial?
Yes, sir.
Have you reviewed your waiver of rights with your defense attorney?
Yes, sir.
And did you initial those Did you sign the waiver of rights form?
We just did it verbally. Happy to sign if needed.
Okay, we'll go through all those individually now. So did you discuss with your attorney all the rights that you would be waiving?
Yes, sir.
Have you had enough time to speak with your attorney, Ms. Wood, about all the facts and circumstances known to you regarding the charges in indictment 23 SC 186399?
Yes, sir.
Do you need any more time to discuss this case with your attorney?
No, sir.
Are you satisfied with your attorney's services?
Yes, sir.
Ms. Wood, do you waive formal reading of this indictment?
We do.
Do you waive any and all defects in this indictment, including any with respect to your client's name?
So waived.
Um, All right, Mr. Batten, do you understand this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense to this court will be a sentence of 15 years to serve the first 8 in custody with the balance to be served on probation. The special conditions be that you have no contact with any known criminal street gang members, that you refrain from any participation in criminal street gang activity, that you possess no guns, or no firearms, weapons, or replicas thereof. Do you understand?
Yes, sir.
Can you go back to the very beginning of the recommendation? I got all the special conditions, but I pivoted over too late. Is it still 15 to serve 8 or it's something different?
15 to serve 8, Your Honor.
Balance probated.
Yes, Your Honor.
Okay.
And do you understand, Mr. Batten, that the court does not have to accept the recommendation, and this court can sentence you up to the maximum on each charge and can run those sentences consecutively or one after another? Do you understand?
Yes, sir.
And do you understand that sorry, do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in federal courts? Do you understand?
Yes, sir.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today? Do you understand?
Yes, sir.
Okay. I will make the caveat that the probation that you are currently on out of Fulton County will not be affected, as you were already in custody, or the plea happened after these crimes had occurred. So it should not affect.
Got it. The conduct to which Mr. Batten is pleading guilty now predates his conviction for which he's on probation. So it would not be a basis to revoke.
Yes.
Okay.
And Mr. Batten, are you a United States citizen?
Yes, sir.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, sir.
Do you understand that your conviction may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment? Do you understand?
Yes, sir.
You understand that by pleading guilty to this felony, if you use, receive, possess, or transport a firearm, you will be guilty of an additional felony that carries with it a potential sentence range of up to 5 years. Do you understand?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty? Do you understand?
Yes, sir.
All right, I'm going to go through these next rights, known as your Boykin rights, one at a time. Mr. Batten, do you understand that by pleading guilty, you're giving up the right to trial by jury?
Yes, sir.
Mr. Batten, do you understand that by pleading guilty, you're giving up the right to remain silent and not incriminate yourself?
Yes, sir.
Mr. Batten, do you understand that by pleading guilty, you're giving up the right to confront witnesses against you?
Yes, sir.
Mr. Batten, do you understand that by pleading guilty, you're giving up the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the right to the presumption of innocence?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the right to testify on your own behalf and to present other evidence?
Yes, sir.
you understand that by pleading guilty, you are giving up the right to subpoena witnesses and compel the production of evidence?
Yes, sir.
You understand that by pleading guilty, you are giving up the right to have the charges against you proved beyond a reasonable doubt?
Yes, sir.
And do you understand that by pleading guilty, you are giving up the right to appeal if convicted of these charges after a trial?
Yes, sir.
Okay. Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the 8 counts of violation of Street Gang Terrorism and Prevention Act in indictment number 23 SC 186399?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that unless counsel is substituted or permitted to withdraw, your counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later? Do you understand?
Yes, sir.
And do you understand that you have only 4 years from today's date for these felony charges to file what is known as a habeas corpus petition challenging the voluntariness and constitutionality of this guilty plea? Do you understand?
Yes, sir.
Do you understand that you have until the last day of the current term of court to file a motion to withdraw your guilty plea? Do you understand?
Yes, sir.
And do you understand that any of the filings we have just discussed must be filed by your counsel unless you are representing yourself? Do you understand?
Yes, sir.
Your Honor, I'm going to deal with the first set of charges, 14 through 16. Your Honor, were this to go to trial, the facts would show that on October 3rd of 2019, Atlanta police officers responded to 1550 Marietta Road Northwest in City of Atlanta, Fulton County, to a car fire. When officers arrived on scene, it was a rail yard, and they spoke with railroad worker, Mr. Johnny Campbell. Mr. Johnny Campbell stated that he saw what he believed to be a black Maxima and a silver Range Rover drive into the rail yard together. Approximately 1:40 a.m. on October 3rd of 2019, he went about his business and did not pay the cars any more attention. And then he heard a loud explosion and came back to where the cars entered, saw the silver Range Rover fleeing and the Maxima on fire. The officers waited for the car to extinguish once the fire department got there, and they were able to recognize quickly that there was a citywide BOLO for this particular vehicle, as it was suspected to be involved with a homicide that occurred at the Lowe's 10 days prior to this incident in East Point.
This is what we heard about this shooting, the murder at Lowe's, is what we heard about through Mr. Wolf's plea.
That's correct.
Okay.
Yes, Your Honor. The facts would show that just prior to this incident, Mr. Batten was on Instagram Live inside of the silver stolen Range Rover that had been stolen days prior out of Brookhaven when it was left running, and the owner of the car went inside to run an errand. Shortly thereafter, the officers went and got a search warrant for the phone number of Mr. Emery Batten to see if it was in the location of the fire or the arson. When those records came back, it put Mr. Batten's phone number in the area of the arson at the time of the arson. And then that particular Range Rover at issue, 20 minutes after the fire hit a license plate reader that was about 6 miles away from the incident. Also of note, Your Honor, the co-defendant, Mr. Ricky Wolf, who pled guilty to gang charges involving the murder at the Lowe's of Mr. Melvin Robinson, called Emory Batten directly after the murder happened. It was the first phone call within minutes of the murder. And then this occurred 10 days later. There was a text message in the Instagram returns of both Mr. Wolf, from Mr. Wolf to Mr. Batten, asking caller ? And then the response was the okay sign just after the arson had occurred. Additionally, arson investigators were able to take samples out of the car, and it showed that the accelerant used in the fire came back as gasoline. Additionally, well, Your Honor, that would be the facts of the case were this particular incident to go to trial. Now, the next set of gang charges occurred between January 5th and January 12th of 2019. At trial, the state would show that on January 5th of 2020, a purple Dodge Charger owned by Amend Baband.
Was it 2019 or 2020? The indictment.
Apology, 2020. Okay. It's 2020. It's so it's on January 5th of 2020, a purple Dodge Charger owned by victim Amend, AHMEND, last name Baban, BAHBAN, was stolen from the Ed Voiles dealership in Marietta. The car shows, or video surveillance shows, somebody in a hoodie matching the stature of Mr. Batten, start the car with a fob, and the only other known fob was in the possession of the dealership at the time. However, those can be reprogrammed to start a car. That particular car was abandoned in city of Atlanta at the corner of Campbellton and Barge Road after an accident where the driver fled. In the front driver's seat of the car, Mr. Batten's phone was recovered from the front seat. Additionally, fellow 27 Uno's gang member Tremarcus Johnson was taken into custody around the same time. A phone dump of Tremarcus Johnson's phone showed that Emory Batten had sent pictures of that particular purple Dodge Charger on all four sides of the car with the make and model in an attempt to sell the vehicle just prior to the car being abandoned at Campbellton and Barge Road in Atlanta, Fulton County. Next, on January 9th of 2018, Mr. Robin Fowler had his 2018 Dodge Challenger stolen from 96 East, or Miss Robin Fowler, 96 East Andrews Drive in city of Atlanta, Fulton County. She left her car running while she went inside to pick up her son. The car was stolen while it was running in the fob inside of the car. The phone dump of Tremarcus Johnson again showed that Mr. Batten had texted pictures of all four sides of that particular car in an attempt to sell. Then on October 10th, 2020, there was several keys stolen from the valet at 273 Buckhead Avenue, city of Atlanta, Fulton County. Shortly after the keys were stolen from the valet box, two individuals came and stole a 2017 Porsche 911 and a 2018 Mercedes C300 from the parking lot using the fobs that had been stolen. Again, the phone dump of Tremarcus Johnson shows that pictures of those cars were texted from Emory Batten to Johnson shortly thereafter, after the incident. Then finally, on January 12th of 2020, an Audi Q7 was stolen from 3365 Piedmont Road at Goucher Restaurant. The valet at the restaurant went to park a vehicle when video surveillance showed that an individual matching Mr. Batten's stature took a key from the valet stand. As the valet driver was returning from parking another vehicle, he attempted to stop the car from leaving the parking lot. He was grabbed the door, but the car took off at a high rate of speed. Again, this pictures of this car were texted from Batten to Johnson. That would be the state's case should it go to trial. I would also like to add that Mr. Batten, as well as Tremarcus Johnson and co-defendant Ricky Wolf, all are confirmed and documented members of the 27 Unos criminal street gang, whose MO is to steal cars, either that are left running through slider crimes, and particularly high-end vehicles, such as the ones in this case.
Mr. Johnson was a juvenile, or why is he not in this case?
By the time this was indicted, by the time we got into the cell phone dumps, he had already pled his case out, and he's
okay. He's resolved his business.
Yes.
Okay. Got it. Thank you.
So,
Ms. Hardy, do you have any criminal history information for Mr. Batten? There must be something because he's in a red jumpsuit.
This defendant has 5 adult cycles in Georgia, a felony conviction in 2021 for theft by receiving an aggravated assault. It looks like there may be a hold out of DeKalb. The date of that warrant is 2/2022. Nothing further to report.
Okay. Thank you.
Your Honor, I can speak to the theft by receiving and the ag assault that he was convicted of. That was in result to a stolen Range Rover that was stolen out of Sandy Springs. One of the officers attempted to stop Mr. Batten as he was driving the car. He drove directly at the officer, forcing the officer to jump out of the way. So that was the basis of that ag assault. And it was that was actually when he's been in custody since that date. He was arrested on January 17th, 2020. And it was during the subsequent investigations under all of the 27 Unos members that different phone dumps of various members showed criminal activity amongst the group, resulting in sporadic charges, I guess.
Okay. Got it. Ms. Tucson, it sounds like Mr. Batten is on probation now, but it's for conduct that occurred after all these situations.
Yes, it's showing active on that case he mentioned.
Okay. And is that, I guess it's not being supervised anywhere because Mr. Batten hasn't gotten out since he was arrested for that.
I mean, it shows him under the Atlanta circuit, but in custody.
Got it. Okay. Ms. Wood?
Thank you, Judge. Mr. Batten is 22. He does have a 12th grade education, as you heard. His family was here earlier. I'm not sure what happened, but they do support him and they're eager to support him as he travels throughout the rest of his sentence. We are hopeful, Judge, that he will be able to avail himself of opportunities in Ducey so that he can hopefully maybe get a certification, take some classes. He understands that this lifestyle is not it. And so we do ask that you accept the state's recommendation in this case. And yeah, that he get credit for all that time since January 17, 2020.
Sure. Okay. Mr. Batten, do you have any questions before I go through the parts I need to do?
Yes, sir.
Okay. I'm assuming there's no restitution. I didn't hear you mention anything about that. At least that's not how it will be collected through this plea.
No.
Okay. Mr. Batten, I find there's a factual basis for your involvement in these stolen cars and the arson, destruction of the stolen Maxima, et cetera. I also find that your plea is knowing and voluntary, knowing meaning you've understood the things we talked about. And when you didn't, you called for a timeout. In fact, we took a timeout this morning so you and Ms. Wood can continue to discuss. I'm sentencing you under the Probation Options Management Act, which simply means that when you're on parole or probation, and these are all parolable, I suspect you'll get there soon, then you'll be on probation for a while after that. If you have a small violation of probation, you and probation will handle it. But if it's more significant, you get arrested again, you're found with Instagram pictures of you with other guys doing what looks like gang-related activity, or you're holding any firearm, replica or real, those are the kinds of violations that would come back to me, and we would sort out what the results would be. Ms. Wood, may my staff sign the indictment on your behalf?
Yes, Judge.
Mr. Hiles?
Yes, Your Honor.
Mr. Batten, is it okay if we sign your name to the indictment indicating your plea just to those counts we've been talking about?
Yes, sir.
Good, we'll do that. I will follow what's been negotiated, and on all 8 counts, it'll be the same sentence of 15 years to serve 8 with the balance probated. You'll get credit for all the time you've been in as calculated by the custodian. 3 special conditions to your probation. Number 1, no contact with known gang members. That doesn't mean you have to ask a guy, like, hey man, what were you up to back in the day? But if people are bringing you into a situation that you think might be suspect, you need to walk away from that. Obviously, no participation in gang-related activities. And then finally, while you are under this sentence, no guns or replicas of guns. So it's not okay, even though it's got the little orange thing on the end and it just shoots those little pellets. A gun is a gun is a gun. For your purposes, you can hold a baseball bat instead, or a bow and arrow, but no guns. Anything else, Mr. Hiles, in Mr. Batten's case?
No, Your Honor.
Ms. Wood?
No, Your Honor.
Okay. Ms. Tucson, I'm going to let probation notify Mr. Batten about reporting when he's wrapping up his sentence, because he's going to go to DOC custody first rather than us trying to lock in an address now, if that's okay.
Okay, yes, that's fine. It will be uploaded.
Excellent. Okay. Thank you, everyone. We're going to take a quick break. We will resume at about 3:47, so 10 minutes from now. And we'll go in whatever, I think it's just the 2 of you now. Ms. Willingham is online, but just negotiate. It's just you on the defense side. So why don't you just tell us the order in which we're going to do it? I know we've got Price and we've got Hughes. That may be it, but I'll do whatever it is you guys need.
Thank you, Judge.
I'll be happy to go.
Oh, Ms. Willingham, she's on. You should tell her she can drop off.
Yes, I told her.
Okay. All right.
Your Honor, may I be excused, please?
Yes, sir. Thank you for sticking around for that one.
Is it cool to do Price first?
Sure.
Okay.
Starts sounds like but apparently it's something else.
Come with you.
Mr. Robinson's trial.
Is that when we specially said it, or you want it specially said?
That's the date that's now. Odyssey.
Okay.
I just want to know.
Okay. Yeah, reach out to Ms. Nelson, just letting her know, hey, we'd like a special setting. That'll remind me, and I'll do that.
All right, thank you so much.
Okay.
Please for the marathon.
Yeah. You want to go through for the last one? Very close.
Julie, what's the total sentence on this Hughes case?
12 years probation.
Okay. Thank you.
Yeah, but basically.
It's an intelligent.
Oh, that's what's wrong. Hey.
Leela. Wait. Say your birthday. Happy birthday.
What's your birthday?
No, mine. It was Lisa.
Lee. I thought it was a kid's birthday. Who had a child's birthday?
Dion.
So.
That's what I'm saying.
What, is Mr. Lewis still up?
I don't know.
She was gonna run from 8. He's a 3-time convicted felon. She asked for 8. She literally asked me for it. She sent me an email saying, he doesn't really love the 8 years to serve. That's what you asked me for. And I gave it to you. I was at 10, and you said 8, and I said, okay.
Okay.
And it's, I'll get to take the pain in here if I have to, and it's the death of his wife, but we'll be here for him. I mean, he asked for 8.
We'll talk to her and then he's right there. Yeah.
He's still here. Someone,
And we could
take
do it.
someone down to bring some other people up, so I think they know that.
And we could definitely do it like tomorrow, Friday, whatever day.
Yeah.
I'm not gonna force it. I mean, we're gonna resolve it.
Right. Okay.
Yeah, I don't.
I'll text her.
That's right.
Okay. I will see what's happening with that.
Okay.
Thank you, Lee. I really appreciate it.
Yeah, yeah.
I'm sorry that you have to be here all day.
It's all good.
Okay, so. I said price, right?
Yes.
Okay. I feel like I've been going nonstop. So you can follow up. Yeah. Yeah, it's me. Yeah, some of the deputies were complaining about like my Kroger brand candy, so I brought this in and then it's like completely gone. It's like church candy.
I'm hungry.
If you like butterscotch. Mhm.
All right. All right, I'll take this. You know, I like. Oh, yeah. I didn't watch this, but it's good man. That's my brother. Yeah, no, it's yeah. So the shoes, they're not all really brown. But yeah, that's why I mean, yeah. Not at all. Anytime.
Julian, on the Hughes I feel like there's more than just one case, right?
It's 3.
Okay.
You need the case numbers.
Okay, so I have 23 SC 187106 and then 23 SC 188978. Oh, and then 23 SC 189495.
That's right.
Okay, perfect. Thank you.
And on 978, we wrestled around a little bit, but it's just going to be 1 count of criminal trespass.
Okay. Thank you.
You have my cell, right?
Mhm.
Just text me.
Okay.
She, whatever, I mean, I'm not 2 steps away from you.
Okay, I'll let you know. I sent her a message.
She asked for See the email? She sent me an email the other day. It's not you. Yeah, they figure out. She asked me. She literally asked me. What is it? Reducing costs. That's interesting. How long has it been like? I think she did go on. Yeah, I think he's getting to it now. He got he works on, so I'm moving it back. Down. He's got up. Yeah, he's got it up.
Why are you here, Mr. Bate?
I thought Miss Feely was still here. I was checking in on,
Another offer?
I gave her the offer she requested, and then she said, well, he doesn't love that anymore. So then I said, you can go down negotiate it. I don't care.
Maybe he'll love trial.
Wow.
Okay, well, maybe tonight she'd be in the best frame of mind. Who knows? All right. Ms. Wood, thank you
Yes,
for
Judge.
being, and Mr. Jordan, the folks who stay here all day in court, along, of course, with our deputies, and the mystery person in the way back. And all the folks online. We have left Hughes and Price. Is that it for today, or is there more?
My count, that's it, Judge.
That's it, Your
Okay. Who would you like to do first?
I believe Mr. Price is logged on, so if we could handle him and then we'll do Mr. Hughes.
He is Octavius's iPhone. Mr. Price, can you come alive for us? There he is. Still got his red shirt on. All right, and let's get the podium off and go over to defense table. There, we've got everyone we need. Can you hear us, Mr. Price?
Yes, sir, I can.
Good, we can hear you. Appreciate your patience. Did you pick up your son or whoever it was you were getting?
Yes, sir, I did pick up my son.
Good, is he safely delivered to where he needed to be?
Yes, sir, he's actually with me right now.
How old is he?
My son is 4.
Wow, little guy. Excellent. Okay.
Yes, sir.
There he is. Hey, young man, what's your name?
I'm TJ.
You're TJ?
Mm-hmm.
What are you eating there?
Muffins.
Mustard?
Muffins.
Mm-hmm.
Excellent. All right. Well, I got to talk with your dad for a little bit, okay?
But I got to house.
Okay.
All right. You go do that. So, Mr. Price, you ready to go forward with a plea hearing?
Yes, sir.
Okay. Mr. Jordan is handling this for Ms. Willingham, colleague of hers. You can see him on the screen there. It says WTNS. He just waved at you. He'll swear you in, and then we'll go from there. When you're ready, Mr.
Thank
Jordan.
you, Your Honor. And before we begin, this will also be a misdemeanor plea. Count 1 will be reduced to disorderly conduct, OCGA 16-11-39. Count 2 will also be reduced to disorderly conduct, OCGA 16-11-39. And count 3 will be null pros, Your Honor.
So 2 disorderly conducts and a null pros.
That's correct, Your Honor.
Thank you for that headliner.
Thank you. Mr. Price, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
Octavius Demetrius Price Jr.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you and what is the highest level of education that you've completed?
I'm 27 years old as of today and 12th grade.
Well, happy birthday. Are you able to read, write, and understand the English language?
Yes, sir, I am.
Do you understand that you have been charged with 2 counts of disorderly conduct?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes, sir.
Have you had enough time to speak with your lawyer, Ms. Lacey Wood, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss the case with your attorney?
I just wanted to be clear on everything and know exactly how long probation would be and things like that. I just wanted to be clear on that. That's about all.
Okay, well, I'll give you a chance if you need to speak with Ms. Wood about that, but let me tell you 2 things about it. One, Mr. Jordan can tell us in just a second what the recommendation is. And 2, I need to overlay that really no one knows until I sentence you. So Mr. Jordan's going to recommend something. Ms. Wood may say, we agree, or I recommend something different. But in the end, I'll be deciding. The most it could be is 24 months of probation. That's 2 counts of 12 plus 12. The least it could be would be 1 day of probation. And I'm not being vague and I don't know where it's going to be. I generally follow what the parties recommend, but I don't know anything about this case. I don't know what Ms. Wallace thinks about the case. I'll probably hear a little bit about that from either the prosecutor or your lawyer. So I'm going to need to learn a little bit more, but chances are I will go along with a recommendation, in particular if it's a joint recommendation. Mr. Jordan, what is the state's recommendation?
Your Honor, it is 24 months of probation with these special conditions of probation. Being no violent contact with the victim, that he complete a family violence intervention program, and they also complete 100 hours of community service, that he possess no weapons and use no drugs or alcohol.
Okay. And is that a negotiated plea, Ms. Wood, or you're asking for something different?
Judge, it is negotiated. There's something at the very end that he wants me to put on the record, but for the most part, it's negotiated.
And most importantly, to his question, 24 months probation is what everyone has negotiated to make the felonies go away.
Yes, Judge.
So there you go, Mr. Price. I could not give you more if I wanted. 24 is the most I could give you. I might give you less depending on what I hear. Does that answer your question?
Yes, sir.
Okay, should we keep going?
Yes, sir.
Ms. Wood, are you satisfied that your client has a full understanding of this proceeding?
I am.
Ms. Wood, do you waive formal reading of the indictment and also any and all defects in the indictment, including any with respect to Mr. Price's name?
We do.
Mr. Price, do you recall originally having been arrested on the charge of aggravated assault?
Yes, sir.
Your Honor, the state is unaware of any outstanding warrants that are related to these charges. Ms. Wood, do you know of any outstanding warrants that are related to these charges?
We do not.
Mr. Price, do you understand that you are entering a guilty plea to 2 counts of disorderly conduct?
Yes, sir.
Has your attorney advised to you the minimum and maximum sentence for each charge that you are pleading to?
Yes, sir.
And as Your Honor previously stated, the minimum is 1 day and the maximum is 12 months in custody. Mr. Price, do you understand that this is a negotiated plea of guilty, which means, would you like me to place the recommendation back on the record, Your Honor?
Nope, unless you suddenly changed it.
Understood. Mr. Price, are you aware that the court does not have to accept the recommendation that was previously given?
Yes, sir.
Are you aware that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes, sir.
Do you understand that since you are being placed on probation, or you may be placed on probation, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, sir.
Are you currently on probation or parole?
No, sir.
Are you a United States citizen?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights, which I will now list off? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Say that one more time. I'm sorry.
My apologies. Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
Mr. Price, how do you plead to 2 counts of disorderly conduct and indictment number 23 SC 185613?
I plead guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, sir.
Do you understand that you have only 30 days in which to appeal your conviction based on your plea today?
Yes, sir.
Do you understand that since these are both misdemeanor charges, you have only 12 months from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
And Your Honor, for a factual basis, on January 17th of 2020, officers responded to a domestic dispute between Ms. Zaire, and I apologize if I'm mispronouncing that, it's spelled Ziarre, last name Wallace, has normal spelling, and her child's father, the defendant, Mr. Price. Ms. Wallace stated that she was dropping her son off to Mr. Price so she can go to work. She and Mr. Price got into a verbal argument over watching their child. Mr. Price then struck her on the right side of the face multiple times. She fought back in self-defense, retreated to her car, and drove away prior to Mr. Wallace that's a typo, Mr. Price pulling out his gun, cocking it back, and pointing it at her as she pulled away. Mr. Price said that as she was getting his son out of the car, that she was taking too much time. The officers then went to the defendant's house. He asked Ms. Wallace if she can pick their child up at 8 p.m. because they had something to do, and Ms. Wallace punched him in his lip. Mr. Price did admit to having a gun in his hand, but he denied pointing it at Ms. Wallace. Ms. Wallace did, according to the officers, have bruising on her right cheek. Mr. Wallace was at that time arrested for aggravated assault and battery and was transported to the East Point City Jail. Your Honor, according to ADA Willingham, they did reach out to Ms. Wallace and spoke to her multiple times in regards to this case. She did say that she did not want the defendant to go to jail. The reason why she's asked for no violent contact is because they've tried parenting through or picking up the child through a third party, and it has not worked well at all. So she would much rather prefer to co-parent with him.
Okay. Got it. So she, Ms. Wallace, is comfortable with a resolution such as this, and in particular said, don't say no contact because it's just tricky getting the child back and forth.
Yes, Your Honor.
Okay, appreciate that. Ms. Hardy, you're never going to come back to this courtroom again because it's after 4. We only have one more plea after this. Do you have any criminal history information for Mr. Price?
Mr. Price does not have any history to report.
Thank you. Ms. Wood, I assume Mr. Price doesn't want to burn a first offender on a misdemeanor.
No, Your Honor, and I did advise him that I would not recommend that. He is 27. He does have a child, as you saw. He
Is that the child he has with Ms. Wallace, or is that a different kid?
Yes, Judge, that's the same child.
Okay.
He's been in the Army National Guard since 2015. We were trying to find some resolution that worked other than a misdemeanor plea, but it's my understanding he talked to his superiors there. This will not affect his involvement, his service with the Army. Judge, I apologize. I may have missed Mr. Jordan's when he was relaying the special conditions. At one point, Ms. Willingham was asking that a special condition be no weapons. And I would be asking if the court would consider not making that a condition since he is in the Army National Guard and will have to be around weapons from time to time. And then at one point, there was also a special condition of no alcohol. I don't believe alcohol was involved in this incident, so I would ask that that not be a special condition. And finally, my last request is Mr. Price wanted me to ask the court that after 12 months of compliance, if the court would consider suspending the probation.
Okay. Got it. Mr. Price, what is your primary job?
Right now I work as a supervisor for the shuttle drivers at the Home 2 Hotel by Hilton.
Say that you're a supervisor of shuttle drivers at what?
At the Home 2 Hotel by Hilton.
Oh, where's that?
Virginia Avenue, 334 Bobby Brown Parkway.
Okay, so this would be shuttles to the airport and back.
Yes, sir.
Got it. Okay, you supervise them. And then you're also in the National Guard. How many days a week, a month, a year are you doing that?
It ranges from anywhere from 2 to maybe about 6 days a month. And it's once a month. And it's 2 to 3 weeks every summer.
Okay. When you're doing that, I appreciate that you're around weapons, probably big ones. But those you don't take home with you when you're done with your weekend or your 2 weeks, do you?
No, sir.
Okay, got it. Anything you want to add to what we were just talking about?
I did want to say this. I don't believe I ever said I had a gun in my hand, and that would be my only thing.
Okay. Ms. Wallace is still present in your life because you interact with her when you're picking up your son or returning your son to her. Is that correct?
Yes, sir.
Okay, but she doesn't live with you. You guys aren't still an item.
No, sir.
Okay, got it. All right. Well, Mr. Price, I find there is a factual basis that there was some disorderly conduct going on in January of 2020. That's a long time ago, and that's going to factor into what I do here. I also find that your plea is knowing and voluntary, meaning you've understood what we talked about. No one's forcing you to do this. I am going to sentence you on count 1, which has been reduced to disorderly conduct, to 9 months probation, and count 2 to 9 months probation. That's also disorderly. I'll run those consecutive to each other, but 9 plus 9 is 18. So it's 18 months probation. And if after those first 9 months of probation, there have been no issues, you've shown up for what you need to show up for, you've completed the family violence intervention program, you've completed your community service, then misdemeanor probation can be terminated early. So it's 9 plus 9 rather than 12 plus 12. Do that for a couple of reasons. One is the age of this case. It's not your fault. It's old. But two, since then, there have been no issues that have been reported to anyone between you and Ms. Wallace or you and anyone. You've got no criminal history. And then finally, because of your valuable service to our country and our state through the National Guard, I would like for this sentence to get out of the way sooner rather than later so it doesn't complicate any continued service you may have. Now, that being said, if in a month I get a report that you gave Ms. Wallace a black eye, I will not hesitate to revoke 12 months. So just be mindful that you're getting more lenient treatment because it sure seems like you deserve more lenient treatment, but you could quickly prove me wrong by messing up while you're on probation. That doesn't seem to be your life history. You don't seem to have gotten in trouble before, and I understand that co-parenting can be difficult. So special conditions of your probation. Number 1, no violent contact with Ms. Wallace. Number 2, complete a family violence intervention program. That's not one class, it's a series of classes. Number 3, I'm going to have you do 80 hours of community service. And then finally, no firearms in your household. When you're doing National Guard and they give you an M16 or a tank or whatever it is, that's okay. That's when you're serving our country. When you are in your house or rolling in your car, if you have a gun, that'll be a violation of your probation. And I will not put an alcohol restriction on you. It doesn't sound like that's something that you're struggling with. Mr. Jordan, anything else in Mr. Price's case?
Nothing further from the state, Your Honor.
Ms. Wood?
No, Your Honor, thank you.
Mr. Price, you will get a call or an email either from Ms. Wood or from misdemeanor probation about how to connect with misdemeanor probation. They're going to give you instructions either to call or email or show up somewhere, and you need to do that. If you don't connect with them, all they do is send me a warrant saying, where's this Price guy? And you don't need that and you don't want that. So make sure you follow up with them once you get that information.
I understand.
All right. Any questions about any of that?
No, sir.
All right. Good luck with you and your cute little boy.
Thank you. I really appreciate it.
All right. Take care.
Bye, Mr. Price.
All right. Thank you, Ms. Wood.
You're welcome.
Good old Ms. Wood. All right. Let's please get Mr. Hughes out here. So we've got a plea to 2 cases. The third case is also accused. It's being null pros, or it's a plea to 3 cases.
Plea to 3, right?
It's a plea to 3 cases, Your Honor, and I can give you a breakdown either when Mr. Hughes comes.
When he gets out here, I'm going to get organized.
Look, this is a record. 13 pleas have taken today.
So it's a lot of work you guys done. You guys have done today, and we got our monthly, we don't call them rankings, but all the judges view it as rankings. It's got civil case count and criminal case count. And let's just say the McBurney division, they're doing all right. No pressure, Ms. Clark coming in, replacing Mr. Peoples. You better not mess up with that trend.
How are you?
How about yourself?
I'm good. I'm just worried. I'm just feeling.
Oh, yes.
Okay. Okay, good.
Okay, final cases, 1 defendant, 3 cases of the day. Position 17 on our trial calendar, 23 SC 187106 is our case on the calendar. All 3 cases belong to Mr. Hughes. Hello, Mr. Hughes.
How's it going, Your Honor?
It's going all right. How's it going for you?
A lot better.
Good to hear. You're wearing orange. Are you being housed in Cobb?
Yes, sir. I am.
Okay, got it. I need to know what the other two case numbers are so we get them on the record.
Yes, Your Honor. So there's 23 SC 188 978. I believe that's the one I was accused this morning.
And those charges are?
And those charges are, Your Honor, for that particular case, it was, I believe, one count of burglary and one count of theft by taking.
All right.
But in that case, Your Honor, we are going, count one, the burglary will be dismissed, and the second count will be reduced to criminal trespass, OCGA 16-7-21.
I won't ask why you accused it, only to dismiss and reduce it, but here we are. And what's the other case?
The other case, Your Honor, is 23 SC 189495.
That's probably the one from today, since it's a higher number. And what are those charges?
Those charges, Your Honor, is a one count of possession of Schedule II controlled substance, and I believe 2 counts of financial transaction card theft.
Okay, and those you aren't reducing. This other one was indicted and went to Judge Cox and got transferred to us.
Correct,
So
Your Honor.
I understand why you're tweaking that.
Yes.
But the case ending in 495, it's a plea to those counts.
Yes, Your Honor.
All right, and in the case of record, the one ending in 106, any dismissals or reductions, or what are we doing?
No reductions, Your Honor, but the plea will be from counts 1, 2, and 6 and 7. So the state will be moving to dismiss counts 3 through 5.
I count 8 counts, but I don't have the indictment in front of me. I have the calendar. Let me call it up. And let's see.
I also have 8 counts, Your Honor. My apologies. So the state would move to dismiss counts 3, 4, and 5, and also count 8.
So it's 2 ag assaults, family violence, battery, and hindering a person. Those are the pleas.
Yes, Your Honor.
Got it. Okay. Thank you for structuring that for us. Mr. Hughes, Ms. Wood, who is a law partner, if you will, with Ms. Feely, who's been working with you normally,
Yes, sir.
bless her birthday today, and we let her go a little early. So happy birthday, Ms. Feely.
I wish I would have knew that.
She was here almost all day. I know she spent some time with you. I finally said, go be with your family.
It's great for that.
She's good people. But your lawyers have told me that you're prepared to enter a plea in all 3 of your cases.
Yes, sir.
Some things are being reduced and dismissed and all that, but in the end, there's going to be this global resolution. Is that your understanding?
Yes, sir.
Great. Mr. Jordan is going to handle the plea for the state. So he's going to swear you in and then ask you a bunch of questions. You need to let me or Ms. Wood know if at any time you have any questions, okay?
Yes, sir.
All right, let's go.
All right, Mr. Hughes, can you please raise your right hand?
Don't understand.
You're good to sit. Is that okay, Your Honor?
It's fine with me, as long as Ms. Rivers, our court reporter, can hear you, and with that microphone right there, she'll be able to hear you.
And you don't have to feel the need to lean over if you wanted to look at the screen or just listen. That's absolutely fine.
Okay.
Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
Reginald Matthew Hughes, Jr.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir, I'm not.
Is there a medication that you normally take that you have not been given today?
No, sir, it's not.
How old are you and what is your highest level of education that you've completed?
32 and I'm currently in college.
Okay. Are you able to read, write, and understand the English language?
I am.
Do you understand that you have been charged with the following offenses? And we will start with the indictment ending in 106. That being 2 counts of aggravated assault, family violence, 1 count of battery, family violence, and 1 count of hindering a 911 call.
Yes, sir.
Do you understand that in the indictment ending in 495, that you have been charged with 1 count of possession of controlled substance and 2 counts of financial transaction card theft.
Yes, sir.
And do you understand that in 23 SC 188978, you have been charged with 1 count of criminal trespass?
Yes, sir, I do.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you would receive a jury trial?
Oh, yes, sir, I do.
Have you had enough time to speak with your attorney, Ms. Lacey Wood, about all of the facts and circumstances known to you regarding the charges in these indictments and accusation, including any potential defenses?
Yes, sir, I have.
Do you need any more time to discuss the case with your attorney?
No, sir, I do not.
Are you satisfied with her services?
Yes, sir, I am.
Ms. Wood, are you satisfied that your client has a full understanding of this proceeding?
I am.
Do you also waive formal reading of the indictment and also waive any and all defects in the indictment?
We do.
Mr. Hughes, do you recall having been arrested on these charges in these 3 separate cases?
Yes, sir, I do.
Your Honor, the state is unaware of any outstanding warrants that are related to these charges. Ms. Wood, do you know of any outstanding warrants that are related to these charges?
We do not.
Mr. Hughes, do you understand that you are entering a guilty plea to the following offenses? In the indictment ending in 106, you are entering a guilty plea to 2 counts of aggravated assault, family violence, 1 count of battery, family violence, and 1 count of hindering a 911 call.
Yes, sir, I do.
Do you understand that in the indictment ending in 495 that you are entering a guilty plea to possession of controlled substance and 2 counts of financial transaction card theft?
Yes, sir, I do.
And finally, in the indictment ending in 978 that you are entering a guilty plea to 1 count of criminal trespass?
Yes, sir.
Has your attorney advised to you the minimum and maximum sentence for each charge that you are pleading to?
Yes, sir, she has.
And Your Honor, just for the record, for aggravated assault, family violence, the minimum is 3 years in custody and the maximum is 20 years. I'm sorry, Your Honor, it's a 3-year sentence and a maximum 20-year sentence. For battery, family violence, the minimum is 1 day in custody and the maximum is 12 months. That would be the same for count 7, hindering a 911 call. For possession of controlled substance, the minimum is 1 year and the maximum is 3 years. It would also be the same for financial transaction card theft, a minimum of 1 year and a maximum of 3 years. And finally, for criminal trespass, the minimum is also 1 day and a maximum of 12 months. Mr. Hughes, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, this is a global resolution. The total recommendation, Your Honor, is 12 years probation. The special conditions of probation being that Mr. Hughes stay away from the victim in the indictment ending in 106.
That's Ms. Kraft?
Yes, Your Honor. And that he attend and complete an approved anger management course, and that he also forfeit the weapon that was used in this particular crime, I believe, Your Honor.
But it was a phone receiver was the allegation.
I believe so, Your Honor. I'll remove that from the recommendation. That may have been a typo by Mr. Peoples. Your Honor, I can give a breakdown on the particular charges that the state came up with in regards to a global plea, or I can just leave it as a total sentence if you prefer.
You can leave it as a total sentence. I mean, it would have to be built out of the case ending in 106.
Correct.
Because we've got a misdemeanor in one and then in the other charges that max out at 3 years. But I can get to 12 years probation if I think that's where I ought to get.
Yes, Your Honor. And I believe that Mr. Hughes, over the span of these cases, it's been about somewhere in the area of 230 days in custody total.
Yeah, I've got 222, but I just looked at one of the cases. It may be that there's something additive in there.
Yes, Your Honor.
Okay.
Mr. Hughes, do you understand that the court does not have to accept that recommendation?
Yes, sir, I do.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes, sir, I do.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir, I do.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes, sir, I do.
Are you currently on probation or parole?
No, sir, I'm not.
Are you a United States citizen?
Yes, sir, I am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, sir, I do.
Do you understand that your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, and finally, your ability to obtain employment?
Yes, sir, I do.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm during the commission of a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Oh, yes, sir, I do.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today?
Yes, sir, I do.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir, I do.
Do you understand that by pleading guilty, you are giving up the following rights, which I will now list off? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir, I do.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, sir, they haven't.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir, I did.
How do you plead to the charges of aggravated assault, family violence, that being 2 counts, 1 count of battery family violence, and 1 count of hindering a 911 call, and indictment number 23 SC 187106?
I plead guilty.
How do you plead to 1 count of possession of controlled substance and 2 counts of financial transaction card theft in 23 SC 189495?
Guilty.
And how do you plead to 1 count of criminal trespass and 23 SC 188978?
I plead guilty.
Thank you. Are these, is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, sir, it is.
Do you understand that you have only 30 days in which to appeal your conviction based on your plea today?
Yes, sir, I do.
Do you understand that for the felony charges, you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir, I do.
And for the misdemeanors that you're pleading to, you have only 12 months from today to file that same petition.
Yes, sir, I do.
And Your Honor, for a factual basis, if we can begin with the most serious case, which is the indictment ending in 106.
Yep.
Give me 1 second, Your Honor. I do apologize. On May 29th of 2020, while patrolling in an area around the 4979 Old National Highway, which I believe is a Travel Lodge hotel, an officer was waved down by a bystander whom was at the hotel and advised them of suspicious activity. The anonymous bystander did not wish to write a statement or give their name, but did advise officers that the victim, Ms. Craft, was being beat on by several men. Officers then spoke to the victim, Ms. Craft. Ms. Craft stated that the defendant had returned to the motel room drunk and began cursing her out. Ms. Craft states that she pushed the defendant from out of her face and he threw her onto the couch, whereby he began punching her in the head and face. Ms. Craft states that the defendant took the telephone receiver and hit her several times in the back of the head with it. She then stated that the defendant also strangled her by placing both hands around her neck. She states that she tried to call 911, but an unidentified male also in the room grabbed her and placed her in a headlock while the defendant unhooked the phone so she could not use it. Ms. Craft states that she asked the defendant to leave the room and he said he would kill her if she tried to leave. Ms. Craft states that at some point when the defendant opened the door, she was able to push past him and run to the gas station across the street. Your Honor, there's no evidence that other than living together, I believe that Ms. Craft may have dated Mr. Hughes at one point, but I know that this was not a domestic violence case because there has to be some evidence that they either share children or were married at some point. Your Honor, for the case.
So then it wouldn't be family violence, aggravated assault?
I think it would be family violence just because of the fact that I think that there was evidence that they were at least staying together in the hotel room.
Okay, well, I'll hear from Ms. Wood on that. If this was I met you last night, I don't know that quite makes it family violence, but we'll hear. It's not going to change the outcome. Just curious.
Understood, Your Honor. And Your Honor, for 978, the indictment ending in 978, we actually had discussed stipulating to the facts there.
Okay.
Just because Ms. Feely did give some late information that Mr. Hughes stated that the computers that were allegedly taken in this case actually belonged to the defendant. Reading the facts of the case, that may have very well been the truth. So I do believe that that is it was fine to reduce that case to a criminal trespass offense.
All right, so there's a stipulation to the factual basis of a criminal trespass.
Yes, Your Honor.
All right, and then finally in 495.
In 495 on February 10th of 2023, an officer responded to 6400 Powers Ferry Road for a report of a male who was trespassing. Upon arrival, contact was made with the building owner, who advised that a male was located by the cleaning crew. He advised that the male was also located in the same building 1 week ago on the property and was arrested. He advised that the male had been appearing to set up a place to sleep on the 4th floor of the building. Officers did search that floor and they did locate the defendant, Mr. Hughes. Mr. Hughes was laying asleep on the floor with a blanket and headphones. The officer observed trash from fast food, chargers, shoes, and a bag of clothes. Mr. Hughes was found with a bag that was later revealed to be methamphetamine. There were also multiple credit cards that were found on his person that did not have his name on it. At that time, he was arrested for the offense of possession of controlled substance and 2 counts of financial transaction card theft. There was also some mail in there belonging to other people as well. Those charges were not presented to the grand jury. Your Honor, we do believe, especially in the indictment ending in 106, though those are very serious charges, I don't believe the state has ever been successful in locating that victim, even since indictment of that case. So we do believe that this is a fair negotiated resolution, Your Honor, and we would ask that Your Honor accept the negotiated plea.
Got it. Okay, thank you. Ms. Hardy, if you could please share whatever criminal history information you have for Mr. Hughes, and then you may sign off. You earned your paycheck today.
Thank you, Your Honor. Mr. Hughes is a multi-state offender with arrests out of Georgia, Florida, and Indiana. Felony conviction in 2010 for theft by taking, 2019 theft by receiving and possession of methamphetamine, 2017 forgery, 8 probation violations and 2 FTAs. Nothing further to report.
Thank you, ma'am. What's the Indiana connection, Mr. Hughes?
forgery charge.
Oh, I didn't mean so much what you got in trouble. Do you have family in Indiana, or did you just drive to Indiana to do forgery?
I never was convicted of it, but I was with some guys and we got in trouble up there. But no, I'm born and raised in Atlanta.
Okay, you just happen to be in Indiana.
Happen to be in Indiana.
Okay. Ms. Tucson, is Mr. Hughes on probation now? That 2019 is not such an old case.
No, Judge, he's not on active probation.
Okay, well, that's about to change. Thank you. Ms. Wood.
Thank you, Judge. Mr. Hughes is 32 years old. He attended high school at Banneker High School. He does have an 11th grade education. It appears he has a GED as well. He works in the entertainment industry. He's a video producer and also does some engineering work. He has 2 children, 2 little girls, 8 and 6. Judge, he's been in custody since February 11th of this year, so 222 days. We would ask that you accept the state's recommendation in this case.
Mr. Hughes, tell me what your connection was to Ms. Kraft at the time. Had you guys been dating?
She was my girlfriend for a minute. She got mad because I had another chick. It was a sticky situation, but no, I didn't. None of that occurred.
But the way you knew her, it was romantic. You two had a relationship for a while. When you said she was your girlfriend for a minute, does that mean 6 months, 6 years, 6 days?
Maybe like 6 months.
Okay. All right.
A little less.
And when this situation happened, you guys had a hotel room at the Travel Lodge?
I had a hotel room and she popped up.
Got it. Oh, did you have a hotel room with another young lady?
Well, I had a hotel room and she popped up and there was another lady in the room. So
yeah, I bet she was kind of sour about that.
Right.
Yeah. Okay.
And
how'd she find you?
I stayed at the hotel. I used to live at the hotel.
Okay, so she knew she might bump into you there. All right. They found meth with you in February of this year, and I haven't heard anyone say anything about drug treatment or anything like that. Is that something that would help you? Is that why you're sleeping in, was it an apartment building or was it like an office building on Powers Ferry? It sounds more like an office building.
I was actually occupying the space because the cleaning crew told me I can use the office space. So I was actually occupying the space for business. I just so happened to sleep there that night. And that's when the guy found me.
Okay. Well, I don't know. The cleaning crew can truly give you authority to use space in an office building.
I didn't know there was a cleaning crew.
But either way, I'm not fussing at you about that. You understand my question. They found meth on you or in your stuff. And I'm not asking to say, oh, let's get them in more trouble. The reverse. As I look at some of the stuff, you got a little hustle, it's this stolen stuff, forgery, this and that. Well, sometimes that's not just a hustle. It is, I can't hold a job because I've got an addiction. And so I do stuff like this. What's your deal?
Actually, I was the top student in my college. I go to AIU. I was the top student in my college. They paid me to go to school, so I actually had money, so it wasn't an issue. But yes, I do from time to time use drugs to keep me awake. Because I have a lot going on. I work with the, like she said, in the entertainment field. So we work like through the night, and some days I don't need to sleep. I figured.
Okay. That's helpful for me to know. Do you have any questions about anything we've discussed?
Oh, no, sir, I don't.
All right. Well, I find there's a factual basis for each of your 3 pleas in each of the cases. The fight at the Travel Lodge, in the love triangle, the criminal trespass, someone's computers, and finally you sleeping in the office building with stolen credit cards and meth. I also find that your pleas are knowing and voluntary. Knowing means you've understood it all. You were the best kid in your high school and you're doing well in college, so I bet you understand this stuff. Voluntary just means no one's forcing you to do this. Do you agree with that?
Yes, sir.
Your probation sentence will be subject to the Probation Options Management Act, which simply means that while you're on probation, if you have a small violation, and I hope you have none, you in probation will solve that. But if it's a bigger one, you get arrested again, or all of a sudden you're up in Ms. Kraft's business and she doesn't want you there. Those kinds of things will get you coming back to me and we'll work through the consequences. Ms. Wood, may Ms. Nelson sign the 3 indictments or accusations, whatever format they're in, for you?
Yes, Judge.
And for you, Mr. Jordan?
Yes, sir.
Mr. Hughes, is it all right if we put your electronic signature on those 3 cases indicating your guilty plea?
Yes, sir, that's fine.
Thank you. All right, I am going to sentence you in 20, I guess we'll go in numerical order, 23 SC 187106. Your sentence for counts 1 and 2 will be 10 years to serve 7 months, with the balance on probation. 3, 4, and 5 are dismissed. 6 and 7 are misdemeanors, and your sentence there will be 7 months to serve. Those will run concurrently with count 1, and count 2 runs concurrently with count 1. So the overall sentence there is 10 years to serve 7 months with the balance on probation. You'll get credit for the time you've been in, which conveniently for you is a little more than 7 months. Special condition number 1, no contact with Ms. Kraft. Don't try to rekindle that old relationship. And if you just happen to bump into her virtually, don't drop her something on Instagram, anything like that. She has gone her way, and you're going a different way. Number 2, special condition is you're going to take an anger management course. Number 3, you're going to submit to a drug and alcohol abuse evaluation. So that's just talking with an expert who's going to hear you out on, no, I just use so I can stay up longer. And maybe that's the case. But if it's something more profound than that, and any treatment is recommended, that treatment will become part of your probation. And finally, I'm going to require you to do 80 hours of community service. In 23 SC 188978, that's this stipulated fact, someone's computers. Let me have the indictment in front of me here. One 188978. Count 1 is dismissed, and count 2 is, or is it the other way around? The burglary is reduced and the theft is, that would make more sense because criminal trespass. Okay. So count 1 is being reduced to criminal trespass, which is a misdemeanor. Your sentence is 7 months to serve, and count 2 is being dismissed. That sentence will run concurrently with your sentence in the Ms. Kraft case. And finally, in 23 SC 189495, that's you sleeping in the office building with someone else's credit cards and some meth. Your sentence on each of those 3 counts will be 3 years to serve 7 months with the balance probated. Those counts run concurrently with each other, and that case runs concurrently with the Ms. Kraft case. And you need to stay away from that address, which is 6400 Powers Ferry Road. So you know that office building, unless you still have you're pretending you have an office there because the cleaning people say you do?
No, I still have stuff in that building that I need to get out, like clothing and equipment.
You think it's really still there after all this time?
I'm not sure. I can call the cops and have them escort me.
I would do that. I would reach out to law enforcement. If they're like, I don't know what you're talking about, reach out to Ms. Wood. She's not going to do it for you, but she could at least show that you're supposed to stay away, but maybe you have some property there and maybe you could get it. I don't want to be the deliverer of bad news. I'd be surprised if it's still there, but you certainly free to go check for it.
Yes, sir.
But after you get your stuff, you stay away from there for the remaining 2 years and 5 months. Did I miss anything, Mr. Jordan?
No, Your Honor.
Ms. Wood?
No, Your Honor.
Okay. The last thing we need to do is that Ms. Tucson, who's on the call here, she's with probation, she needs to get a little contact information from you so that she can make sure you start your probation soon after you get out, because you should get out in the next couple days.
Okay.
Okay.
Yes,
Ms. Tucson?
Good afternoon, Mr. Hughes, Ms. Wood. She did send me some information. I appreciate that, Ms. Wood. You'll be in Decatur, correct?
Yes, ma'am, I will.
And is Miss Tamika Busby who I can contact to give her the reporting instructions?
Yes, ma'am.
Okay, because that office is in Conyers. I will call her to send these to her. What was your question?
I was gonna say, I can still report to Fulton County. You can keep it in Fulton County.
You won't have to report to Fulton. You're not gonna be living in Fulton.
Okay.
You could ask later to have it transferred there if you want, but the default is that probation goes to where you are. Not meaning they'll come to your house, but if you're living in DeKalb, that's where you need to report. If you're living in Pike County, you report in Pike County.
Okay.
So I know Conyers isn't real convenient. I'm not quite sure why that's where they opened up shop rather than Decatur, where most people live.
Yeah, for DeKalb, they closed the one in DeKalb and they consolidated it to the one in Rockdale.
It's too convenient for people. So you will need to report to that office in Conyers. You also could end up moving, and moving is okay. You just need to let probation know my new spot is in X, and whatever county that is, then they'll move your supervision to that county. Okay.
Yes.
Just don't move and not tell anyone, because then you will have absconded. They'll send me a warrant. I'll sign it. And here we go again. And a few more months in jail. And that's not what anyone wants.
No, sir.
Okay. Ms. Toussaint, do you need anything else from Mr. Hughes or anything else you need to tell him?
No, I put on here, I will call Auntie, give her the information. Reporting date will be October 4th. And then I just wanted to confirm the other indictment numbers, because on here it says pending with the CP. So it's 23 SC 188798 and 23 SC 189495.
So one correction, it's 978, not 798.
Oh, got those backwards. Okay, 188978.
Yes, ma'am.
Okay, thank you. That was all.
Thank you. Thank you for a long day. Thank you, Ms. Rivers. Ms. Nelson, I know you're still working on final dispositions. I'm going to end the Zoom call. I appreciate everyone's time. This was a super productive day.
Hey, Judge, have a good night.